therefore the appearances are the same. The record should reflect the jury is not in the courtroom. With that, which attorney wishes to put something on the record?
That would be me, Your Honor. I will indicate that defense counsel Jeremy Perry and I have been discussing the interview transcript, and the state has told defense counsel which portions of the interview we intend to play, and we've got the transcripts of those intervals also. Now, it's my understanding that defense counsel Jeremy Perry intends to cross-examine Paul Ratzberg about things that were not within those transcript clips. In other words, he wants to cross-examine Detective and Lieutenant Ratzberg about statements that Lieutenant Ratzberg made elsewhere in the interview. And the state's objection is that it's hearsay. And the defense argument is that it becomes relevant because their position is that Aaron Dillard had an opportunity to read this entire transcript. And so therefore, Aaron Dillard's statement about what Mark Jensen allegedly told him was informed not by what Mark Jensen told him, but by what Aaron Dillard read in the transcript of the interview. So it's sort of a conditional relevance. The condition precedent is that they need to establish or show that Aaron Dillard read this interview transcript. So I don't have a problem with them being able to cross-examine Detective Ratzberg eventually about the statements that are contained in the interview transcript, assuming they meet that condition precedent. But however, I don't think they can meet that condition precedent. I don't think they will be able to meet that condition precedent. So I don't think they should be allowed to cross-examine Detective Ratzberg about his statements in the interview until they've established that conditional precedent to wit that Aaron Dillard had read or had an opportunity to read this transcript.
What exactly does the defense want to cross this lieutenant about that is objectionable by the state?
It's nothing. I'll be very specific. It's nothing new. This all came in 2008, and the last thing that Mr. Jamboys just said is that to show that Aaron Dillard had an opportunity to view this transcript, and we're going to establish in this trial that that there was a transcript. Obviously, there was a transcript of this interview prepared. It's going to come up in mere moments. That transcript was sent to Mark Jensen 4 days before Aaron Dillard got to the Kenosha jail. And what I'm going to be asking this declarant about are statements that he made in it. I'm not going to be asking for Mark Jensen's responses. And it's precisely the information that Aaron Dillard then parrots in terms of claiming that Mark Jensen told him. Now, the state in its opening statement said the only way Aaron Dillard could do that is if he heard it from the mouth of Mark Jensen. And we have to have an opportunity to show that there's another way for that statement to have come into Aaron Dillard's possession, and this is that direct way.
But you're not going to ask this witness that this is what Aaron Dillard said. Yeah.
I'm not going to ask him what Aaron Dillard said. I'm going to ask him a handful of statements that he made to Mark Jensen in the interrogation. I'm not going to ask for Mark Jensen's responses. That's it.
I think he can ask what he said.
Here's the problem, Your Honor. First of all, I certainly agree that he can cross-examine Paul Ratzberg, and cross-examination in the state of Wisconsin is wide open. He's not restricted to what I ask about on direct. However, in order for him to cross-examine, he's got to cross-examine him on a relevant proposition. It's got to be something that's relevant. The fact that Detective Ratzberg, for example, at some point was talking about asphyxiation, which I think he was in the course of this interview, that's not relevant unless they can show this relevant. And their argument for relevance is that Aaron Dillard saw that or read that, but they can't show that Aaron Dillard read that or saw that. And it is true this came out in the last trial, but I've had an opportunity to read the entire transcript of the last trial, And there was simply no evidence that Aaron Dillard ever saw this interview transcript. None. So in order for it to become relevant, they'd have to ask the jury to speculate that Aaron Dillard read this portion or read this interview transcript. There's simply no evidence in the record of the last trial that Aaron Dillard ever saw this. And Aaron Dillard will categorically deny that he saw this. Now, I acknowledge Aaron Dillard. They're going to challenge his credibility, and rightfully so. There's a lot of questions about his credibility, but he's denied that he ever saw it, and they don't have any evidence that he ever did. Now, if they want to put Mark Jensen on the stand, Mark Jensen can testify that, yeah, I showed this to Aaron Dillard. Then they'd have some evidence that Aaron Dillard read this. But right now, and at the last trial, they never presented evidence that Aaron Dillard ever read this transcript. That's so my objection is that the cross-examination on what the detective said elsewhere in the interview is not relevant.
Well, one thing I want to be clear, the defendant does not have to testify. We're not going to get into that. He has an absolute right not to testify.
Oh, I agree. And I certainly didn't. That's why I certainly wanted to say this in front of the jury. I'm just saying that the only evidence that they could present that would show that Aaron Dillard actually read this transcript is if it was Mark Jensen, because there were only two people in the cell at the time when Aaron Dillard was reading the stuff. Aaron Dillard will testify as to what he was reading, and he'll testify he was reading the transcript of Ed Klug's testimony from the forfeiture hearing.
Well, let me ask this question. You said, I thought you were going to play the whole interview.
No, that would be over 4 hours.
All right. So you're going to play 45 minutes of it.
Yes,
right?
we're just going to play. There's a variety of sections of it that we're going to play.
So I'll go back to the defense. Exactly what are you going to ask this lieutenant? Is it about statements he made outside of the interview?
No, outside of the 45 minutes that are going to be played, but part of the interview. I mean, I'll just tell you, it's 1, 2, 3, 4. It's 5 statements that he made.
Give me the 5 statements as an offer of proof.
Okay.
By the way, Your Honor, for the record, the state will stipulate that he made those statements. We've got them on video. And
I think they still have the right, even if you stipulate, they still have the right to ask the question.
They don't have the right to ask the question unless it's relevant, and they've got to show its relevance.
I'd say this: the state made this relevant in their opening statement by saying that Aaron Dillard, there's no other place he could have gotten this information, and we will show, and we'll have to show, otherwise we won't have an argument, a closing argument on this. We'll have to show that Aaron Dillard had an opportunity to get this information from someone other than Mark Jensen.
I'm gonna let it in, just to be safe. I've been tough on the defense for relevance, and I think the last time I said it goes to the weight, and if it's 5 questions, what this witness said in the interview, I think it's an appropriate area to get into. So let's bring the jury back, and we will continue.
Pizza.
You're familiar with the phases of ethylene glycol poisoning?
No, I'm not.
Not at all?
Not at all.
Were you at one time?
No, I'm not. I wasn't at one time.
Wouldn't be able to testify at all about.
No, I would not.
Okay, so
Not about ethylene glycol. I'm not an expert or even very comfortable going through the different pharmacokinetics of ethylene glycol.
So if you testified in 2008 about the phases of ethylene glycol, do you wish you hadn't?
I wish I hadn't.
Oh, I told you guys he was key during the 2008 trial. This is big. This is major, guys. All right, good morning, chat. Welcome back to Wisconsin versus Mark Jensen, day 8. Now, we left off on Friday with the direct examination of Aaron Dillard, the jailhouse snitch. Today, chat, today, Jensen's defense is going to work their cross. This is key. We just showed a clip of them getting the pathologist, Dr. Chambliss, to admit that he falsely testified in the 2008 trial when it came to antifreeze. And Dr. Chambliss was a key witness in the conviction of Mark Jensen in 2008. Today, chat, is so important. They have to crush Aaron Dillard. They have to put doubt in the jury's mind that Aaron Dillard not only read transcript from the 2007 bond forfeiture hearing of Ed Klug's testimony, but that it is plausible that he also read Detective Ratsberg's transcript of the 1999 interrogation of Mark Jensen. Which means, chat, and we've all suspected it, that Aaron Dillard had too much detail, and that's where he concocted this story that he sells to the DA, old Bobby Boy Jamboy, that Mark Jensen confesses. If they can crush Aaron Dillard on the stand today, that makes every other jailhouse snitch not credible. Today is so important, chat. So important. Make sure you guys subscribe on YouTube. Subscribe on YouTube. Hit the bell for all notifications. Make sure you have your notifications turned on your phone and the back end of YouTube. On Facebook, if you're watching, please like and follow the page. And all throughout the trial, spam the chat with, that's Craig Albee. Spam the chat with hearts and likes. That helps push us out there, chat. It's so important. Let's grow our community. That is attorney Craig Albee from the 2008 trial. This is cool. He makes an appearance. Chat, I am so excited today. I am nervous. Today is a big deal. We have all been working the theories on whether or not Mark Jensen is really guilty, or if Julie Jensen staged.
All right, we're going to go back on the record. It is Monday, January 23rd, 2023. Mark D. Jensen, 2002 CF 314. Let's have the appearances again.
Good morning, Your Honor. State of Wisconsin appears by Special Prosecutor Robert Jamboys, Deputy District Attorney Carly McNeil, and Public Service Special Prosecutor Beverly Jamboys.
Attorneys Bridget Krause, Jeremy Perry, Mackenzie Renner appear on behalf of Mr. Mark Jensen, who appears in person. Good morning.
Good morning. All right, the jury's back in the courtroom. Thank you for coming back, folks. We're going to continue with the cross-examination. Now, I should say we're going to start the cross-examination of Aaron Dillard. Mr. Dillard, would you please stand? I'm going to swear you in again. Raise your right hand. You solemnly swear the testimony in this matter be the truth, whole truth, nothing but the truth, so help you God. The witness said, yes, he does. And with that, Mr. Perry, you can start your cross.
Thank you, Judge. How's that? Mr. Dillard, you agree you're a con man, don't you?
Yes.
Prior to coming here today, you review your prior testimony?
Yes, I have.
Did you review the letter to your lawyer?
Yes.
How about the transcript of your recorded statement with the prosecutors?
Yes.
How long have you been in the Kenosha jail waiting to testify?
Since last Tuesday. This
What?
past Tuesday.
So about a week ago?
Yes.
Have you been watching the broadcast of this trial?
No.
On direct exam on Friday, you testified that your prior convictions were for forgeries and frauds.
Correct.
You testified that you have a special skill set. Do you remember that?
I don't know if it was a special skill set, but it was just I was able to get people to talk or get things that I wanted.
You're able to tell people stories and they believe you.
Yeah.
And then you're able to get things from them.
Yes.
This is going back to the year 2000. You used a computer to create payroll checks made payable to you, and then you went to various Kenosha bars and cashed them out.
That's correct.
In order to do this, you bought check stock.
Is that a question?
Yeah.
Yes.
You created these from whole cloth,
What is whole cloth?
made it from scratch.
Yes.
And you did about 8 of these, right?
Correct.
$400 a piece, roughly.
Yes.
So you were able to cash these at various businesses and get about $3,200.
Yes.
Do you remember going to Las Vegas with your cousin Tom Kaiser and a woman named Shannon Panko?
Yes.
You met Shannon Panko on Yahoo Personals.
Yes.
You used an alias of yours.
Yes.
You were calling yourself Kyle Rezick.
Yes.
Do I have that right?
That's correct.
You said you couldn't fly because of your military classification.
That's not true.
When you checked into the hotel as Aaron Dillard, you explained to her that because of your military clearance, you couldn't give out your real name.
She knew my name. So no, that's incorrect.
You convinced Shannon Panko to lend you money.
No, that's incorrect.
You took her credit card out of her purse and charged the hotel room onto it.
No, that's incorrect.
Do you acknowledge borrowing money from Shannon Panko?
I acknowledge her paying for the room.
Did you ever pay her back for the room?
No.
You forged a check to the ABC Supply Company.
Correct.
That was another time where you created a whole new check for an entity that didn't exist.
Correct.
The check made it seem like it was coming from a place called Wisconsin Restoration Services.
Correct.
That was for $881.
Correct.
It was signed S. Lake and even listed a driver's license number.
Correct.
No account like that ever existed,
No.
right?
I just said no, it didn't.
Okay. You did not identify yourself as Aaron Dillard,
No.
and you went and bought a compressor from the ABC Supply Company with that completely forged check.
Yes.
You remember living in Arizona around 2003?
No.
You met electronic technicians that work on FBI radios and phone systems?
Not in Arizona.
Not in Arizona?
No.
Which state was that in?
Las Vegas. I wasn't living there at the time, but I was out there.
You met electronic technicians that work on FBI radios in Las Vegas?
Yes.
You told them that you were the heir to Dillard Clothing?
Never.
Told them that Home Depot was a subsidiary to Dillard Clothing and that you were an heir to that as well.
No.
You had in your possession a whole bunch of Home Depot gift cards that you sold at half price.
Yes.
Those cards were all stolen and worthless.
No. Incorrect.
You gave Mike's Foods multiple checks, getting over $1,000 for accounts that were closed years earlier.
Yeah. It's okay. Yes.
You agree that you're a woman victimizer?
Yes.
When you met a woman named Deborah Spears, you told her your name was Kyle Rezick.
Yes. In the beginning, I did.
I'm sorry?
Yes. In the beginning, I did.
Told her that you were very wealthy,
No.
that you had a yacht,
That's not correct.
an expensive condo.
No. She actually picked me up at my house.
You told her that your wife and son were killed in Lithuania.
No.
Told her that you had a lucrative telecommunications business in Lithuania.
I probably told her I had a business in Lithuania that made a little money. Yes.
Told her your assets were frozen and you needed to borrow money from her.
I don't recall how I told her I was going to borrow the money, but I did borrow money from her.
She filed bankruptcy as a result of your actions.
I don't believe that.
You intended to victimize Deborah Spears.
Yeah.
Yes?
Yes.
You stole her debit card numbers to pay for a cell phone bill.
Well, they were entered into my cell phone and it overwrote the numbers. And so it stayed in there and I used it a second time.
Okay. You had an unauthorized $500 withdrawal from her checking account.
That was that occurrence.
While you were in the jail, you called your wife, Nadia. You told her, just say it was her that did it.
Yes.
You had Nadia call Deborah Spears, told her to drop the charges, and if she didn't, you'd never pay her back.
Correct.
You've met at least 3 women on the internet that you've borrowed money from and never paid back.
Incorrect.
We've already talked about Shannon Pankow.
I didn't borrow any money from her.
You remember Wendy Reamer,
I do remember Wendy, but I didn't borrow any money from her.
Lori Brown?
I didn't borrow any money from her.
You lied on that Yahoo Personals profile.
Explain.
You indicated that your education was postgraduate.
I don't remember that.
You told Wendy Reamer that your name was Kyle Rezick.
I don't remember.
You told her that you played college football,
No.
had a rare bone disease,
No.
flew to Europe for treatment,
Never for treatment.
had a mansion in Kenosha,
Again, no. She actually picked me up at my house as well.
that you bought your parents a home next door to the mansion,
Again, no.
that you claimed to her to be a medical and surgical equipment seller.
I did have a medical supply company in Lithuania.
You're an American citizen, right?
That's correct.
The United States government actually extradited you to Lithuania to face punishment for crimes there.
That's backwards. Lithuania extradited me to Lithuania, just from America.
You were in America
Yes,
and you were shipped back to Lithuania.
that's correct.
You're the first American citizen to ever have that distinction, right?
Correct.
That was for committing fraud against Lithuanian citizens.
Who were trying to obtain illegal entry into America? Yes.
So that's a yes.
Yes.
Costas Kurlis, that's Kurlys. Do you remember him?
Yes.
He paid you $2,500 for his daughter to get a 10-year visa to the U.S.
Correct.
You made friends with them,
Correct.
met them in a cafe,
Correct.
approached them with what you said you were able to do.
Correct.
You were polite yet serious.
Yes.
You told them that your parents lived in Chicago and they were wealthy.
I said near Chicago.
Convinced them that you were reliable.
Yes.
Got them to give you $2,500.
Yes.
You never produced any visas.
Correct.
You never had any ability to produce any visas.
Correct.
Mr. Kurlis's son was a doctor.
Yes.
You stopped calling the Kurlises back,
Yes.
had someone else call them claiming to be your maid, and said that you were badly injured at a hospital in Finland.
No.
You called them about a week later and promised them that you'd produce the visa or the money.
Yes.
You never did.
No.
Now that scenario that we just talked about with Mr. Kurlis's family, you did that on 7 different occasions to 7 different families in Lithuania.
Yes.
People paid you anywhere from $2,500 to $5,000.
Yes.
In Lithuania, that was those families' life savings.
I don't know that, but it's a lot of money to them.
It's a lot of money in Lithuania, correct?
Yes.
You came up with a story that you could sell them and they bought it.
Yes.
On Friday, you testified that you got to the Kenosha County Jail on the evening of August 14th, 2007, correct? I'm sorry, I said correct at the same time you said.
Correct.
You had a whole host of problems on August 14th, 2007.
Correct.
You had been out on extended supervision, and the reason you were in the Kenosha jail is that you were coming back to court for a hearing to determine how long you had to go back to prison.
Correct.
You had been absconding from supervision when you got pulled over on May 31st, 2007.
Correct.
Absconding means that you were just in the wind, correct?
That I didn't report to my probation officer. Yes.
You weren't reporting as you were supposed to.
Correct.
You had been absconding from the previous fall, correct?
I'm not sure of the times.
On May 31st, 2007, you were pulled over in a vehicle.
Correct.
You had a suspended registration,
Correct.
and you told the officer that your name was Mike Kaiser.
Correct.
Mike Kaiser is a brother of yours.
Correct.
While you claimed to be Mike Kaiser to this police officer, you blamed the suspended registration on your brother, Aaron Dillard.
Correct.
The police officer figured it out during that traffic stop.
Correct.
You started crying and told him, I told them I didn't want to go back.
Incorrect.
What's incorrect about that?
I didn't cry there. I didn't cry there. I cried at the police department saying that I didn't want to go back.
No, you
I
didn't
was
cry.
talking-
You didn't cry at the scene. You cried at the police department.
Yeah. I didn't want to go back.
You were charged with obstructing an officer for that, and you were facing 9 months in jail.
Correct.
That was in Waukesha County, correct?
Correct.
The bigger problem that we've already talked about is that when you got pulled over, you had been absconding from probation.
Is that a question again?
Yes.
Okay. Yes.
You had 17 alleged violations while you were on probation.
Yes.
You had someone's Quest and Visa card on you when you got pulled over.
I had my mother-in-law's Quest and Visa card on me so I could do her shopping.
While you were absconding from supervision in 2007, you cheated a man named Dennis Ritt out of money.
Yes.
You claimed to him to have a Russian cell phone contract.
No, I had a telecommunications company.
You told him you had a telecommunications company
Yes.
in Russia.
In Lithuania.
You convinced him to lend you money
Yes, at a poker game.
at a poker game,
Yes.
and you never paid him back.
Correct.
You wrote a check from a closed bank account to Dennis Ritt.
That's correct.
You knew it wasn't good.
Correct.
You obtained, while you were absconding from probation, you obtained self-employed side jobs for Lori Brown and Cassandra Ivy without permission.
Correct.
You took cash from them and then kept the money for home improvement work from Lori Brown and Cassandra Ivy.
That's not true. I completed the job on Lori Brown's house, and Cassandra Ivy I borrowed money from after I did home improvement work for her.
You had met Lori Brown on the internet.
Yes.
You told her that your name was Aaron Galvin.
Yes.
Wrote that on the home improvement, whatever the contract you had signed with her.
Yes.
Lori Brown was a lawyer, wasn't she?
I know she worked at a law office, but she wasn't. I don't know if she was a lawyer.
Now, Cassandra Ivy paid you $6,200 to work on her home.
I did concrete and siding work at her house, and then I borrowed $6,200 from her afterwards.
Okay. You told her you were bonded and insured.
No.
She was never able to reach you by telephone, and you never began work in her kitchen and bathroom.
No, I never was supposed to begin work in her kitchen and bathroom.
You never returned the $6,200 you'd gotten from her.
That is correct.
Have you ever paid her back for that?
No.
For the Cassandra Ivy situation, you got charged with theft by contractor and home improvement fraud.
Yes.
You were facing 7 years on that case.
Yes.
For the reconfinement, you knew the probation agent was recommending that you get the maximum time available.
In the beginning, she was recommending 3 years, 4 months, 3 years, 11 months. But then I think it's changed to the full amount.
Changed to the full amount, right? You know that when you go back in front of a judge for a reconfinement, they read what the agent's recommendation was.
Yes.
They would take that into account.
I think they would take it into account.
They would take into account the justification for the maximum sentence, right?
You're asking me a question that I can't answer completely. I mean, I know they take it into consideration, but I don't know how they do it or how they use it, but I know they take it into consideration.
And at the time that you got to the Kenosha jail on August 14th, 2007, at that time, the agent was recommending that you be reconfined for 4.5 years.
I don't know at that point what she was recommending because I saw my parole agent before and she was recommending a 3 years something. And then they made a new recommendation that I didn't quite see yet.
The agent justified its recommendation by saying that you were in need of serious CGIP. Do you know what that means?
Yes, she did.
What is CGIP?
I don't know the terminology. Cognitive. I don't know. I know it's cognitive something.
So that your criminal behavior is well beyond the need of cognitive thinking.
That's what CGIP is, and she said I needed it.
Said his repetitive deviant thinking is just in plain need of confinement. Correct?
Yes.
Said that your goal in life was to be a successful criminal. You're motivated by the power you feel to manipulate others, sometimes for material gain.
That's what she said, yes.
So when you got to the Kenosha jail on August 14th, 2007, you were facing 9 months on the new obstructing charge, correct?
Yes.
7 years on the new theft by contractor and home improvement fraud case.
I think that's a bifurcated sentence, though, so it's only so much in and so much out. So I don't know what, I think on a 7 year, I think you're facing 3 years max, 3.5 years maximum.
You'd acknowledge that the maximum total incarceration that you were facing on that case was 7 years.
You're saying it wrong again, because incarceration is only 3.5 years, and then extended supervision, which you do on the street, is the outside time. So 3.5 years.
You had a recommendation from your agent that you go back to prison for 4.5 years on the reconfinement case, correct?
That now I know it's to be true, yes.
When you got there that evening, you immediately recognized Mark Jensen.
Yes.
You knew about him from newspaper articles.
Yes.
You had seen his picture.
That, I don't think so. I saw Edward Klug's picture. I didn't see the other ones.
You gave a recorded interview with the prosecution in this case, didn't you?
Yes,
I asked you about that right at the start of this. You said you had reviewed that prior to your testimony.
correct.
Counselor, I'm referring to page 8 of the recorded interview. The recorded interview, for the record, is marked as Defense Exhibit 71.
Has that been moved into evidence?
It has not. I guess starting at the bottom of page 7, we just started talking. And they said who he was, and I'm like, oh, you're a pretty popular guy lately because he was in the newspaper and I saw his picture.
Then I'm not aware of seeing his picture. I'm sorry. I saw articles about him in the newspaper, though, about the Klug transcripts. But I may have made a mistake there.
Your version today is that you had not seen his picture?
This is 17 years ago. I don't believe I did see his picture. I seen stuff of his in the newspaper, though, from the Klug transcripts or the Klug testimony.
You knew it was a high-profile case.
Yes.
And within 30 minutes, you were talking with him.
Yes.
You were there in the evening of the 14th.
Yes.
There all day on the 15th.
Correct.
All day on the 16th.
Correct.
You had court on the 16th.
Yes.
You were able to get that reconfinement hearing adjourned until October.
I don't know if I was able to get anything done. I think they did it on their own. I don't remember how that happened.
You left at 4 a.m. on the 17th.
Correct.
You said on the 14th he gave you the Klug transcript.
I believe so, yes.
You had then endless discussion with Mark Jensen about all details and aspects of his case.
I don't know about endless, but I know what he told me.
You talked all night on the 14th, the 15th, and 16th, right?
We talked quite a bit on those days, yes.
Isn't that what you said on Friday?
That we talked quite a bit, yes. I didn't say endless or all day, I mean, but it was a lot of the day.
You were intensely interested in every detail you could get.
No, we were talking. There was nothing intense about it until he started admitting what he did.
You sat at a back table with him.
No, there's no table. We sat on the floor.
He showed you his paperwork.
He showed me the Edward Klug test transcripts.
You read more than a single section of a single transcript.
What does that mean? I don't know if transcripts are broken up into anything. It's just his transcript.
You read more than the Klug transcript.
No,
You read the police reports in this case.
no,
You read the transcript he had just gotten of the interrogation with Detective Ratsberg.
no.
You testified that you didn't go into a cell because that's against the rules and you could get a conduct report.
I didn't test. I just said that's probably what could happen if you entered into somebody's cell, but that's not why I didn't enter a cell. But I did not enter a cell.
Do you consider yourself a rule follower?
Believe it or not, when I'm in jail, yes.
So do I understand your testimony that all evening on the 14th, all day on the 15th, Mark Jensen repeatedly said he had not killed his wife?
He said he did not kill his wife.
Then overnight, you took offense that Mark had discussed his kids when explaining Julie Jensen's mental health.
Yes, I did.
And that offended your sense of decency?
Well, I had lost my mom while I was in jail, so I feel like not being able to say goodbye to your mom or anything like that is pretty horrible. So I did take offense to him losing his kids, or
And-
you know.
And that's what caused you to decide to push for information so that you could tell your attorney and get a deal.
Well, it was first I was trying to see how far he would go, and then he went. So then I decided to use it to help myself.
So the way you did that was you said, well, you know, we all did something to get where we are, right?
Yes,
And he said, well, yeah, we all have situations.
yes,
You implied that he did it, and he
Yes.
said, yeah.
it's just like that.
And you said, Mark, how did you get the antifreeze? And then he just gave you a full confession.
Pretty much worked out like that. He told me about the Edward Klug thing and then went into the rest of it.
Within a week, you had written a letter, right?
Correct,
You wrote this after you got back to prison?
correct.
And you didn't send this to your lawyer directly, did you?
No, I did.
You sent it to your wife, who faxed it to your lawyer.
I'm not aware of that. I believe I sent it to my lawyer.
You discussed this with your wife.
No, I don't believe I discussed it with my wife.
She wouldn't have known to fax this to your lawyer?
Well, I believe I sent it to my lawyer through the post.
Is it your testimony today that you did not discuss this, the facts of Mark Jensen's case in this letter with your wife prior to sending this letter?
I don't remember that. This is 17 years ago. I don't remember, but I believe I sent it and put through the post to my wife or to my lawyer.
In the week after the 17th, when you went back to prison, to the time that you drafted this letter, is it your testimony today that you did not discuss this with your wife?
The sending of the letter or discuss what happened with Mark?
Either.
I believe I discussed it. I told her what happened with Mark. But as far as sending a letter, I believe it went through my lawyer.
Your letter that was marked as State's Exhibit 69 on Friday said, I would like to know if you can work a deal with the DA in my cases for the information I have in this case, exclamation point. Right?
I'm not looking at it, but okay, yes.
Do you need to see it?
No, but go ahead.
I would like to know if I can get my record cleaned up and get out of jail,
Yeah, at that point I was using it to try to get out of jail.
or at least be released and have my supervision reinstated, but up in Milwaukee at minimum, exclamation point.
Sure.
Also, I would refuse to testify if I were to be in jail, as I will have fears for my well-being, exclamation point.
Yes.
Your letter mentioned Mr. Jamboys by name.
Yes.
Did you know him by that point?
I knew he was the DA on his case through Mark.
You testified on Friday that you were Mark's protector in jail.
I didn't say it was his protector at all.
You just agreed with that suggestion
Yeah, I agreed that JJ didn't mess with him when I was there.
for the 2 days that you knew him.
Yes.
You met with the prosecution in October 2007. That's the recorded interview.
Okay.
From the time you had written that letter to the meeting in October, you had already made some adjustments to your story.
Objection. It's argumentative, assumes the existence of a fact, not an evidence. If there's inconsistencies, you should point to them.
Sustain.
Well, I'll point to them now.
Go ahead.
In the letter to your lawyer, you wrote that on the day after Julie Jensen had drank a few glasses of juice with antifreeze in it, that he gave her some more juice with antifreeze and she was throwing it up a little. Do you remember writing that?
Yes.
In October 2007, page 15, counselor, you said he gave her 1/3 antifreeze, 2/3 juice, and the next day gave her another glass of it. And that whole day, she was throwing up and really out of it. She would stay in bed a lot, wouldn't get out of bed, really just vomiting. Do you remember telling the prosecutor that?
Yes, but it came in bits and pieces and there were different times. So she was vomiting in a little bit in the morning and more in the evening. I don't know how, it's all time. They go back,
Okay.
times throughout the day.
In your letter, she was sleeping on her back for a bit, and he rolled her over a bit, and she didn't wake up. Then he rolled her on her face and left her for a bit. Do you remember writing that in your letter?
Yes.
In your interview, she was laying on her side,
Which page, counsel?
26. She was laying on her side, and she was, sleeping, and she was breathing good. And he said he just rolled over and then sat on her back and pushed on her face because he said he wanted her lungs to be closed.
Yes.
What's your version today?
It's the same version. She did make it to her side and then went to her stomach.
So he rolled her on her side and then left her for a bit
Yeah.
and then came back
Yes.
and then rolled her on her face?
Yeah, but she started out on her back. I mean, it was that morning when he took the kids to school and went and picked up the check. She was on her back and then he rolled her on her side and went and did something, then came back and rolled her onto her face.
In exchange for your story,
Objection. That's argumentative and assumes-
Sustain.
in exchange for what you told the prosecution, you got a time-served recommendation from the DA on the reconfinement case.
Correct.
The previous recommendation from the agent was 4.5 years,
From the agent, yes.
and that got turned into 0, correct?
Correct.
You got a recommendation of no time on the theft by contractor and home improvement fraud case,
Correct.
facing 7 years, and you got 0 time, correct?
Facing 3.5 and then got a probation.
You were told by the state at that interview if there was a way we could get the agent to get the department to change its recommendation to time served so that then there wouldn't even be a sentencing after revocation, correct?
I believe that's in there.
And you got a letter to the prosecutor in Waukesha that would say whether or not you testified truthfully in that case, correct?
Correct.
And you ultimately got a fine only in that case, correct?
I believe so.
No jail time.
Correct.
Testifying truthfully was determined by Mr. Jamboys in this case, correct?
Sure.
Whether or not he would write a letter on your behalf?
Yes.
Tom Kaiser is your cousin. We talked about him with the Las Vegas trip, right?
Yes.
You've acknowledged to him that you've lied in this case.
That is incorrect.
There was more discussed about the deal going forward in that jail interview in October. Do you remember other conditions of it?
That I don't violate any crimes.
You were told by the prosecutor, and you understand that part of the agreement is that in addition to telling the truth, the other thing that you're going to do is not commit any crimes. If I'm responsible for getting you out of prison, you said, yeah. And you commit any more crimes? You said, oh, I know. That Mr. Jamboys then told you, you go right to the top of my list. You understand that? And you said, oh, I know, and I understand that completely.
And
Mr.
I've served every day on those sentences. Every day that was supposed to be have that I didn't get, I got. So.
And Mr. Jamboys said, and you've probably heard about me in prison, right?
Yes.
And then he told you, and I'll come back just to take care of you if you victimize any more people because I got you out of prison, I will make it a point to come after you. Correct?
Yes.
And despite that, the victimizations continued after Mr. Jamboys got you out of prison.
Yes.
On May 10th, 2011, you broke into Carol Willick's home and stole jewelry from her bedroom.
Yes.
She was a single mom.
I don't know.
You took over $17,000 of jewelry from her home.
Yes.
Did Mr. Jamboys involve himself in that prosecution of you?
I don't believe so.
Now, as you sit here today, you have even more problems, don't you?
Yes.
You've got a pending burglary case.
Yes, it's pending.
That's right. It's just charged and it's ongoing, right?
Yes.
And you're facing 18 and a half years in that case.
Yes.
And it's alleged that once again, you broke into a home and stole several pieces of jewelry.
I haven't seen the discovery yet, so I don't know what it's alleged I've supposed to stole, so I can't answer that.
What was alleged is that they plotted your cell phone that was registered to Michael Kaiser, which is an alias of yours.
Okay.
You've got another case of fraud against financial institutions of over $10,000 and fraud against financial institutions $500 to $10,000. Correct?
Yes.
And in that case, between the two counts, you're facing 16 years in prison.
15.
And it's alleged in that case that in May of 2019, you opened a bank account with the Waukesha State Bank, and over the next 4 days deposited 3 checks from your girlfriend's account and 1 from a different account of yours, totaling over $15,000.
Is this the charges you just discussed?
Yes.
Yeah, then yes.
And then within days of that, you did 8 cash withdrawals from that new account.
Objection, Your Honor. This pertains to matters for which this defendant has not been convicted. He's still.
That's sustained. He has a right.
I'm not asking him to admit.
You're asking him very sensitive questions.
I am. I'm trying to outline what he's
I would
facing.
not go there.
You've got one other pending case.
Yes.
That's an obstructing an officer charge, right?
Yes.
And for that, you're facing 9 months in jail.
Correct.
Mike Kaiser, Kyle Rezick, Aaron Galvin, and Aaron Dillard. Those are all names that you've gone by, right?
Correct.
Have I missed any other aliases?
None that I can recall.
Now, there's another deal for you for your testimony today, isn't there?
I don't know if it's a deal or not. It's just their prosecution's going to write a letter saying I testified truthfully.
Truthfully, as determined by Mr. Jamboys as it was in 2008.
The truth is the truth.
That's the deal you had in 2008 for the Waukesha obstructing charge, right?
Yes.
And in that case, you got no jail
Correct.
after getting that letter.
Correct.
No further questions.
Any redirect, Mr. Jambois?
Yes, Your Honor.
Go ahead.
So first of all, I would move Exhibit D71 into evidence. That's the recorded statement or interview that was done with Aaron Dillard on October 10th.
All right, 71 is received.
And I'd also move the S69, which is the letter that the defendant wrote to his attorney, Gretchen Rosenke.
69 is received.
I'm sorry, it's the letter that Aaron Dillard wrote to Gretchen Rosenke. So you wrote a letter to Gretchen Rosenke, and that letter was 7 pages long.
Correct.
And then there was an interview that you were part of, and the transcript of that is 35 pages long.
Correct.
So there's a little bit more detail in the 35-page interview than there is in the 6-page letter.
Correct.
But let's go through the points that you made in the letter and the points that you made in the interview. Well, let's talk about your history and your experience as a con man. The direct and the cross-examination pretty accurately laid out your prior history as a con man.
Yes.
Is that something you're proud of?
No, I'm ashamed of it.
You're embarrassed by it?
I'm very embarrassed by it.
And yet, when you got out the last time, you continued to engage in fraudulent conduct.
Correct.
In your interview, you indicated that you had a gambling addiction.
Yes.
Did you ever get treatment for your gambling addiction?
Yes, I have.
When was the last time you gambled?
Probably 2 years ago.
So in order to feed your gambling addiction, you would befriend people and then defraud money from them?
Yes.
And so we were talking about a particular skill set. In order to get people to give you money, you have to earn their trust?
Yes.
And so did you use that skill set when you first were locked up with Mark Jensen?
Yes.
You gained his trust?
Yes, I did.
So tell the jury what sort of things you did to gain Mark Jensen's trust.
I gave him information he could use in his defense, like with the toxicology reports and the skin samples or the samples that were lost, to ask for new tests on them. And if they couldn't provide the samples, then you could get that evidence thrown out, things like that. I'd give him ways to just combat what the defense was going to come at him with, or what the prosecution would come at him with.
So Mark Jensen told you that some things were lost at the St. Louis Forensic Toxicology Lab.
Yes,
Now, you wouldn't have known about documents missing from the St. Louis Forensic Toxicology Lab unless Mark Jensen told you about it.
correct.
There's nothing about that in Ed Klug's transcript, is there?
No,
And for that matter, there's nothing about that. Even if you'd read the interview, well, of course, you never read the interview transcript between
No.
Mark Jensen and Paul Ratzberg.
no,
So the only way you'd know that there was anything missing from the records of the St. Louis Forensic Toxicology Lab is if Mark Jensen told you that.
correct.
And that's what Mark Jensen told you.
Correct.
And then after he told you that, you suggested that he should ask that those samples be retested
Correct.
with the expectation that if they were lost, then his case could get kicked out.
Yes.
Did Mark Jensen seem to be interested in that information?
Very interested. He got on the phone and called somebody to talk to him about it.
Almost immediately after you gave him this information, he got on the phone?
Yes.
You heard him talking to this person on the phone.
Yes.
You don't know who that person was.
No, I don't know who it was.
So after you provided this information, could you discern whether or not it appeared that Mark Jensen was trusting you more after you gave him that valuable information?
Yes, he was trusting me more.
And did he start to divulge more information to you?
Yes.
Now, when you first started talking with Mark Jensen about his case, what aspect of his case was it that Mark Jensen seemed most upset about?
The Edward Klug testimony.
Were you aware that it was after Ed Klug testified that Mr. Jensen's bond was substantially increased and at that point he was incarcerated?
Yes.
And how did you become aware of that?
I actually saw that in the newspaper.
So that's what was really uppermost in Mark Jensen's mind at that point was this guy Ed Klug testifies and suddenly his bond gets jacked up and he's put in jail.
Yes.
And that's why he was upset about Ed Klug's testimony.
Yes. Said everybody was out to get him.
Now, what did he tell you about Ed Klug?
He told me he was an attention getter, that he's just looking for the limelight, and basically that's mostly it, besides what he did.
Now, at some point he came around and he told you that he wished he hadn't opened his stupid mouth around his coworker about him wanting to kill his wife.
That's correct.
And that's on page 3 of the letter that you wrote to your attorney.
Correct.
Now, when he started talking to you, did Mark Jensen just spill everything all at once, or did it come out in stages?
Everything kind of came out in stages throughout the conversation on the 16th. On the 15th, we just, talked and talked and talked. And then on the 16th, he started telling me, and then it came out, and then I would get somebody to try to listen to the conversation that we had, and then it would stop, when the person was trying to listen.
So when was it that you told him about having his attorney or somebody asked to have these samples retested?
On the 15th.
Do you remember when on the 15th? Was it in the morning or the afternoon?
I believe it was the mid-evening, like around 6 o'clock or so, 5, 6 o'clock.
So it was on the evening of the 16th that you suggested to him that he should have these toxicology samples retested?
Of the 15th.
On the evening of the 15th?
On the evening of the 15th.
So that was the second day that you were in the...
Correct.
And so during the day on the 15th, what had you been doing insofar with regard to Mark Jensen?
Just talking to him about his case and getting him to open up about it and just speaking to him.
At some point you read, he allowed you to read the transcript of Ed Klug's testimony from the forfeiture hearing?
Yes.
Did you read anything else?
Nothing else.
That's the only thing that you read?
Correct.
So you may have obtained some information from Ed Klug's transcript, or you did receive information from Ed Klug's transcript, correct?
Yes.
Did he talk to you about the conference that he and Ed Klug had been at about a month before Julie died?
Yes.
What did he tell you about this conference?
He said that he shouldn't have mouthed off to his colleague because he was getting drunk, and he mouthed off to his colleague and shouldn't have done that because he had poisoned his wife on the way during that trip.
So he told you that he'd poisoned his wife before he left on that trip?
Correct.
Did he say anything else about poisoning his wife before he went on that trip?
No.
Do you recall reading anything in Ed Klug's transcript, in the transcript of his testimony, about Mark Jensen telling Ed Klug that he'd already poisoned his wife?
No, I don't believe that was in there. I don't think that was in his transcript.
So the only source of information about Mark Jensen poisoning his wife before he went on that trip was Mark Jensen?
Correct.
He also told you that when he got home from the trip, his wife had thrown up all over the carpet?
That is correct.
Now, that also was not in the transcript of Ed Klug's testimony, was it?
No.
I mean, so the only way you'd find that out is from Mark Jensen telling you that.
That's correct.
Did he make any other statement about his attempt to poison his wife or his attempt to murder his wife before he left for that conference a month earlier?
Just that he shouldn't have opened his stupid mouth to Edward Klug about it. That would have really screwed him up if she died on that weekend or that trip.
Did he tell you anything about whether he was lucky that she didn't die when?
Yeah, that's what he said. He said he was lucky that she didn't die on that trip or he had really been screwed.
Now, he also told you that on, what did he tell you about Julie going to the doctor, if you can recall?
He told me that she got prescribed Paxil and that he was trying to get her to go because she was depressed, things like that.
So in your letter, page 4, you wrote, on a Tuesday, he took her to a doctor and that doctor gave her a prescription for Paxil. That's what you wrote, correct?
Correct.
And then your interview on page 15, bottom page 14, I don't know what days they were. I don't know exactly what day, but he said they went to the doctor and she said she was just feeling just down and this and that, and they got a prescription of Paxil. And so that's what you indicated in the interview.
Correct.
And in the letter, you indicated later that day, he gave her the Paxil as well as Benadryl, St. John's wort, Literol, which was actually Librium,
Librium, yes.
and other drugs to make her woozy. That's what you wrote in your letter?
Yes.
And then in the statement, you said, and at that time, he told me they went home and she took the Paxil and she took more medications. It was, the St. John's wort. He kept saying about the St. John's wort. He kept saying about the Librium and then the Benadryl. And he said she took the Benadryl and the Librium and all that. And that's the first night when he gave her the antifreeze. That's what you indicated in the interview on page 15.
I believe so, yes.
And in the letter, you wrote later that day, he gave her the Paxil as well as Benadryl, St. John's wort, Literol, and other drugs to make her woozy. He then gave her a few glasses of juice with antifreeze in it. Correct?
Correct.
And when you were asked, and this is again on page 15, did he tell you how he got her to drink the antifreeze? You replied, yeah, he said she was so loopy and everything. He says he mixed it with juice and he said, here, this will make you feel better, and he gave it to her because she was really, really out of it, really loopy and tired and more. I don't know what the word he used was, but just sleepy, really out of it. And so he'd give her stuff to drink. And that's consistent with what you wrote in your letter. Correct?
Yes.
And then in your letter you wrote later that evening, he said she was up jumping around on the bed and saying she was drunk. He said he took her to the computer to comfort her and show her it was a side effect of the Paxil. That's what you wrote in the letter, correct?
Correct.
And you wrote, and you said in your statement, and again, this is on page 15, and so then he gave her the antifreeze that day, and then at nighttime, he said she was acting like a nutcase. She was up on the bed, dancing around, saying, oh, I'm so drunk, I feel so drunk. He was telling me all that. And then he told me about how he went to the internet to show her that Paxil was a side effect of drunkenness, He said, oh, look, it's just the Paxil, don't worry about it, blah, blah, blah. So they said everything calmed down, and she ended up going to bed. And the next day, he went to the doctor and told him she was acting drunk. She's, all crazy, wouldn't sleep at all at night. And he got her sleeping medication, which is the Ambien. He got her Ambien. And he said he came home after the doctor and gave her the Ambien, and she was sleeping. That's what you said in your statement on October 10th, 2007?
Yes.
And in your letter, you wrote, the next day he said he went to the doctor to talk to him about her, and that doctor gave him medicine Ambien. He went home and gave her that. He said that way she would sleep through all the effects of the antifreeze. He said that he gave her some more juice with the antifreeze, and he intoned when he said juice. So he said it was like juice, meaning that it was not just juice.
Yes.
And in your statement, he said he came home after the doctor and gave her the Ambien and she was sleeping. And when she woke up, he gave her more of the antifreeze, another glass of it. And at that point, he said that that whole day she was throwing up and she was just really out of it.
Correct.
And you wrote in the letter, that night he said the kids were worried about her, so they sat with her a bit and watched TV. He said he gave her more Ambien to sleep. That's what you wrote in your letter, correct?
Correct.
And in the statement, you indicated on page 16, and then that night he sat with TV and watched TV with the kids and something like that, and she would just ask for a lot of water, and she was drinking a lot of water and throwing up. So he told you about the TV both, and
Yes.
both you indicated that in the letter and also in the statement that you gave to myself and the other people assembled in that interview, correct?
Correct.
And in the letter you said that night he said the kids were worried about her, so they sat with her a bit and watched TV. And he said he gave her more Ambien to sleep. He said the next day was so hard for him, was kind of teary. He said she was really sick in the morning and the kids wanted to call the ambulance, correct?
Correct.
And in your statement on October 10th, you wrote, so that night he gave her more of the Ambien. Then he said the next day when she woke up, she was really bad. It was that she was breathing real hard, breathing just really nauseous, and she couldn't get out of bed. She wouldn't lift her head and she wouldn't do anything. And at that point, that's when he told the kids wanted to call an ambulance, and he got real nervous about it. He said he didn't know what to do at that point because, I can't send her to the hospital. So he said that he told the kids that if mom isn't better by the time you get home from school, we'll call the ambulance or we'll take her to the hospital. That's what you indicated in your statement?
Yes.
In your interview? And in the letter you wrote, he said the next day was so hard for him, was kind of teary. He said she was really sick in the morning and the kids wanted to call an ambulance. He calmed them. He said he gave her another sleeping pill so she would just sleep, and said to me he thought she would be dead by the time he got home from running around. And in your statement, you wrote, it said, so he took her to school. What you meant to say is he took the kids to school?
Correct.
He said he took her to school, but he took the kids to school. And at that point, he came back, and then that's when he told me about him. He said he was worried because she wasn't breathing hard anymore. Is that what you wrote? And that's what you said in your statement on October 10th, 2007?
Yes.
And in your letter, you wrote, he said he gave her another sleeping pill so she would sleep. Said to me he thought she would be dead by the time he got home from running around. He said he went out, kids' school, came back, some check thing, and came home. He said she was breathing better, and he was scared. She was not going to die before the kids got home. Correct?
That's
What
correct.
you wrote in the statement? So in your statement, in your letter to your attorney, after indicating she was breathing better, he was scared she was not going to die before the kids got home, they would force him to call an ambulance. He said she was sound asleep and very non-responsive. Said she was sleeping on her back, and he rolled her over a bit, and she did not wake up. So he rolled her over on her face with her face in the pillow. He thought that would make it hard for her to breathe. He left her for a bit and came back, and she was still alive. Then he got on top of her, pushed her head in the pillow, and sat on her back so she could not breathe, and she died, and he went to work. That's what you indicated in your statement, in your letter to Gretchen Rosanke. Is that true?
That's correct.
And in your statement, you indicated, he said he got near, he said she wasn't raspy breathing. He didn't know what was going to happen at that point. And he said he got nervous. He said he got real nervous at that point. And he sat on her. He sat on her back, and he said, I couldn't have the kids come home because I couldn't have an excuse. So he said he sat on her back and then pushed her face into the pillow, and then he killed her. And then at that point, he left for work or whatever.
Correct.
What page is that?
Page 16. Now, all this information I just told you, that was not in Ed Klug's transcript, was it?
No, it was not.
The only possible source of this information would be Mark Jensen.
Yes.
And you hadn't seen the crime scene photos showing Julie in such a position that it appeared as though she'd been rolled on her side.
No, I've not.
And you had not seen the autopsy photos that indicate that there was bruising along the rib cage, right, that would line up with where her arm was underneath her.
No, I've not.
So you had no idea that the physical evidence in this case would correspond perfectly to the description that Mark Jensen gave you about the manner in which he murdered Julie Jensen.
No.
Now, you knew as Mark Jensen was telling you this information that this could be valuable to you.
Correct.
So you wanted to make a point to ensure that the information that you obtained from him, you accurately relate it to law enforcement or to the prosecutor.
Yes.
And you hope to use that in order to get yourself out of jail.
Yes.
And it worked out just the way you'd hoped.
Yes.
Just kind of like when you got the money from the people that you defrauded money out of, you felt this success that you got some money, right?
Yes.
And you felt some success because you got what you wanted in this case.
Well, I mean, yes.
But you got it in this case by telling the truth about what happened.
Correct.
And you knew that telling the truth was an essential component of every aspect of getting any kind of a deal from the prosecution.
Yes.
And in this case, now you're testifying, and the only thing you're going to get is a letter from the prosecutor to the current prosecutor indicating that you've testified truthfully in this case.
Correct.
You wanted us to write a letter requesting leniency on your behalf.
Yes, I did. I didn't want to be in prison again and be under all this.
And we categorically rejected that proposition, didn't we?
That's correct.
You're not getting any kind of a request or recommendation of leniency from this prosecutor, are you?
No.
Nor from the prosecutor seated to my left.
Correct.
The only thing you're going to get is a letter indicating that you testified truthfully in this case.
Correct.
Now, among the skill sets that you've developed over the years as you defraud people out of their money, and you got Mark Jensen to tell you what happened in this case, among the skill sets you never learned to talk to the dead, did you?
No, I have not.
You're a con man, but you're not a seer.
Correct.
So the only way you could have gotten the information that you described to this jury about the manner in which Mark Jensen murdered his wife, you got it from Mark Jensen. Isn't that true?
That is correct.
Now, Thomas Kaiser is your cousin,
That is correct.
and Thomas Kaiser got tagged with a charge, but was it 2007 or 2006, something like that?
Sure, yes.
And you gave information to law enforcement at that time
Yes.
against Thomas Kaiser.
Yes, I did.
And did that leave Mr. Kaiser kind of peevish toward you?
I think it may have.
Yeah. So you may have an axe to grind with you.
Yes.
You indicated that in the jail you invited somebody to come over and listen.
Yes.
And who was the person that you invited to come over and listen?
Dion Hardison,
And why did you make that special invitation to Dion Hardison?
because I wanted somebody else to hear what Mark was saying.
And Dion Hardison, is he white or is he African American?
African American.
So when did Dion Hardison try to come over and listen in on your conversations with Mark Jensen?
Yes.
And that was in response to your invitation to Dion Hardison?
Correct.
And when Dion Hardison would come over to try to listen, what would Mark Jensen do?
He was shut down.
So he wouldn't talk about it in front of Dion Hardison.
Correct.
While you were there, did he talk to anybody else about his case besides you?
Yes.
Who else did he talk to?
I don't know his name, but I think he was in cell 5 or 6.
Describe him if you can.
Oh, gosh. I think he was about 6 foot, 220, white guy.
And you remember what he said? Were you present when he talked to that other guy?
I was near, so I could hear things, but it was kind of the similar things we were talking about how the Klug statement, how he was a attention getter and all that.
Did he confess to that other guy about killing Julie?
That I do not know.
So is there any other person that was in the cell block that he confessed to besides you that you are aware of?
No.
Was it hard to get Mark Jensen to talk about the case?
Not really. He seemed like he wanted to talk about it.
But when he was talking to other people, he wasn't telling them that he'd murdered his wife.
What I believe, yeah, he did not.
You never heard him say that to any other person.
Correct.
But you're the only person that provided him information about checking on this tax stuff from St. Louis Forensic Toxicology Lab.
Objection beyond the scope of what this witness has testified that he knows.
Well, you attacked his credibility pretty good. So I'm going to give the state a little leeway. Go ahead, Mr. Jim Boys.
Could you read the last question back, please? Nothing further on redirect, Your Honor.
Recross?
Yes.
Go ahead.
You just got done testifying that in your letter or in your interview that Mark Jensen told you he mixed 1/3 antifreeze, 2/3 juice, correct?
Correct.
We've talked about how you testified in this case previously, right?
Correct.
On January 18th, Counselor, I'll direct your attention to page 109, lines 19 through 22. You were asked, did he tell you how much antifreeze and how much in the juice? Answer, no, not exactly the amount. He didn't go into detail about that.
Yeah, he said roughly 1/3 to 2/3, so that wasn't exact amounts.
How many people were in the cell block with you in 2007?
7 others.
7 others, and how big is the common area?
About, I don't know, about 12 feet by 25 feet.
And when you were having this discussion, was everyone else in their cells?
Sometimes they were, sometimes they weren't.
In all your experience that we went through with the different frauds you've committed, do you think that if you said that you read Detective Ratsberg's interrogation transcript, that it would be convincing that you got your information from the mouth of Mark Jensen?
I've never read Detective Ratsberg's information, so I couldn't answer that question.
Do you think you would have gotten a deal from the state if you had told the state that Mark Jensen denied killing his wife?
Yeah, why would I? Yeah.
You would have gotten the
wouldn't.
same consideration if you had said that he denied killing his wife.
No.
Nothing else.
All right. We are done with this witness then.
All right, chat. Aaron Dillard going back to jail to face his other pending charges. What do you guys think? Was Aaron Dillard a credible witness? We have a poll up on YouTube.
For the record, is our next witness.
The next witness is Lindley Kapelish, number 30.
On Facebook, put a 1 in the chat if you
And
think Dillard was
How
credible.
long is the direct going to take?
Put a
So
2
this
if
witness
you
and the
think
next
he
one
wasn't.
are quite short.
All right, let's call this witness then.
Welcome to the
Number
stream,
30.
everybody. Thanks for
Yeah, so the
tuning
state for the
in.
record is calling Lindley Kapelish.
All right.
Be sure to like the stream over on YouTube, like and follow the Facebook page, share the stream out. Let's build our community over here. We are hearing that some of the other channels are having some tech difficulties.
Just remain stand, raise your right hand. You solemnly swear the testimony is meant to be the truth, whole truth, nothing but the truth, so help you God? Thank you. Try to get as close as you can to that microphone. And then if you could spell your first and last name for the court reporter.
Sure. Lindley, Lynley, Kapelish, Kapellusch.
Go ahead, Ms. McNeil.
How are you currently employed?
I work for the Kenosha County Sheriff's Department in the Jail Division.
Now I want you to think back to the 1990s, particularly starting in 1996. During that time period, where were you employed?
Robert W. Baird and Company.
And what kind of company is that?
It was an investment firm.
And what was your job there?
Sales assistant.
And so what were your job duties?
I would assist the brokers as well as answering the phone.
And how long did you work there?
From August of 96 to August of 2002.
And did your time working there overlap with Mark Jensen working there?
Yes.
And what was his job there?
He was a financial advisor.
Now, were you in that job? Were you the primary person answering the phone?
Correct. I would be the first one to answer the phone, and then if I was on the phone, it would bounce back to two other women that I worked with.
So during the time period when you worked there and Mark Jensen worked there, so August of 1996 until about June of 1998, did you ever receive any harassing phone calls?
No, not to my knowledge.
So as the receptionist, you don't recall any phone calls where anyone yelled at you or swore at you?
No,
Were there any phone calls that Mark Jensen complained about that were harassing in nature?
no,
Were you told as the receptionist, hey, be on the lookout, there might be harassing phone calls for Mark Jensen?
no.
And how was the mail handled in this office when incoming mail would arrive?
Our office manager, Joan, would open the mail.
Is that Joan Scully?
Yes, correct.
And if Joan Scully was not available, would other assistants like yourself open the mail?
Yes, I would open the mail if she was absent.
But mostly it was Joan Scully's
Yes,
job?
she was primary.
And same thing with the phone calls, if you weren't available, another assistant would help?
Correct.
Now, do you ever recall a time period when you worked with Mark Jensen at Baird where there was pornographic images coming in the mail?
No,
Do you ever recall him complaining about pornographic images being left on his vehicle?
no,
And were you ever warned, you or any of the other employees that you're aware of, Were you ever warned that there might be pornographic images coming in the mail for Mark Jensen?
No,
Now, during this time period that Mark Jensen worked with you, did you have occasion to meet Julie Jensen at all?
yes, yes.
And what were those circumstances?
She would come into the office with the boys.
And so on occasion, Julie would visit her husband?
Yes, they would bring him McDonald's or come in and see him.
And occasionally the children would be there too?
Yes,
I have nothing further for this witness.
Across.
That would be me, Ms. Renner. Your
Go
Honor.
ahead.
Can you remind me one more time how to say your last name?
sure. Capellish.
Capellish. Thank you.
You're welcome.
So I understand you worked with Mr. Jensen at Baird,
Correct.
and that would have been starting around August 1996
Correct.
until he left the office.
Correct.
You did not make the transfer to Stifel Nicholas with him, did you?
No, I did not.
Now, you indicated that your job was a sales assistant, right?
Yes, yes,
And as part of that job, you would answer telephone calls.
yes,
And occasionally, then you would transfer those to the brokers.
yes.
Now, you were first talked to about this case in 2007, right?
Yes.
And at the time, where were you working?
For the Kenosha County Jail,
Okay.
Kenosha County.
All right. So at that point, you were being asked to remember back a decade.
Yes,
And is it fair to say that you wouldn't necessarily remember hang-up calls that happened in the office 10 years ago?
no, I wouldn't remember them if people call the wrong number and they hang up without saying anything. I mean, it wouldn't stand out, no.
And additionally, did the brokers have direct phone lines?
No,
They did not have the ability, like people couldn't call Mr. Jensen directly without going through you?
not that I know of, no. I had to transfer calls.
Okay. If there was a private line or a direct line, would you have known about it?
I would assume so. I don't know of any direct lines.
Okay. So you would have to remain on the call with Mr. Jensen or any of the other brokers?
No, I would transfer the call.
Okay, so you would transfer the call to a different phone number where the broker would pick up.
Right,
So there was a separate phone number for the broker, for each of the individual brokers.
and that, yes,
Otherwise, you would have to have remained on every single call with every
Correct.
single broker.
right, correct. No, I transferred it to their phone.
So there were private lines. You're
Right.
just not aware if anybody outside of the business had them?
I am not aware of people calling into them, I guess is what I'm saying.
Okay. Now, did you, as part of your duties, keep a log of everyone who called for each of the brokers?
No,
So you would receive calls from people who are not current clients, is that correct?
correct,
And those, even though you didn't know who the person was, you would transfer them to the brokers?
correct.
And Mark would take those calls, correct?
If it was his day, yes.
And you didn't stay on the line after a call was transferred?
No,
So you don't know what actually was said on any phone call that was transferred after you transferred it?
no,
Now, did you have a personal social relationship with Mr. Jensen?
no,
So you didn't hang out with him outside of work?
no,
Didn't talk about your personal problems?
no,
Didn't talk about his personal problems?
no,
Go ahead.
Now, I'm going to be showing you here what is marked as Exhibit D68. Can you tell what that is?
Looks like a copy of a postcard.
Okay. And that postcard is addressed to Mr. Jensen at Baird.
Yes, it's addressed to Baird and Company and attention Mr. Jensen on the bottom.
Okay. And have you seen this postcard while you were working at Baird?
No,
So you didn't have interaction with this postcard and it was not brought to your attention?
no. Mm-mm.
So you've never seen that before?
Nope,
Not as part of your employment?
the first time I testified is the first time I saw it, but no.
I can take that. Now, when you were employed at Baird, you were aware that Mr. Jensen had hired a private investigator? Were you aware of that?
No,
Were you aware that this private investigator staked out Mr. Jensen's car at the office for a day?
no,
Redirect.
So just to be clear, when you answered the phone and someone asked to speak with a broker, would you have that person identify themselves?
I would have them identify themselves if that was their client. A lot of times if they were call-ins or walk-ins and the broker of the day was the term, then I would just forward the call to them saying it's a call-in or potential.
But you would want to give the broker the name of the person calling, regardless who it was.
Yes, they like that.
And your understanding of how the lines worked at Baird was all the incoming calls would be essentially sorted through you.
Correct.
That's all I have. Thank you.
Anything on those two questions?
But again, you didn't keep a log of who was calling, right?
No,
And you didn't do any investigation to determine if the name they were giving you was their real name?
no.
Nothing further.
All right, you're excused. Thank you.
Thank you.
Witness,
Yes, I do.
what number?
So this is number 43, Ann Lynch.
So this previous witness, Lindley Capellish, did testify in the 2008 trial. If you guys are new to the platform, thanks for tuning in. Stay tuned during breaks. We play some trial recaps. We play some footage from the 2008 trial. We break down the case. We give you case background, history, answer your questions you guys are dying to get answers to. Be sure to like the stream, everybody. Share it out. Thank you so much for tuning in.
Standing, raise your right hand, I'll swear. You solemnly swear the testimony in this matter will be the whole truth, nothing but the truth. So help you God?
I do.
Just go seek into that microphone. Spell your first and last name for the reporter.
Ann Lynch,
And if you could just spell both your first and last name.
ANNELYNCH.
Thank you. Go ahead, Ms. McNeil.
Yeah.
Sorry.
So Ms. Lynch, Can you tell us, did you know a person by the name of Julie Jensen?
I did.
And how did you get to know Julie Jensen?
Her son, younger son Douglas, was in my class at preschool.
And so about what year, what time period would Douglas have been in your class?
In 98.
And what was the name of this preschool?
Kids Castle.
And what was the time period that this class was held? Was it every day? Was it half a day? Can you tell us about that?
The school itself was every day, Monday through Friday. He was part-time, I believe, Monday, Wednesday, and Friday.
And would that be part of the day as well?
He was probably until lunch break, maybe 11:30, 11.
So during 1998, during what would have been that school year, you would have seen Douglas 3 days a week?
Yes,
And it's about for half a day each day?
yes.
And who was the person who would pick up and drop off and pick up Douglas?
Julie.
And through that, did you meet Julie Jensen then?
Yes.
Now, I'd like you to think of the time period shortly before Julie Jensen died. During that time period, did Julie Jensen have a discussion with you about Douglas going into the kids' castle full time?
Yes, she did.
And can you tell us about that discussion?
She came to pick up Douglas and was very upset. She was crying, said that her marriage was over, and she was afraid that Douglas would have to be in preschool for full time. She was worried about him.
And so was that connected with her saying her marriage was over, that Douglas would have to go full time?
Yes, she'd have to get a full-time job and was worried about Douglas going to school, being 3 at full-time.
And so she expressed that concern to you?
Yes.
Now, she indicated to you that her marriage was over. So was it your understanding that she was looking into divorce?
Yes.
And then getting a full-time job?
Correct.
And therefore, at the kids' castle, Douglas would have to be there all day?
Yes.
And she seemed distressed about this situation?
She did. She was crying and shaking.
And about how long after that conversation did you learn that Julie Jensen had died?
It might have been the last conversation I had with her. I couldn't tell you for sure.
After Julie Jensen's death, did you go to the funeral?
I did.
And was there anything at the funeral that was that happened that you recall?
I had went over to Douglas. He was coloring in a book, and his father came over and talked to me, explaining that Julie had multiple doctors and multiple medications, and that it was the mixture of this that caused her death.
And so you mean by Douglas's father, are you referring to Mark Jensen?
Yes.
Did you ask him about how Julie had died?
No.
So he just came up to you and started talking about this?
Yes.
What was his demeanor like when he talked to you?
Just matter of fact. He didn't seem upset or distraught or anything.
And so after Julie Jensen had died, did Mark Jensen continue to bring Douglas to the kids' castle?
He did.
And did Douglas's schedule change at that point?
It was all Monday through Friday, full time.
I have no further questions.
Doing
Thank you.
across.
Attorney Krause.
Go ahead.
Ms. Lynch, prior to the funeral, you had limited contact with Mr. Jensen?
Yes,
Most of your contact was with Julie.
correct.
She was the primary pickup and drop-off person.
Yes.
You didn't have any contact with Mr. Jensen prior to this visitation or funeral?
He had dropped off.
And in the hours leading up to it, I'm sorry, that was a bad
Oh.
question.
No, I did not.
You don't know if he had grieved privately with his family or his pastor?
I do not.
The limited contact you had with Mr. Jensen prior to the funeral, did he talk a lot about his personal life?
No,
You weren't friends with him?
no,
You had testified that Douglas went full-time. Was that after Ms. Jensen's passing?
correct.
And before that, it was 11 to 11:30.
About that, yes.
After he went full-time, what time was Douglas done with daycare?
I was gone when he would be picked up, so I'm not sure what the hour was.
What time did you generally leave?
1.
When you talked to Julie Jensen shortly before her passing, you had testified that she was crying
Yes,
and shaking
yes.
because she was upset that her son had to go into full-time daycare.
That and
The fact that she might be getting a divorce.
correct.
The conversation that you had with Ms. Jensen, do you know what the time period was between that conversation and her passing?
I do not.
Was it a month earlier?
I'd have to say it was a little bit less than that.
When you talked to Ms. Jensen on that day, she never expressed any concerns about being afraid of her husband.
No,
She expressed concerns because her marriage was ending
correct.
and she had to put her son in daycare.
Yes.
Nothing further. Thank you, ma'am.
Redirect.
Just to clarify the timing of that conversation,
Mhm.
did you testify that this particular conversation about marriage ending, that might have been the last conversation you had with Julie Jensen?
It might have been, yes. I don't remember for sure.
And so do you know how long before her death that was?
Not for sure, no.
Okay, and you're just trying to remember back to 1998.
Right. Yes.
I have nothing further.
Any questions? Thank you. All right, you're excused. Thank you. All right, I think it's a good time to take our morning break, folks. Again, please don't talk about the case. Take your break. Thank you.
All right, chat. So this morning has been interesting so far. What did you guys think about Aaron Dillard? Did the defense do a good enough job discrediting his testimony and showing that Dillard not only read the Ed Klug transcript, but possibly read the transcript from the 1999 police interrogation?
'22.
22. Do we have any issues of any witnesses this morning that we have to discuss prior convictions?
Yes, we're going to have David Thompson, and he has a number of priors that we have.
All right, once you guys talk during a break, see if you can come up with a number and we'll put it on the record, okay? Thank you.
All right, there you have it. So Paul Griffin is going to be the next witness. And then today at some point, we are going to have David Thompson. Thompson, for those of you that don't know, testified in 2008 that Mark Jensen and he conspired to kidnap Ed Klug to prevent him from testifying. Now, there is some controversy surrounding David Thompson and Bob Jamboy. David Thompson alleges that in late 2006, early 2007, that he sold a specific type of drug to Bob Jamboy. And this has been denied by Jamboy. It's led to arguments in the court. We have those clips too. We can play them a little bit later on. Stay tuned. Again, chat, if you're new, thanks for tuning in. You have tuned in to Never Stop Media. We are an investigative, independent investigative journalist company. Check out our website for articles that we write. You can find those on Never.Stop.Voices.com. And our YouTube channel has tons and tons of content over the last couple of years. Streaming some trials is a little new to us. We do have some trials up on the page, and we just recently created a new YouTube channel that we need to get to 1,000 subscribers. I just created it this morning, but the intent of that is to only put trial content on there, so it doesn't kind of saturate this YouTube channel where we do a lot of civil rights issues and corruption within systems, trying to kind of separate it. Some people are not interested in civil rights things and corruption and all of that, and they only want to watch trials. So we get that over here, chat. So we created a new channel for you guys, but we can't go live on that channel until we get 1,000 subs. So I'm trying to put some content up there as we're all sitting here watching the trial today. And once we reach the 1,000 subs, we'll go live on that channel as well. So that is that, chat.
You're familiar with the phases of ethylene glycol poisoning?
No, I'm not.
Not at all?
Not at all.
Were you at one time?
No, I'm not. I wasn't at one time.
Wouldn't be able to testify at all about,
No, I would not.
okay, so
Not about ethylene glycol. I'm not an expert or even very comfortable going through the different pharmacokinetics of ethylene glycol.
so if you testified in 2008 about the phases of ethylene glycol, do you wish you hadn't?
I wish I hadn't.
Have an H&R Block Tax Pro do your taxes online, and tax season feels just as good as all those others.
I do have one issue. If the parties want, I don't know if it's going to be an issue. And Mr. Jambo, you could probably respond. Was there an issue as to the termination of Dr. Maureen Levin?
Yes, Your Honor. The defense had sought to cross-examine Dr. Mary Mainland about Dr. Lavin's termination of employment. Of course, Dr. Mainland was not here at the time that Dr. Lavin was terminated. The state believes that any testimony regarding any information regarding Dr. Lavin's termination from employment is not relevant to this case. Dr. Lavin was the medical examiner for Kenosha County at the time this case was on December 3rd, 1998, the date that Julie was killed. But she testified at the preliminary hearing. But while preparing this case for trial, she refused to answer questions in my office about her, whether or not she was board certified. We knew she was not board certified. We were simply asking her questions about this, and she said she wasn't going to answer it. And I said, well, you understand that when you go into a courtroom, if you refuse to answer questions that are put to you in defiance of the judge's order, you may leave that courtroom in handcuffs, and you are required to answer questions in court. And furthermore, when you're sitting in the district attorney's office and he's asking you questions, you are obligated to answer those questions as well. And if you don't, you're going to be terminated. And she refused to answer questions about her board certification. And as a consequence, she was terminated. It had nothing to do with her opinions concerning any of the evidence in this case. It had nothing to do with her theory of what, or her prior testimony as to the cause or manner of death in this case. It was simply because she had not become board certified and she refused to answer that question.
So she never testified in Jensen 1, right?
No, she did not testify in the
And
trial.
Dr. Mary Mainland testified?
Yes, Your Honor.
And she was obviously the medical examiner for Kenosha County at the time, or from another county?
She was our medical examiner at the time of the Jensen trial.
So what would she know about the termination of Dr. Levin?
Well, as she indicated, she really didn't know that much about it. And she had heard things about it, but she wasn't here at the time that Dr. Levin had been terminated. I think what the defense counsel was trying to elicit from Dr. Mainland was that she was intimidated into rendering these opinions by the district attorney because the district
And
attorney.
that was you?
Yes, because the district attorney had gotten the previous medical examiner terminated. But she was not terminated because she refused to agree with the prosecutor's theory of the case. In fact, the prosecutor's theory of the case has always come from the medical examiners. It's not the other way around. But she was terminated because she refused to answer questions pertaining to whether or not she was board certified. It has nothing to do with the development of the evidence in this case. So it's completely.
Did we ever find out if she was certified or not?
She was not board certified. That's why she refused to answer the questions.
So Judge, I think the concern is that as it relates to the cross-examination of Dr. Mainland testified that she was aware of some of this information, maybe not everything that Attorney Jamboy said, because she wouldn't have had that information unless Attorney Jamboy told her that information. But she was aware that there was an issue as it related to the Jensen case and her findings that caused Dr. Mainland was aware that there were issues with Dr. Levin and her findings in the Jensen case, or her testimony in the Jensen case, that caused her to be terminated from her employment.
Did she
She knows
testify
nothing
to
about
that
the
in front of
findings.
Judge Schrader?
She testified that she was aware that that Dr. Levin was terminated.
While you're looking at those other transcripts, see what she said in Jensen.
So, Your Honor, I can tell you this. The whole theory of the cross-examination of Dr. Mainland was to suggest, plant in the jury's mind, that Dr. Mainland was somehow intimidated by the prosecutor into rendering the opinions that she rendered in this case. Contrary to what defense counsel just said, there was nothing about Dr. Levin's testimony.
That's what I'm saying. Get the transcript and let me take a look at it.
Okay.
So remind me, that's another issue for the pretrial.
All right. Man, controversy. Tons and tons of controversy surrounding old Bobby Boy. There is a lot. Pull up a little bit of this to give you guys a little background on this alleged back alley deal. It's hard to tell if there is credibility to this or not, but there is so much controversy around Bob Jamboy. In the last little clip that we just played, where Bob says that, and this is kind of notable, Bob says that there's this allegation about how he intimidated this doctor to basically give this testimony that Bob planted in their heads. And that's kind of an interesting statement, because Court TV released a documentary. It's very one-sided. It's from the prosecution's theory side, but it's very interesting to watch. I encourage you guys to watch it. But in there, Bob kind of straightens up in his chair and he's telling the documentarian that he told people what this case was and what the theory was and how Julie died. He told them. It's kind of an interesting thing because DAs don't normally do that type of stuff, and they take what the investigation gives them. But Bob told them. He was the superhero in the case. So, very interesting chat. It's very interesting. We don't know if these allegations are true or not, but there is so much controversy surrounding DA Bob Jamboy. We also posted on the Facebook page, if you haven't seen this, so in 2016, Bob Jamboy sued the Dane County District Attorney's Office and won a $350,000 settlement. We got the court paperwork up there. Little description about what happened. Check that out if you're interested. Here is the alleged deal with David Thompson, the jailhouse snitch, who claims that him and Mark Jensen plotted and schemed to kidnap Ed Klug so he couldn't testify in the original trial. Let's see what you guys think.
I don't know how to bring up this other motion, but is the defense still wanting Mr. Thompson to testify that he sold cocaine to Bob Jamboys in 2006 or 7 or whatever that year was during the trial?
Judge, this is Jeremy Perry for the defense. We don't believe that what Mr. Thompson is saying is true. Okay, we think that this is a lie of Mr. Thompson's. We do think that his lie about this and his claim to say, or his willingness to say whatever he wants to say to try to get him out of whatever situation he's in whatever moment he's in, we think that his lie is relevant in terms of being cross-examining him on that. And this is the state's witness. So
I don't care whose witness it is.
Well, it's the state's witness, and this is what the state's witness has told us has happened. And so
Give me a date that he told you this. Exact date.
It's June of 2017. That's June of 2017. Yeah,
11/2/2016.
When?
November 2nd, 2016.
That's when he told the investigator about this.
Yes.
And when supposedly did he sell the cocaine to Mr. What year?
Sometime between November of 06 and
Between 2006 and January of 07.
All right, chat. They are coming back.
It was emailed to the clerk, but it's addressed to the court. I did give copies to each side, so the attorneys for the prosecution and the defense have a copy of that letter. And then, Ms. McNeil, do we have a number for prior convictions for Mr. Thompson?
So we have the same debate as we had for Mr. Dillard. We are agreeing on the number. It's just based on the years, how far back the court goes. So if the court went simply back 10 years from today, it would be 4. If the court went 10 years back with 2007, when David Thompson initially became a witness in this case, then the total number would become 10.
Well, to be consistent, I'm going to say 10. That's what we did for Mr. Dillard. So, okay, so whoever's going to talk to him, tell him the number is 10. Okay, are we ready for the jury?
Yes, Your Honor.
Yes? All right, bring the jury out.
All right, make sure you guys like and share the stream. We have tons and tons of breakdowns of this case, chat, on the YouTube channel. We even did a viewer discussion where we have kind of a theory here that there is so much evidence that points to Julie Jensen staging this entire thing and kind of pulling, if you saw the movie Gone Girl, kind of pulling a Gone Girl moment and accidentally unaliving herself. And our viewer discussion that we have that you can find on the channel really does a good breakdown of that. Check that out, chat, because that's another theory. It's an interesting concept. We have the same theory here. We point out all the discrepancies in the testimonies, all the evidence that points to Mark as well as points to Julie. We still have a lot of trial left here, chat. A lot of evidence, a lot of testimony.
All right, we are back on the record. Mark D. Jensen, 2002 CF 314. The appearances are the same. The jury is back in the courtroom for the record. With that, your next witness, Ms. McHale, or Mr. Jamboys.
You're on the state called Paul Griffin.
All right.
Also, chat, we have hours and hours and hours of marathon streams from the original 2008
To the
trial.
microphone.
So you guys can
Spell
see
your
what
first and
happened
last name for the
during that
recorder.
trial. Gives you a lot of
My name is Paul
background.
Griffin, Paulgriffin.
Thank you. Go ahead, Mr. Jamboys.
And Mr. Griffin, could you please pull the microphone that looks like this, pull it as close to your mouth as possible? And Mr. Griffin, do you know Julie Jensen?
Yes, Julie was my sister,
And is she your younger sister or your older sister?
my older sister. She was 4 years older than I am.
Did you have any other siblings?
Yes, I have 3 brothers.
So why don't you tell me the ages of your siblings and starting with the oldest and working your way down?
Okay, my oldest brother, Larry, he's 10 years older than I am. Then there was another brother named Richard, and then Julie, and then my brother Michael, who was 2 years older than I am, then me, then my brother Patrick, which was 5 years younger than I am. So in total, we had five children in our family, ranging 15-year range.
And you'd mentioned a brother Richard, and can you tell us about Richard, if you know?
Richard was older than I, so he unfortunately died at a young age before I was born.
So you never met Richard?
No.
Now, tell me about your parents.
I wish you all could have met my family, could know my family. My parents, my father, Ray Griffin, he worked at American Motors Company here in Kenosha. Before that, he worked for Simmons Mattress and Peter Pierce Fire Truck Building Company.
And when your father was working for American Motors, what did he do at American Motors?
He was a designer, a drafter. So my understanding, and this I learned later because I met someone who worked with him, who actually worked with me later in life. And he used to design in a lot of the things in the car that weren't designed in, like the air conditioning units and things like that. Kind of like the second thoughts of the design, or the things that had to go into the cars before they went into production.
And what did your mother do, if you can recall?
My mom was a homemaker. She took care of the family. She cooked and cleaned and provided, all the necessary things in our home. At one point, she did work part-time.
So what kind of father was your father?
My father had grown up as a farmer in Bristol here, and he was fair but firm. As kids growing up, if you were bad, you'd get a spanking. It was simple as that. And once in a while, if you were really bad, you'd get a swat on the rear with a willow stick, But my mom was always there to say, he's had enough. So, my parents were really good, loving parents. They taught us to be fair, kind, not lie, not steal. We attended church regularly. My mother was Lutheran, and three of us, my brother Michael, and Julie were raised Lutheran. My father was Catholic, a devout Catholic, and for some reason our family remained that way. As a kid, it was a cool thing to tell my friends, yeah, my family split religion, but it was never an issue, and we just went to different churches, and always went to church on the holidays and every Sunday.
So, what sort of things did your family do together?
We were big into camping. My dad, being a very creative, resourceful designer, actually bought a Jelco school bus and parked it in our driveway for like a few months and converted it into a fully functional RV.
What was in this fully functional RV?
It had bunk beds in the back. It had a bathroom in the back with a toilet and a shower. It had a pull-out bed that was a couch. It didn't have a TV, I don't remember, but we weren't into watching TV while camping. It had a stove and refrigerator, a dining room table, and I think he kept two of the original bus seats in it as the dining room table.
And did you often use that RV camper?
Yeah, we used it to go to the Ozarks. We used it for weekend trips when we'd go up to Eau Claire to visit my oldest brother in college. We would take it on long trips. So we went to the Smoky Mountains with it. It was a huge source of pride for my family, my dad. And while it was a Jelco school bus painted tan and brown and said Ray's Rogue on the front of it, which may have been a little bit embarrassing as a teenager, but on the other hand, it was, we would camp next to people that had the really big, fancy, shiny RVs made by companies, and yet they were enthralled and loved it.
Tell us about some of the, you said your father worked at American Motors. Did you ever go on any camping expeditions that were connected to American Motors?
Yes, my father would take us to, yearly we would go to the proving grounds, and I think it was in East Troy, Wisconsin, where we would camp there for a few days, and all the engineering people would bring their campers and buses and camp out there. And
this was a company-sponsored event?
Yes.
So what sort of activities did you and your family engage in at this company-sponsored event?
Well, my dad, we got to see all the new like Javelins and AMXs and all the new concept cars from AMC at the time. And then my dad would take us, like the entire family, and ride us on the test track with all the bumps and test ride for the vehicles.
Were there other activities that you did with your that you did as a family together besides camping?
Yeah, tons of activities. We ice skated, roller skated. We went to Red's roller rink a lot as a family. We my being a one income family, I look back on this and I respect my father so much for providing so much. We were always proud of what we had and proud of who we were. And you know, my dad made things work even with five kids. So, you know, sometimes we wore hand-me-downs and shopped at Goodwill, but we all had ice skates, so we would go. We lived on 82nd Street, which at that time was a gravel road and dead-ended into a cornfield. And if you walked like what seemed like a mile as a kid, but it may have been like a quarter mile, but if you walked into that cornfield, you found a pond. And so in the winter, when it was cold enough, and that pond would freeze over, my dad would drive us to the end of 82nd Street, and we'd all go walk, you know, through the cornfield and go ice skating on that pond. We did a lot of camping, even in our yard when the bus was parked in our yard, which was like an acre of land. We would have sleepovers, so I'd invite my friends, and we'd sleep in the bus overnight and do sleepovers. So there was always something going on at the Griffins, whether it was Julie and her friends sleeping over, or the boys, you know, and our friends.
I was going to ask you, on all these camping trips and everything, Julie participated in that as well?
Yes.
Now, tell me about music and your family.
Music became a big part of our family when, I don't remember the year, but the accordion was the instrument to play back in the 1970s. And so my brother and sister, Julie and Michael, they both took accordion lessons at the music center when it used to be on 52nd Street. And so my dad would bring me to go pick them up or drop them off for lessons. And so I became interested in drums. Well, so when I was about 12, my parents bought me my first drum set for Christmas. And so that's how I started as a drummer. But music became a big part. My brother Michael and I formed our own band and started playing for the Danish Brotherhood for parties and dances. And so my parents would drive us. And from that we got jobs at weddings and parties and dances. My parents were excellent dancers, and every Saturday night when we were at home, we'd camp out in the living room with our homemade pillows that my mom made us, and my parents would go to square dancing. And so Julie was the one that would babysit us, and a lot of times we got in trouble, but and caused a lot of trouble for Julie. But I learned quickly that if she sat on me and tickled me, I was done.
So there's been discussion of, there was some reference to some family history of depression. Were you familiar with any history of depression in your family? Did you ever see any evidence of depression in your family?
Never. No, I was not aware of anything.
So you had a happy childhood?
Yes, I'm very proud of my childhood, and I believe my brothers are too.
Can you tell me about the last time that you spoke to Julie before her death?
It was a few weeks before her death, and I was never a real big talk on the phone kind of guy, and being that you had to sit, you know, with a landline at that time, a lot of times Julie would talk to me and my wife at the time, Jill, and so we would share conversations, you know, she would talk to me for a while, then she'd talk to Jill.
Now, so in 1998, you were married to Jill?
Yes.
And how many children did you have at that time with Jill?
Three children, yeah.
And where did you and Jill live?
We lived in Pleasant Prairie on 39th Avenue and 93rd Street in a house that I built.
In a house that you built?
Yes.
And so how long a drive is that from where Mark and Julie lived?
It was about 3 miles, maybe.
So pretty close by.
Yes.
And tell us about visiting with the Jensens, with Mark and Julie, and with them visiting with you. How often would that occur?
We would get together on holidays, birthdays mainly, birthdays for the kids. And holidays were more for family. So Julie was busy with the Jensens a lot, and I was busy with my wife's family. So we didn't see each other as much on holidays.
So when's the last time that you saw Julie before she died?
I believe the last time would have been my son's birthday on August 25th.
Of 1998.
Yes,
And where did you celebrate your son's birthday?
at my house.
And Julie was there?
Yes.
And who was with her?
Mark, David, and Douglas.
And what was your perception of Julie when she was at your house for your son's birthday?
She was as normal, but I know at the time she was a little irritated because Mark was wrestling around with David, where the activity was focused on my son's birthday and opening presents, and so they were being a little distracting. Douglas was glued to Julie always. She was his comfort, and Douglas may have been 2 at the time, I'm guessing. But Douglas was a very quiet child, and he found comfort in always being by Julie. So I clearly remember Julie sitting on the couch and Douglas sitting on her lap.
So how did you hear that Julie had died?
It was in the evening of December. December 3rd. I got a call at my house from Todd Coster. That was Julie's brother-in-law. And he said, "Paul, I don't know how to tell you this, but Julie died."
So you'd last seen her in August and she seemed to be in perfect health.
Yes.
And then you hear she died. So what's the next thing you did after getting this information that your sister had died?
My wife and I went down to Julie's house, and the police wouldn't let us in there. So then we went to the Jensen's house.
The Jensens, you mean Dan and Florence Jensen's house?
Yes.
And what happened at Dan and Florence Jensen's house?
Well, we sat down, and we were just in shock and not knowing what happened and asking Mark what happened. And he was going over the details of the past few days. And
what did he tell you about the details of the previous 2 days?
He was saying that Julie had been sick and that she had been to the doctor, and he had said that he went to the doctor and got a prescription for her. And I don't recall which, but he mentioned Paxil and Ambien specifically.
And when he mentioned Paxil and Ambien, did he make any suggestion about the effect that those 2 drugs may have had on Julie?
Yes, he was saying that she was acting drunk.
And you recall how his father, Dan Jensen, reacted when Mark was telling you these things?
Yes, he was adamantly yelling at Mark, saying, "You can't say she was acting drunk, and you can't tell the police that." And he was very angry that Mark was using that description for Julie.
At some point, you came to suspect that Mark was responsible for Julie's death. Is that true?
Yes, I suspected him immediately.
After Julie's death, did you try to find out what had happened from the authorities?
Yes, I did. I tried contacting the medical examiner's office. And because my wife and I were interested in helping with David and Douglas and trying to maintain a relationship with them, I talked to Mark, and he urged me to call the medical examiner's office.
Did Mark tell you why he wanted you to call the medical examiner's office?
Well, for the same reason he was wanting to know what they determined as the cause of death for Julie.
At some point, did you speak with Detective Paul Ratzberg?
Yes. This was after I told my wife about my suspicions of Mark. And we got in a huge argument about it because she was not.
Objection, it appears this is going to go into hearsay.
Sustained.
So quite aside from the reaction that your wife had, did you talk to Paul Ratzberg?
Yes, I went and saw him.
And did Paul Ratzberg suggest to you that it might be a good idea to record some conversations with Mark Jensen?
Not after the first visit. It wasn't until after the second visit.
So after the second visit, at that time, has Paul Ratzberg suggested that you record phone conversations with Mark Jensen?
Yes.
And what was the purpose that you had in mind for agreeing to this, to record those phone conversations?
To determine exactly Julie's condition on the day before and the day of her death.
So your purpose in having these conversations was to elicit information from Mark Jensen, what he would say about those things?
Yes, I just wanted the truth.
And we have played some of those recordings for you and you just heard some of them recently. Is that true?
Yes.
And you heard your voice and Mark Jensen's voice on that phone call?
Yes.
I'd request that that I be allowed to play these portions of these phone calls in the presence of the jury, and it's the CD containing this information is State's Exhibit 73, and I'd move it into evidence, Your Honor.
All right, 73 will be played.
Now, as we're playing this, the transcript is going to be on the television, so I request you look at and read along as you're hearing this conversation.
Is the transcript marked as a separate exhibit?
It's all on 73.
It's all on 73. The transcript and the recordings are on 73. But we provided you with the transcripts, counsel.
I understand that. I just wanted to know if there was another number.
It's all in one.
So for the record, this is 0828, the time.
Yeah, I didn't even hear her talk Thursday. I mean, she was moving, but she was, man, I don't know how to describe it. Yeah, it makes sense too. Everything was like kind of wheezy. She was cognizant of what you're telling her. And you're trying to figure out what's going on with her, so I was asking her questions. And she kind of sat in bed, but she needed support. to do it. And I kind of sat behind her on the bed, supporting her when the kids came in and said, you know, good morning and everything to her. We were getting ready to go to school. Yeah, she was weak enough by Thursday. I doubt she would have been, you know, if she could have gotten in the bed, it would have been crawling. Okay. You know, she went to sleep. I came back and checked on her, and that was, she hadn't moved from when I had seen her in the morning till when we got home. Playing her that night. Right. Yeah. Basically same position. Yeah.
Okay, so stopping at 10:09.
So that was your voice and Mark Jensen's voice on the phone?
Yes.
And Mark Jensen was telling you that by Thursday, she was weak enough by Thursday. I doubt that she would have been, if she would have got out of bed, it would have been crawling.
Yes.
And then you had another conversation with him?
May I ask which date this is?
So the date of the first one was January 9th, 2000, and this one is February 24th, 2000. And so this one is starting at 6:47.
That's why I was just wondering if, you know, that was something that affected David or you know. Yeah. I'm not sure. I mean, I kind of doubt there would have. I don't think so because that was a Thursday. I mean, she was barely able to really even speak the other morning. Yeah, that's right. It was just, you know, I mean, she was sitting up in bed and I was supporting her. You know, it was, yeah. And then you get on the bus and took Doug. You know, I took Doug. Yeah, that's right. You had said she couldn't. Yeah, so I don't do anything. Right. The night before, that was, yeah, the night before was when I think, I'm trying to remember it all. Yeah, that was the night we had macaroni and cheese. We made that and I botched that real good. And she wasn't even awake much. I mean, she was in bed the whole time. I don't think, well, she was sleeping most of the time and the kids were being quiet to not wake her. Mm-hmm. I mean, there was some conversation that night, but she was pretty much out of it. Yeah. I don't think so. Okay. I don't think so, but, you know. Yeah, it just occurred to me and I thought, yeah, oh, you know.
So stopping that at 08:27.
And that was your voice and Mark Jensen's voice on the phone?
Yes.
You know, get back to your family history again. Do you recall going to your mother's funeral or the circumstance surrounding your mother's death?
Yes.
So can you tell us about when did your mother die, if you can recall?
My mother died, if I remember right, it was 1991.
And where was she when she died?
In Lake Placid, Florida.
And do you know how she died?
She died from complications from a swimming pool accident.
She basically drowned in a swimming pool, is that?
Yes.
And when you attended her funeral, do you recall seeing Julie there?
Yes.
And who did you go to the funeral with yourself?
I went with my wife, Jill.
And had you and your wife Jill suffered a loss earlier?
Yes.
Objection relevance.
Where are we going on this, Mr. Jensen?
There was a conversation at the funeral, and I want to hear his version of the conversation.
We'll allow it. Go ahead.
So Jill had just had a miscarriage,
Yes.
and did you talk with Julie about that?
Yes.
So Julie had learned about the miscarriage?
Yes. It was fresh news because it had just happened recently. And so we were very excited about having children. And so we had to break the news to my family that Jill had miscarried.
And this was very upsetting, difficult time for you.
Objection leading and relevance.
Why don't you just well, I said it was relevant, but why don't you rephrase the question?
So you just lost a baby and you just lost your mother.
Yes.
How were you feeling at that time?
I was very shocked first of all about my mother's death, and sad because, we had very high hopes in having children.
And did you and Julie have any conversation at your mother's funeral?
Yes.
And what did Julie say or offer at the funeral?
Julie offered to be a surrogate mother for us.
And other people were present when she made that offer?
Yes.
It was very touching.
It was extremely touching for my sister to offer that.
Do you remember when your father died?
Yes.
And when did your father die?
It was 1997.
And what was it that caused your father's death, if you can recall?
He had brain cancer.
Where was he living when this diagnosis occurred?
He was living in Florida by himself at the time he was diagnosed, but then he was in Eau Claire at the time of his death. He was being cared for by my oldest brother.
And do you recall, before going to stay with your brother, do you know where he was staying in Wisconsin?
He stayed with Julie for a while.
And after staying with Julie for a while, then he went and stayed with your brother?
Yes.
And then your father died from the brain cancer a short while later?
Yes.
Do you recall a time when Patrick was a teenager that he got upset about something?
Yes.
Tell the jury what you can remember about that incident.
My brother Patrick was, I believe he was 15 at the time. He, being a 15-year-old, had taken the car without permission, had driven, I think he was going to get a pizza from Pizza Hut, and it was a snowy night, and he slid on the curve of Cooper Road and slid the car off the road, and was found there by the police. He wasn't hurt, but he was in big trouble with my father, so he got grounded.
And Patrick did not respond well to being grounded for taking a car without permission and sliding it into a ditch?
No, and as an act of rebellion, Patrick.
Objection, Your Honor. I believe the statement as an act of rebellion calls for speculation on what the thought process of his brother was.
Why don't you just rephrase or ask another question?
Well, did Patrick ever talk to you about this incident?
Afterward, yes.
So at the time, after he'd been grounded by his father, what did Patrick do?
He supposedly tried to slit his wrists.
And what did he do after he'd cut his wrist?
I don't really recall.
Well, did he seek medical attention or tell somebody about it?
Objection, if he doesn't recall, he doesn't recall.
Overrule, let's answer the question.
I don't know exactly how he was found or what happened at that point.
That was something he did in response to being grounded at the age of 15.
Yes, it was, as Patrick told me, it was a way of,
Objection, hearsay.
Sustained.
So tell me this, did anybody else in your family ever talk about or commit suicide?
no,
Did you ever hear Julie say anything about suicide?
no,
Julie never talked to you about committing suicide.
never.
Tell me about the kind of relationship that existed between your sister Julie and your wife Jill.
They talked about a lot of girl stuff a lot. They talked about kids a lot.
Objection calls for hearsay.
Your Honor, the statements that Julie made are all admissible. There's no hearsay objection because of the Jensen 2 decision. It said all of her statements are admissible. There's no hearsay objection that applies because of the forfeiture doctrine that exists in the state of
Your
Wisconsin
Honor,
for
if we should-
non-testimonial
I believe we have a
statements.
speaking objection here. If the court would like to take further argument, we can do that outside the presence of the jury.
To overrule the objection, let's just get to the question, Mr. Jambois.
Could you read the last question back, please? So what else did they talk about, if you can recall?
And again, objection hearsay, as this is not a conversation that Mr. Griffin had with Ms. Jensen. It is a conversation relayed to him by his wife, which makes it hearsay.
We don't know that. He didn't say that.
Why don't you ask the question?
So did you ever listen or hear your wife Jill talking with your sister Julie?
Yes.
And what kind of things did you hear them talking about?
They talked about a lot of things. They did talk about Julie's unhappiness with Mark in some of his behavior because he was traveling a lot. He was staying overnight, like in Chicago when he could be home with the family, and he was always out, always gone, and drinking a lot, talking
Julie-
about getting drunk on business trips.
So Julie was complaining to Jill about Mark, and you heard these conversations.
Yes. And Julie did tell me some of this to me as well.
At some point, you learned that your mother was an alcoholic. Is that true?
Yes.
And when did you first learn that your mother was an alcoholic?
I didn't know that my mom had a drinking problem until Julie's wedding. It was the rehearsal dinner before Julie's wedding.
And what happened at the rehearsal dinner?
My mother passed out, like just unexpectedly, and had to be taken away by ambulance.
So how old were you at your mother's or at your sister's wedding?
I was probably 22 or so.
Now, and when did you leave home?
I left home at 18.
So from the time of birth through the age of 18, you lived in your mother's home.
Yes.
You had contact with her on a daily basis.
Yes.
And do you recall now, as an adult looking back, ever witnessing any incident where your mother appeared to be intoxicated?
No.
So you never had any inkling as you were growing up that your mother had a problem with alcohol?
No.
And you didn't learn about this until Julie's wedding?
Correct.
Did you and Julie ever talk about your mom's alcoholism?
We did, yes. After her wedding, Julie would attend Alcohol Anonymous meetings and learn, so that she wanted to help our mother to overcome the problem. So Julie would attend and learn things and learn what to try to do to help my mom.
To support her, but not enable her.
Yes.
Did you ever visit the residence of Mark and Julie Jensen?
Yes.
Did you ever see an office or a den in that residence?
Yes.
And who showed you that office or den?
I remember Mark showing us after they had done some remodeling and they had done some wallpapering. Julie and Mark were, they did a lot of house projects, and Julie was always good with decorating and organizing.
Now, during the time that you and Julie, did you ever know her to be a smoker?
No.
She did not smoke.
No, never.
What about Mark? Was he a smoker?
Yes.
What did he smoke?
He smoked cigarettes and cigars, I believe.
Did you see any cigars or evidence of cigar smoking when you were at their residence?
Yes, he had a humidor in his office.
That was his office?
Yes.
What else was in his office that you can recall?
A computer, other than bookshelves and decorations, a desk.
Now, where were you employed in where were you employed in the 1990s?
I was employed by Snap-on Tools.
And what did you do for Snap-on Tools?
I was a mechanical design engineer.
What sort of things did you design at Snap-on Tools?
Power tools. I worked for the power tool division I think from 1994, I moved from the manufacturing engineering offices to the product design offices.
So in your course of work at Snap-on, did you have a computer at your office?
Yes.
And you knew how to use computers?
Yes.
Did you send and receive emails when you were at Snap-on Tools?
Yes. I don't remember the exact time when email became the mode of communication rather than office memos, but yeah, it happened sometime around then.
Did you ever send an email to Julie?
No.
Did you ever receive an email from Julie?
No.
Did you know if Julie had an email address?
No. Julie was a letter writer. She wrote beautiful letters by hand.
Were you aware of, or did you ever see the license plate that Julie had in her car?
Yes.
What was the license plate?
It says my 3Ds.
And Your Honor, that for purposes of marking exhibit, that's part of State's Exhibit S73. We're going to display the license plate and ask you to identify it.
Yes, I still have it.
That's the license plate that Julie had on her car,
Yes.
and it's My 3Ds. What does My 3Ds stand for?
My 3Ds stands for David, Douglas, and Daddy, which was Mark. And those were the things that Julie was proud of.
The centers of her universe.
Yes.
After Julie's death, did you continue to have contact with Mark Jensen?
Yes.
Do you know when David's birthday is?
Yes, January 21st.
And you said that you get together as a family for birthdays.
Yes.
Did you get together, did you as a family get together with Mark Jensen and David on David's birthday?
Yes, it was at the Jensen house.
And this is January of 1999?
Yes.
His birthday was January 21st?
Mm-hmm.
Yes?
Yes.
So on or around January 21st, 1999, you got together with Mark Jensen at Mark Jensen's residence.
Yes.
And who did you go to the house with?
Jill and I went to the house.
So your children didn't come with you?
Yes, I believe they did. Yes.
So it was Jill, yourself, and your 3 children?
At the time, it was probably my 2 children. Yeah.
2 children?
Yeah.
Okay. And who was at Mark Jensen's residence?
Well, there were a lot of kids there, friends of David's, of course. And there was a babysitter, I don't recall her name, who we knew because we were in contact with them and tried to maintain contact with David and Douglas as much as possible. And Kelly Labonte was also there.
So on January 21st, 1999, or thereabouts, within a day or two of January 21st, 1999, Kelly Labonte was introduced to you?
Yes.
Had you ever seen her or met her before?
No, that was the first time.
And who introduced you to Kelly Labonte?
Mark.
And how did he describe Kelly Labonte when he introduced you to her?
He said she was a friend from work.
Did you make any observations about Kelly Labonte while you were at the residence on
Yes.
January 21st? What observations did you make about Kelly Labonte?
She was very familiar and very comfortable with the house, including the master bedroom. And she was also very bossy to the kids. And I remember I was irritated by that, just feeling like someone has replaced my sister.
I move State's Exhibit 73 into evidence, subject to cross-examination.
All right, subject to the cross, 73 will come in.
I have no further questions of Mr.
Who's
Griffin.
doing the cross?
That would be me, Your Honor.
Go ahead.
I have no questions.
All right, you're excused. Thank you.
All right, that was a smart move. Smart move by the defense. That was some kind of damaging testimony, I believe. The jury had to have felt all of that. And they are probably not looking at Mark very good. Normally, chat, like I said, we don't normally stream these trials, but sometimes these big trials that happen out here in Wisconsin where I live, I am in the courthouse and typically am on a friend stream and kind of providing background details, inside scoops about what's happening in the courthouse, how the jury's reacting to testimonies. This case, we're not there, unfortunately, but we are really breaking
It's
this
number
case
70
down.
on the witness list.
Thank you.
That's why we're live streaming this. We're doing some serious breakdowns. But during the Brooks trial, my close friend Andrew Mercado from Mercado Media, check out his channel. He does a lot of really killer coverage on the Ukraine-Russia situation that's going on. Every day he's going live. He's been doing some serious live streams about that issue. Check him out. He's a good friend of ours. But he was live streaming the Brooks trial, and I was in court and giving him the inside juice about what was happening in the courtroom that you guys couldn't see. I was in the media room and kind of giving a lot of background details about what was happening down there. We got Dave Thompson coming up. Dave Thompson is the jailhouse snitch that claims that him and Mark conspired to kidnap Ed Klug. But a lot of other people have testified that Dave Thompson was beating Mark Jensen's butt in jail and extorting him for money. This is going to be another witness that the defense is going to have to destroy on that stand to create serious doubt for this jury that's here. I'm not personally sure if the defense destroyed Aaron Dillard like they've done with some of these other witnesses. I'm not sure they pushed hard enough. I don't know if they really put a lot of doubt in that jury's mind. What do you guys think?
We'll need to take a short recess. Mr. Thompson is across the. It'll be probably 5-10 minutes before he gets here.
You don't have another witness available?
He's the next witness, Your Honor, is David Thompson. We
5
don't have
minutes?
another witness sitting out there, no.
You say 5 minutes he'll be here?
Yes, he's in the DA's office. We just need to bring him across. Might be less than that. If you want to just wait for him, we can.
Taking the long way around, or?
I think he probably is taking the long way.
Yeah,
around.
he's got to go through
Yeah,
security.
he's got to go through security.
So,
He can't take the same way I do, so.
all right, you guys can stand up, relax if you want. We'll just wait out a few minutes.
Bobby boy, well, he can't take the same way I do. Why not, Bobby?
Anyways.
That's your best friend. It's your best friend. That's your dealer, Bobby boy. Anyway, chat, I'm so glad you guys are here. We do obviously have a lot of new people on YouTube watching. Welcome to the stream, everybody. Don't be scared to chat. We have a good community over here. Everybody's super friendly. You don't have to lurk in the shadows. Come say hi, introduce yourself. Welcome. Chat away. If you have some theories, put them out there. If there's things that stand out to you, put it out in the chat. Let us hear it. We're kind of convinced about our theory over here, but there's still some things that are kind of in the Mark's guilty column. We're trying to break it all down. We're trying to pay attention to the evidence. We're trying to solve the case. What happened? Now, we did mention that at the end of this trial that we were going to kind of all get together, do a stream while the jury's deliberating, kind of get in here and pretend we're all jury members. And, you know, everybody puts their little comments and what they think and this piece of evidence and that piece of evidence. But one of our viewers suggested that we do something even cooler with that, chat. And I loved the idea. So I think what we're going to do, and I got to figure out how many people we can bring up on the stream at one time. But I think what we're going to do is once the state rests, okay, their case in chief, we're going to try to bring 11 of you on the chat, right, on the actual stream. We'll send you the link. You don't have to turn your video camera on, so you can still remain anonymous. That's fine. But we'll try to get 11 of you. I'm not sure if we can fit all that many. So
Sir, remain standing. Raise your right hand. I will swear you in.
However many
Raise
we
your
can
right hand and
fit,
face me.
we're going to do
Solemnly swear
a
the testimony is meant to be
kind
the
of
truth,
jury
whole truth,
deliberation.
nothing but the truth, so help you God? Yes. Thank you. Get as close as you can to the microphone. Spell your first and last name for the reporter.
David Thompson, DAVID,
All right, who's doing the direct?
I am.
Go ahead, Mr. Jones.
Good morning, Mr. Thompson.
Morning.
Do you recall there was a time that you were locked up in the county jail with a guy by the name of Mark Jensen?
Yes.
Do you see Mark Jensen anywhere in this courtroom today?
Yes.
Could you point to him, describe what he's wearing?
He has on a gray or black suit, a blue shirt, and a mixed color tie,
I
glasses.
request the record show the witness identified the defendant.
Mr. Thompson has identified Mr. Jensen in open court.
So was there a time that you were locked up with Mr. Thompson or with Mr. Jensen in the same jail?
Yes.
And do you remember when that was?
2007.
And when you first arrived at the jail, was Mr. Jensen already there, or were you there first?
He was there first.
And what were you doing in the county jail?
I was in the county jail at that time for bank robbery.
And were you charged state or federal?
Federal.
So can you tell the jury why a federal prisoner is in the county jail?
They had a contract with the state jail to house federal inmates.
And so I guess we're going to get around this. Have you ever been convicted of a crime, sir?
Yes.
How many times have you been convicted?
10.
And this was one of those episodes in your prior criminal history.
Yes.
And so tell me, when you first saw Mark Jensen, what kind of contact, if any, that you can recall having with him?
When I first met Mark, he was kind of standoffish, I guess because according to what was going on with his case at the time. But after about 2 or 3 days, I started talking to him, and he, finally warmed up to me. And we carried on conversations on a daily basis. He made phone calls for me. I made phone calls for him.
So he made phone calls for you. how did you get him to make phone calls for you?
Oh, well, I asked him the first couple of times that I asked him, he wouldn't do it. Then I like the third time he relented and made a call for me.
So what happened between the first, second, and third time that caused him to change his mind?
We had a little altercation, and afterwards I apologized to him about it, and from therefore we just became, kind of cool.
So tell me about this little altercation that you had with him.
He had promised to make a phone call for me, and then I'm kind of like was mad because he didn't do it, and I ended up shoving him. And then I felt like, okay, well, I shouldn't have shoved him because he didn't make the phone call for me, so I wouldn't apologize to him.
And after that, he then made a phone call for you.
Yes.
Now tell me, did anything else change about your relationship after he made the phone call for you?
Yes, like he opened up more. We became kind of closer. We would talk every day, drink coffee together every morning. Read the newspaper and talk in the corner, and just off to ourselves, just indulging in regular everyday conversation.
No, there's kind of a hierarchy in a prison and a jail, isn't there, among the inmates?
Yeah, to some degree, yes.
And where do bank robbers fit in that hierarchy?
That's a good question. I would guess somewhere in the middle, I would assume.
So, I mean, if you're going to be in for a kind of a crime, well, bank robbery is better than, say, retail theft, right?
Absolutely.
But where does murder fit in the hierarchy of things?
Murder puts you right at the top.
So Mr. Jensen was kind of higher than you in the hierarchy of things because he was in for murder at the time.
Total celebrity.
So at the time that you were there as a federal inmate, you were looking at some potentially pretty serious time for bank robbery, right?
Yes.
And at some point, did you come to think that, well, gee, maybe I can use Mr. Jensen to benefit me some way in my case?
To some degree, sort of.
So when did that first come to your mind?
Mark had approached me about his co-defendant, and
a co-defendant. Did you tell you what the person's? Mark doesn't actually have a co-defendant.
Mr. Klug. He had approached. He said that Mr. Klug was going to testify against him, and he asked me. He said, "Well, I don't really want him to come to court, and he approached me with the idea like, man, what could I do to keep him from coming to court?" And that kind of, piqued my interest because I wanted to see, was he really serious about this or was he just blowing off some hot air? So as he kept talking about it, I said, well,
let's stop for a moment. So
okay.
let's start at the beginning of this conversation about Ed Klug. When he was talking with you about Ed Klug, where were you and he located?
We were here in the Kenosha County Jail on J Unit.
In the J, and did you say J Unit?
Yeah, Kenosha County Jail here, yeah.
Okay. And when he was talking to you about Ed Klug, where were you inside that unit? Were in relation to the other inmates? Were you two off by yourself?
Yeah, we would be back by his cell because he had a corner cell in the back, so we would most times be back there.
By his corner cell?
Yes.
Would you go inside his cell, or would you be out?
I have gone inside his cell before and looked at some of his newspaper articles and through some of the paperwork that he showed me.
So you'd go into his cell for him to show you things.
Yeah.
And what are the things that you remember him showing you?
Just some of the newspaper articles where it said that he had killed his wife, and some court papers that he said, he was really, adamant about that he hadn't done it at first, and he really wouldn't talk too much to go into great detail about it, but just the fact that he was just charged with it and had been fighting it for a while.
And when did he first start talking to you about Ed Klug?
It was about the 5th or 6th day that I was there, because he was that seemed to be the only thing that troubled him was the fact that this guy was going to come testify against him.
So during the whole time that you were there, this 5 or 6 days that you'd been there with him, was there anything else he complained about with respect to his case aside from Ed Klug?
No, mostly just Ed, though. He said that was going to be the thorn in his side.
He said Ed Klug would be the thorn in his side.
Yes.
And That's when he started talking to you about Ed Klug. So what did he say about Ed Klug?
Said that he didn't want him to come to court, and that there was some way that he could keep him from showing up.
He was asking you that, if there was some
Yeah.
way to keep him from showing up.
Right. And at that point, I said, well, let me really see how far he's willing to go with this. So I asked him, I said, well, probably can make that happen for you for the right price.
Now, at the time that you were making this offer, you didn't really actually have any intention of trying to do anything to make Ed Klug disappear.
No, not at all. I was too busy focusing on my own case, but I just really was piqued by what he was saying.
So when you said, you can make it happen for the right price, what did Mr. Jensen ask you or say to you?
Oh, well, how much?
And when he asked you how much, what did you say to him?
I just gave him a roundabout answer. I said, well, man, $1,000. Just to see what he would say, see what he was, if he would bite that, if he was really serious.
So when you said $1,000, what did he say?
He said, that's kind of low, but I can do that.
And then what happened?
So I got on the phone and I called my girlfriend at the time, and I told her, I said, I'm gonna have Mark call you, and when he gets on the phone, I want you to tell him that everything is as planned.
Now, before you had that conversation with your wife, tell us more about the conversation that you had with Mark Jensen. I mean, did you tell him how you were going to make Ed Klug disappear for $1,000?
Well, he first of all, he gave me the information on where Mr. Klug's business was at the time, which was up by Alberton, somewhere like in Kimberly maybe, and gave me his name. Yeah.
So let me ask the question then. So tell the jury what Mr. Jensen told you about the whereabouts of Ed Klug.
He told me that he lived in Alberton, that he wanted him to disappear.
And did he tell you specifically where he lived in the Appleton area?
Well, I had my fiance look up the address where it was at, and it was precisely what Mark said it was. Just yeah.
And did he tell you where it was?
Well, I can't recall exactly, but I knew it was in Appleton.
Okay, and then after he gave you that information, did you give him any information about how you could make Ed Klug disappear?
Yeah, I told him I could have someone kidnap him and sell him until court days were over with.
And did you tell him who you would need to talk to on the outside in order to facilitate that?
Well, I told him I would have to call Kim so that we could get the money transaction taken care of first, and then I didn't specifically tell him who I would have do it though.
Okay. So did you tell him how this money was to transfer hands, and exactly what the payment agreement would be?
Yeah, I told him that my Kim would talk to his mom, and they would make the transaction outside there, and he would give me half of the money first, and then half of it once it was over, once the court proceedings were over with.
So he's going to give you $500 down and $500 upon completion.
Yeah, well, like $575 and $425. Yeah.
Okay, so it was actually not an even number, 5 and 5. It was.
Well, yeah, that's kind of like what he said she was able to get at that time.
Was how much that she could get at that time?
The $575.
$575 is what he told you his mother could get at that time?
Right.
So it's $575 up front, then $425 later?
Yes.
And that's the conversation that you had with Mark Jensen in the cell.
Yes.
And then how did you facilitate talking to your wife about that? Was Kim your wife at that time?
No, she was just my daughter's mom.
So she was your daughter's mother.
Yeah.
And so she was the woman that was prominent or connected to you in your life at that time.
Yes.
Your significant other, as a saying.
Yes.
And so did you tell Mark that you would need to talk to Kim about this?
Yes.
And did he tell you how Kim would be able to get the money?
Yes, he told me that she would have to go pick it up from his mom's house.
And so what's the next thing that happened after you and Mark had this conversation?
Well, I got on the phone and I called Kim and I explained to her what was going on, and she was kind of bewildered by it all. And I said, well, just go along with what I'm telling you to do. And when he gets on the phone, tell him exactly what I told you, and he goes and see what his response is. So I told her to tell him that everything would be as planned.
And she didn't really know what you were talking about, did she?
No, she didn't have a clue as to what I was talking about.
And these phone calls from the jail, were you aware that they were subject to monitoring and recording?
I was aware of it, but for what I was in there charged with, I didn't think that they would still be listening part for me to be talking about this Mark and stuff. You know,
Yeah,
thought they were just concerned about the bank robberies.
yeah. But you learned later that
Yeah,
we were listening.
I know better now. Yeah.
You know better now. Do you recall these calls being preceded by a recorded message saying this phone call is subject to monitoring and recording?
You know, when you have greed on your mind, you overlook those things.
Okay. But when you talked to Kim, you didn't tell her exactly what the plan was.
No.
What you told her is what she needed to know in order to fill out her part of the plan.
Absolutely, yeah. Just enough for her to do what was necessary.
And so she was supposed to say something to Mark?
Yeah, she was supposed to. The only thing she was supposed to say was, you know, when he got on the phone, he said his name. She said, "Yes, I'm Kim," and everything is as planned. And he passed the phone back to me.
And would you recognize your voice and Mark Jensen's voice? You heard that phone call again?
Oh yeah, absolutely.
I request that we be allowed to play this recording. It's Exhibit S74, Your Honor.
74?
And I'd move S74 into evidence subject to cross-examination.
Subject cross, it'll be received.
Phone calls. So this, I'm going to ask you to listen. There's going to be a transcript displayed on the screen, so you can look at the screen, whichever one is easier for you to read.
This is from 9/11/07 and starting at 3 minutes and 23 seconds.
Yeah, I hear you. It's Edward. You hear me? Edward. Klug. K-L-U-G. Stifle Nickelman. S-T-I-F-E-L. N-I-C-O. L-A-N-D. 740 4th Street. Kimberly, Wisconsin. What street? 4. Your car? Yeah. Kimberly, Wisconsin. Okay, so I'm confused now. Just keep that. It'll all make sense once you get it out of it. Are these two? No, it's the same person. That's just the name of the company. It's Stifle Nickel. And I keep spelling the name again. N-I-C-O. L-A-N-D. It's Nickelman, right? Huh? Oh, Nicholas. N-I-C-O-L-A-U-O. N-I-C-O-L-A-U-S. Nicholas. N-I-C-A-L-O-S. N-I-C-O. L-A-U-S. And the address in the place after that. Okay. Now the first name I gave you, see if you can go online and get that address and phone number. Okay. All right. And I'll call you back later on and see what's happening with that.
Whose voices were that you heard, just that the jury just heard now?
Yeah, myself and Kim.
Yourself and Kim. Now, at the time that you were talking to Kim and directing your attention to the screen up there, you give this, you say Stifle Nickland, 740 Ford Street, Kimberly, Wisconsin, correct?
Yes.
Now, where did you get that information about Stifle Nickland, 740 Ford Street, Kimberly, Wisconsin?
From Mark.
And then while you were giving this information to Kimberly, somebody corrected you that it wasn't Nicoland, it was Nicholas.
Yeah, it was Mark in the background.
So Mark was telling the background, Stifle Nicholas.
Yes.
So now I'm going to go to the next phone call that occurred between that we want the jury to hear.
So for the record, the first one ended at 0544. And this is also from 9/11/07, and starting this one at 32 seconds.
Hi. Excuse me, you reached Kim?
Yeah, I know that.
Oh, okay.
What do you read out to?
Elmo just came on.
Hey, listen. Hey, you remember the old lady that called you the other day?
Yeah.
She gonna call you to come pick up this money.
To come pick up some money?
Yeah, $500.
Excuse me?
Yeah, $500.
For?
Ask no questions, I'll tell you no lies. You there?
I'm here.
Oh, okay. So, but I was listening on there, you can do it right. Hear me?
Yes.
I'm gonna put somebody on the phone, right? Hear me?
Yes, David.
And all you have to say is, everything is as planned. Hear me?
Say it again.
Everything is as planned. You got it?
That's what I say to her?
No. To him.
Oh.
Okay.
Okay.
All right, hold on. Hello?
Hello.
Hi.
Hey. Everything is planned.
Okay.
Okay?
Sounds good. Let's go.
Yeah.
Thank you. Sounds good.
Alrighty.
Okay, appreciate it.
Okay.
Okay. Thanks.
Yep.
Here's it.
Thanks.
Yeah, so, you probably get a call sometime today to go let you know where we'll get it at.
Okay.
All right?
Yep.
You talk to Mom yet?
No, I called, nobody answered.
Try again real quick.
Okay, so that stopped at 0335.
Now, with respect to that phone conversation, it seemed to me, and you tell me if this is true or not, that you were speaking rather quietly when you were talking to Kim. Is that true?
Yes.
And why is it you were speaking so softly to Kim?
I didn't want anyone to overhear my conversation.
And was there one person in particular that you didn't want to overhear that conversation?
Yeah, Mark.
You didn't want Mark to overhear that
I
conversation.
didn't want her to realize that I was, setting this all up as a plot just to get the money.
So, but then Mark got on the phone,
Yeah.
and you were right there is when Mark got on the phone.
Yes.
And when he got the phone, did he seem excited about it?
Absolutely, very excited.
So what's the next conversation that you had then? We're actually going to play it for you now, and I'll ask you some questions about it.
Okay, so this is starting at 14:58.
Morning.
So you don't have any money now, do you?
Little. What you need?
I don't need it. I was just, just kind of got this one call up on the phone. But, we gonna be trying to, once that way, whatever you do, your call, then you got to pick that up. That'll be, 500.
Yeah. Again, confusing to me, but okay.
He one of them people.
So in this conversation, you're again talking to Kim, and she really has no idea what you're talking about.
No.
Except that at some point, she's supposed to go pick up $500 from somebody.
Absolutely, yes.
So what's the next phone call?
And for the record, that one stopped at 15:34. And that one was also from 9/11/07. The next one is from 9/12/07. And this is starting at 06:57.
Listen.
Yeah.
Dude's mother called me today. Wants to know what I wanted.
The $500.
But wouldn't she already know that?
No, because he just let flat out tell her. Why did you
I said, I'm not exactly sure. I said, I'm expecting a phone call from my husband later. I said, let me call you back.
Right.
So she's just going to say from us that a stranger's just going to say to her, I need this, and she's going to give that to me.
Tell her that that's what Mark was talking about.
Okay.
See, you know now, you see the name now?
Yeah.
Okay.
Yeah, I did.
Right.
And stopping that at 07:53.
So by that time, Kim told you that Mark Jensen's mother had called her,
Yes.
and she had asked what it was that Kim wanted,
Yes.
and Kim didn't know what she was supposed to say in response to that question.
No, she didn't know. She seems to have forgotten what she was supposed to do.
Well, because you're being kind of mysterious with Kim, weren't you?
Actually, I was trying to be mysterious with Kim and with the recording of the phone call.
Okay, could you please start to speak into the microphone, sir?
So I was trying to be mysterious with Kim and with the recording of the phone call. I was trying to crack some type of code where everything wouldn't all be blurted out at once,
Because by this time you'd figured out somebody was listening, possibly.
Yeah, they still was listening, talking about for more bank robberies, but it never happened.
So now on September 12th, this conversation just occurred. And did you and Mark have further conversations after that call?
Oh yeah, we definitely had a lot of conversations after that.
So tell us about the conversations that were going on between you and Mark Jensen and interspersed between these phone calls.
Well, for one, like when he first found out that this would go through with Mr. Klug, you know, he was ecstatic about it. You know, I guess he figured that would be the end to his troubles as far as the cases he was facing. But what he didn't know is that I had sent Kim a letter telling her to contact my lawyer and give him this information that this guy was plotting to have this guy kidnapped.
So you were asking Kim to reach out to your lawyer?
Yeah, I sent her a letter in the mail.
Oh, so you mailed it to her. You didn't
explaining everything to her. Yeah.
You didn't talk to her about over the phone about it. You sent her a letter.
Yes.
And what did you write in your letter to Kim?
I told her to contact the proper authorities, you know, about this Mark Jensen guy and see how far he's willing to take this, what he's talking about. And she did so. Well, actually, they did so from here. They contacted my attorney themselves from the jail here.
So then you talked to your attorney about it.
Yeah, I talked to my attorney. My attorney asked him, said, "What are you doing? You're gonna get yourself hooked up on some other stuff. You need to stop it."
And then you explained to your attorney what you were doing and why you were doing it.
Yes.
Now, at some point, you left the jail. You were taken out of the jail and moved for another court appearance, correct?
Yeah. When
And
I can't. Yes, go ahead.
When you came back from the court appearance, you were put in a different cell block. Is that true?
Yes.
And where was that cell block in relation to the cell block that you had previously shared with Mark Jensen?
Right next door.
And what separated the new cell block from the previous cell block?
Just a glass window.
And what was on the other side of the glass window? Was it like a hallway or a guard booth, or what was
There
it?
was a guard booth in between the two cell blocks.
So the two cell blocks were separated by two panes of glass with a guard booth in between?
Yes.
So when you got back from your court appearance, how were you able to communicate with Mark Jensen?
Well, once you go to the back of the cell block, the room kind of curves in to a point, so the windows get closer and closer together. And we wrote notes. We wrote on paper, wrote notes, and we pressed them against the glass. And I would read his, and he would read mine.
Is that unusual for inmates to communicate with each other in this fashion between the two cell blocks?
Well, yeah, if you don't want to yell and scream, have everyone knowing what you're talking about, absolutely.
So this was a common thing.
Yeah.
Okay. So you didn't want to yell and scream to Mark Jensen. You wanted to communicate to him in a quieter fashion.
Yes.
And so you held up some notes,
Mm-hmm.
and he held up some notes.
Yes.
I'm going to show you a note, and you tell me what it is. All from part of Exhibit 74, Your Honor. Okay, so whose note is this? Is this your note or his note?
That's his note.
And I'm going to move up closer so I can read this better. So he wrote, talked to my dad this AM, hadn't been able to get them all day, question mark, question mark, question mark. That's what Mark wrote to you?
Yes.
And then you wrote something back?
Yes.
And then he wrote to you, my dad said, I got to move closer. I can't read it. Oh, it's on. Oh, I'll read on your screen. That's what I'll do here. My dad's. My dad said they got a call this AM, question mark. And questioning calls from Kim's number. Don't know who it, don't know who, question mark. And then if I understood right, that's why I was trying to get them to clarify if they knew more. They seemed upset. So those were Mark's messages to you?
Yes.
And you couldn't ask him to clarify it any because he was in that other cell block.
Yes.
And then he wrote, could somebody be watching that phone? So he was talking about the phone in the jail.
Yes.
And when he asked that question, could somebody be watching that phone? Did you put up a message for him in response?
I believe I did. I'm not quite sure. Yeah, I'm pretty sure I did.
But you don't remember what the message was?
No.
Now, this is your message to him. Is that your handwriting?
Yes, it is.
And you wrote, when I call Kim, we'll say all is as it should be. So that's what Kim was supposed to say?
Yes.
That's what Kim was supposed to say to their parents, to his parents?
She was supposed to say that to Mark.
Okay. And then you write, they called Kim down to the station asking her if I did any more crimes. They think I've done more banks and some other bullshit. That's what you wrote to Mark?
Yes.
But then you write, but I came clean when they first questioned me. There isn't anything else. Correct?
Yes.
And you were talking about what you told the authorities when they first arrested you for your bank robbery.
Yes.
Then you wrote, but handling things okay for a change. Do you know what that was about?
Yeah, I was just, getting comfortable in my situation because I had a pretty hard time with, accepting that I was going to be away from my daughter for a while.
But then you write, but it is a must. What was that about?
That was in reference to what Mark had said on the phone about Mr. Klug.
So, but it is a must. That is a must you must get rid of Ed Klug.
No, a must that we must turn this in.
Oh, okay. Okay, this note was to Mark Jensen.
Hold on, wait. Oh, yeah. That's the Mark. I'm sorry.
So this note to Mark Jensen, but it is a must. What were you talking about? If you can recall.
I can't really call what that statement right there was on. What is a must? So I can't really recall what that statement there is about, but
Okay, so then we'll go to the next statement.
Okay.
Let me know after your visit, son. I'm going to call Kim now. So what you were asking Mark to let you know about his visit on Sunday, and I'm going to call Kim now?
Right, yeah, he was supposed to talk to his parents about the money.
On Sunday.
Yeah.
And then there's a question, can't mom drop it off? And that was your message to Mark?
Yeah, I was asking him, could his mother drop the money off to Kim?
And how did he reply, if you can recall?
I think he said she'd be unable to do that.
And then you replied, that's all good. Who drops it off doesn't matter.
Right.
And then you ask, can Kim come pick up the $575 from mom tomorrow?
Yes.
And do you recall how Mark responded to that?
Well, he said he had to call her and talk to him first.
So then you
sure it
wrote,
would be okay.
can Kim call her now for the money, $575? Correct?
Yes.
That's your note to Mark.
Yes.
And do you recall how Mark responded to that?
No, I'm not sure. I'd have to see the message in timeline.
Okay. And then there's this message, don't forget to tell mom to leave me the $30.
Yeah, I had asked Mark to borrow me some money, and he said that he would go on his visit Sunday and ask his mom.
So you wrote to him, I hate to burden you, but do you think mom could leave me $30 for stamps, soap, toothpaste, and deodorant lotion?
Yes.
And then you indicate David Thompson, 4199 K5, can leave it tomorrow?
Yes.
Was how much more direct do we have?
I would say maybe, what, 10 minutes, 10 to 15 minutes, Your Honor?
Can we last another 10, 15 minutes? All right. And then we'll take our lunch break.
This, do you see this note? It says, after lunch, let's work on this guide sheet, work on guide sheet after lunch. Do you know who that was? Was that your note? And who was it being sent to or directed at?
That was directed at another federal inmate because at the time that I came in, I wasn't aware of how they did their sentencing. So I had the federal guideline sentencing sheet that I wanted to go over with this other young man.
And he was in the same cell block as Mark Jensen?
Yes.
So you had to communicate also with him via the glass, using
Yes.
notes on the glass. And then the question, how long will it take or how long he be kept? That's your call. I mean, he's asking how long will it take or how long will he be kept? Question mark. Was that the question mark that
Yes.
the question that Mark had posed to you?
Yes, it is.
And you replied, that's your call?
Yes.
And then you write 2 weeks is cool, but he can be made to leave town or made to sign an affidavit saying he totally lied on you. And so those were options that you were giving him?
Yes.
And how did Mark respond to that?
He was very open to that.
And then you write, this is all for you. So whatever you want done will be done. Is that
Yes.
what you wrote to him?
Yes.
And did he reply to that?
Yes, he was okay with that.
And then you wrote, it's all good. No tongue will keep him from ever saying anything. Oh, it's all good. No tongue will keep him from saying anything. You know, this case has no statute of limitations. That's what you wrote to him?
Yes.
And then you write, getting the job done is what he does best.
Yes.
So you're referring to this outside person.
Yeah, this fictitious person. Yeah, he never existed. Yeah.
So when you're talking about removing Ed Klug's tongue in that preceding statement, you weren't actually contemplating having somebody take out Ed Klug's tongue.
No, I just wanted to make it sound good for Mark. That's all.
So when you talked about him, no tongue will keep him from ever saying anything. How did Mark respond to that, if you can recall?
Oh, he was happy about that. He didn't want this guy to testify at all. He didn't want him anywhere in the picture.
So then you write, trust me, Mark, come October 8th, you'll just have about your old life back. Correct?
Yes.
Or you'll just about have your old life back. Now, what was going on October 8th, if you knew?
I'm not sure what was going on that day, but I think it was pretty close to one of his court appearances, and I was just trying to reassure him that, this guy wouldn't be showing up.
And then you write, I'll be here for at least 2 months, but I know this process won't have to be done again. That's what you wrote?
Yes.
And how did Mark respond to that?
Again, he was very ecstatic about that as well.
Then you wrote, he won't, exclamation point. So what does he won't mean? What were you responding to something that Mark Jensen had written?
Yeah, I was saying that he absolutely won't be around to testify.
And then you write, his life depends on it, but like said, to eliminate that possibility, there's always plan B. Correct?
Yes.
And what was plan B?
Plan B was to totally get him out of the picture, just get rid of him.
Just kill Ed Klug.
Yeah.
And how did Mark respond to that?
Again, he was okay with that. He was happy about that as well.
He just didn't want Ed Klug to testify. He didn't care how that happened.
Yeah, he didn't care. He just didn't want him to come to court. Yeah.
Now, were you present when Mark Jensen made phone calls to other persons in order to help carry out this plan?
I'm not sure because I didn't really overhear any of his phone calls.
So you don't know whether he called his wife to ask her to give $500 to his parents twice?
Well, he was supposed to do that. We had agreed that he would somehow get the money, right? And he said that his wife would be upset with the idea of being involved in anything like that, but it was more sufficient for his mom to do it.
So he thought his wife would be upset about participating in this, but he thought his mom would be okay with it?
Yeah.
But he never told his wife, to your knowledge, he never told his wife what the $500 twice was for.
No, I don't know. I'm not sure.
You didn't overhear that phone conversation.
No.
But when you talked to him, he talked to you about getting his wife to get the money to his parents?
Yeah, he talked about getting the money. Yeah, because he absolutely wanted Ed not to show up, and he figured that if he got that money, that would be a solid way for him not to come.
No further questions, Your Honor.
All right.
Thank you, Mr. Thompson.
You're going to have to come back for cross at 1:30, sir. We're going to take our lunch till 1:30. Again, don't talk about the case. Be back at 1:30, okay?
Oof, chat. What do you guys think of this testimony? Now, a couple of things to point out. We are live on Facebook and YouTube, so there's two separate chats going on. For those of you that are new, we played tons of marathon
All right,
streams.
Jury's outside the courtroom on hold on them, so we can take the defendant back for lunch. Thank you. 1:30.
We played tons of
1:30
marathon streams that we do on the weekends. And one of the things that we did during those streams is we played David Thompson's 2008 testimony. We played the whole thing. And some of you in chat have recognized that in 2008, David Thompson testified that he did not ever go in Mark Jensen's cell, which is a big deal because the prosecution is trying to show that there's no other possible way that these guys would have known any of these details unless Mark Jensen told these people and confessed the big confession to Aaron Dillard. The defense planted the idea, and we're not even sure if this is, true. We don't know. It's a speculative planting of this idea that Aaron Dillard read the 1999 police interrogation transcript. Okay. We know for a fact that Aaron Dillard read the Ed Klug testimony transcript from the 2007 bond forfeiture hearing. We also know that the 99 police interrogation transcript was sent to Mark Dillard. Oh, I'm sorry. Jesus, God almighty. I'm confusing everybody's name. I'm so tired, chat. Long weekend editing videos. That the interrogation transcript was sent to Mark Jensen 4 days prior to Aaron Dillard arriving in the Kenosha County Detention Center. It is a plausible concept that Aaron Dillard did see that transcript. Now, do you think it was proven that he didn't? Do you think it was proven that he did? The concerning part in Thompson's testimony regarding paperwork and news articles and all these things is that he just testified that he went into Mark's cell reading paperwork, which means that whatever he read could have been kind of broadcasted out to the rest of these snitches. It also kind of shows that if Thompson did this, that Aaron Dillard would have done this as well, right? Because Dillard was closer to Jensen. So Jensen may have shared more documents with Aaron Dillard, which is what the defense is also claiming. That's huge. Now, some of you, you've never been to jail, and most of you probably have no idea what the Kenosha County Detention Center looks like. It's a big, giant square building, right? What Thompson describes as I block and J block with this guard thing in the middle. These are like these kind of rectangle rooms, right? And they're small. They're super tiny, okay? So the idea of holding notes up to the window, from block to block, and you got the guard area in between. Yes, that does happen in the jail. It happens in jails all over the place. There's ways to communicate. There's all kinds of crafty stuff. So yeah, you can see notes written. Those guards are not always in those little guard bubbles. They do walk around because they don't really care about the inmates. So there is ways to do it. If they are in the guard bubble and you really have to pass these messages, you'll have inmates that lean up against the window to, and remember, it's a long rectangle. So they'll lean where the guard sits. You'll have a few inmates that position themselves kind of in the way of what the vision of the guard would be further down into the cell block. So you'll have some inmates that stand there so that you have inmates between the different blocks so they can pass the hold the notes up to the window. So there is crafty shit like that does happen. Okay. Now, yes, Bonnie, they are at lunch. They are at lunch. Let me change the banner for you guys so you guys know what's going on. We are going to play, we have an hour, of break. So we are going to play some clips. We'll play some 2008 stuff. We've already played Thompson's 2008, so I don't want to replay that. And I have no idea the timestamp on when he testifies that he never went to Mark's cell. Let me just change this banner for you guys so you guys know what we're doing here. What's going on in the trial. All right. So that was one thing. Here's the other thing. I block and J block, in my recollection, is not a corner block. If it was a corner block, then maybe what Thompson says that basically the window kind of, narrows in, which makes it easier to share the notes. I don't believe that that's accurate. I don't believe that's accurate in I block and J block. I'm pretty sure I'm correct, but I might be wrong, but I'm pretty sure I'm correct that I block and J block are not corner blocks. They're rectangles. So I don't believe that part of his testimony is true. Now, it's a minor detail, I know, but it's something I caught. We're very familiar with this jail. I don't believe that that's accurate. Now, the jail phone calls that we heard, okay, we kind of heard some new portion of that phone call that I don't remember hearing in the 2008 trial. And now remember, when they're playing the phone calls and everything, right, they had to play the audio from the like a boom box, and then they put a microphone up to the boom box. So, it was pretty bad. It was kind of cringy to listen to, but I don't remember that part. And now we're kind of hearing a little bit more, and we're hearing the phone call way clearer. So I'll be honest. I don't necessarily believe Thompson in a lot of what he says. However, chat, that phone call things that they played, those testimonies of those phone calls, man, I thought that was kind of damaging towards Mark Jensen. Now, he may not be guilty of the first-degree intentional homicide with Julie, because we have our theories about that, right? But chat, was Mark so nervous that he may be convicted that he did actually conspire with Dave Thompson to kidnap Ed Klug? Now, for those of you asking who Ed Klug is, if you kind of knew and you're not following, 100%, Ed Klug is Mark's co-worker. They're like besties. And these two goofy morons, they think it's funny. I don't know why. I don't know who does this. I don't think this is normal. But these two morons, when they're at work and they go out for drinks and everything, thinks it, it's hilarious to talk about, killing their wives. So I don't know who does that. That's something's off with all that too. But man, I don't know, chat. I did not like those phone calls, right? We have tons and tons and tons of evidence that point in Julie's, column that she is planning and plotting and scheming this whole thing. And she's the one that's putting the pictures, and she's finding all these weird things around the house. And she's the one that's actually doing the internet searches, right? Because why, she's basically like, a spouse that's thinks her husband's cheating. And she's looking up Mark's emails. And then based on the contents of those emails, like for instance, and we've said this a million times, but for those of you that are new, she loads up Mark's emails and she's looking at an email that is sent at 3:52 p.m. And here we are at, 11:30, 12 o'clock at night. And she's looking at this email. There's no reason Mark would do this. It's not even, I don't know. I guess it's plausible, but it doesn't make sense. So she sees Big Cedar. Okay. Now, Mark's already talking to Kelly about Big Cedar in this 3:52 p.m. email, right? So whoever's on this computer at midnight loads up the email again, goes onto the Big Cedar website, and then starts clicking around. But again, mind you, Mark has already done this, and he's already talked to Kelly about this. So why is he doing it again? Then following that, somebody is on the Stiffle-Nichols website searching for different Kellys, trying to find out who Kelly is and then what branch Kelly works at. And she's doing this, I say she because we think it's Julie. Whoever's doing it is also searching for other names that they're finding in these emails, like John Jock, right? All these names. And they're searching the Stiffle-Nichols directory for these names and searching which branches they work at. It doesn't make sense that Mark is doing this because Mark already knows these people. He knows what branch they work at. He's not sending an email at 12 o'clock. There's no email sent at 12 o'clock. So it makes more sense that Julie is doing this, trying to catch this goofy moron in an affair, right? And then it throws us for a loop because there's all this stockbroker stuff that's searched next. And Mark is a stockbroker. But we find out last week that Julie also works at a stock firm and she went and got her Series 7's license. So Julie could have checked the stocks and how's Best Buy doing right now before I go off to bed. Now, we've got tons of theories. There's a lot of evidence with that theory. We broke it down like a bunch of times during the breaks. And at the end of our streams, we stay on for an extra hour and do a recap, point out some weird things that we've heard. We put the little check boxes in Mark's column. We put the check boxes in Julie's column. And then we have some other theories, So, yeah. Now, I'll tell you guys that are new, Facebook only allows us to stream for 8 hours. So the Facebook stream, unfortunately, ends at the 8-hour mark. But we are still live on YouTube. So be sure to cross platforms and subscribe to YouTube and come on over there when the Facebook stream ends. There's nothing I can do about it. And we don't stop our streams for part 1, part 2, because it's too hard to get you guys back here. We also have a viewer, one of our viewers on YouTube that has been dialed into this trial. And she watched the 2008 trial. And she is taking notes and she is comparing a lot of crazy things that are happening between the two trials. And we brought her on Friday to kind of recap what she's thinking of everything. So we clipped that out. It's up on the YouTube channel. You can watch that independently. But what we're going to do, chat, is we're going to have her back on every Friday at the end of trial day. And she's going to kind of recap all the crazy that is going on in the trial, so you guys don't have to listen to me do it every day. She's going to recap it and all the things that she's caught, whether it's against Julie or against Mark. Now, I was saying earlier, I kind of wanted to get this out, and they started the court session again. So we were thinking about when the jury actually goes and deliberates to do a separate little stream and have everybody in here and everybody's pointing all these things out, typing their comments, typing their theories, right? And I want to do that. But we're going to do it a little different. I have to see if I can get 11 people onto the stream where we send you a link and invite you on. And again, you don't have to turn your camera on. Some people like the anonymity, right? They're a little nervous about their faces being shown. I get that. Some of you are not as crazy as me. But if we can get 11 people, I'll be the 12th, and we will have a jury room. All right. If we can't get all 12 in there, however many we can get, that's what we're going to do. So if it's 6, we'll get 6. If it's 9, it'll be 9, whatever it is. And we'll have a jury room. So when the state rests their case, we'll put together the jury room. And all of us that we can fit in there will deliberate. And you guys will get to watch that live and see kind of, it's because most of us have never been on a jury. A lot of us, I would assume, have not. Some of us in here I know have. So if we were the jury, what are we thinking? Right? And if we're thinking the similar different things and whatever, the jury in this case is thinking the same things. Now, when the defense puts on their case in chief, we're going to just keep updating, keep going with the theories, keep breaking this case down, keep comparing testimony from 2008 to the 2023 trial. We're going to have our viewer come back on Fridays and break down the defense's case in chief. At that point, it'll be done, and the defense will rest. They'll send the jury for deliberation, and we will do another jury room, and we will deliberate again. I think that'll be fun. So we will set up some parameters about one person speaking at a time, careful with the language. If you are interested in being part of the jury room, send me an email at Never.Stop.Voices@gmail.com, Never.Stop.Voices@gmail.com, if you are interested in being part of the jury room deliberation live streams. Okay? I think it'll be fun. What do you guys think? Now, for those of you that are new, this is a great time to ask questions. Some of you have not been with us for breakdowns. Some of you have not seen our big giant marathon streams where we're streaming for 16 hours and just going crazy, deep diving into 2008 version of this trial, giving so much case background and why this case is even coming back, and the whole Sixth Amendment change and all these different things. Ask questions. Feel free to ask questions, whether you're on Facebook or YouTube. We'll pop your questions up. We'll answer them to the best of our ability. If we don't know an answer, we'll look it up and we'll get back to you. But feel free to ask questions. If you need some clarifying things, put it in the chat. Also, put in the chat where you guys are tuning in from. It's always fun for us to find out where everyone's watching from. We like to know. Put it in the chat. Don't be shy. Come on in. Say hi. Introduce yourself. Now, I did pull up some other 2008 testimony. We played a little bit of this over the weekend. So a little background on what this is. The defense called an expert witness. He is a forensic psychiatrist. Basically, this is kind of a controversial thing. And what he basically testifies to, he interviews everybody. He reads a bunch of statements. Kind of does his independent investigation and then takes the psychology behind all of that information and comes up with an analysis on whether something might be a homicide or an unaliving, right? And we got to be careful on our verbiage. So we have to say unaliving. Otherwise, we kind of get whacked on some stuff. And this is a very controversial kind of expert witness. It was super controversial back then. So we watched the first hour of his testimony where he kind of explains a lot of Julie's background with the mental health issues, a lot of psychosis that she's going through, some delusions that she's having. So we didn't get to finish because we were answering a lot of questions, doing a lot of things, and chat kind of went sideways, and then we just started having fun. But what I'm going to play here is the cross-examination where Bobby Boy and this controversial doctor go at it, and they are screaming and yelling at each other. It's absolutely hilarious. I know you guys like watching Bobby Boy lose his mind. So we're going to play it, and that's going to be our videos during lunch. Here we go. Now, if you guys like what we're doing here, please like and share the stream. There are some pinned comments where you can donate financially. That does help. It keeps us providing content and filing for open records requests so we can expose corruption and all of that fun stuff. If you're on YouTube, you can send in super chats and we'll highlight those comments for everybody to see.
Dr. Spiro. Mr. Jensen. Thank you, Adam. Dr. Spiro, you made reference to what you did in this case to be akin to a psychological autopsy. Is that correct?
Well, I tried to describe what actually I did. Psychological autopsies have many definitions.
Would you agree that what you did in this case could be described as a psychological autopsy?
Depends on who's doing the description.
Well, doctor, it was a term you used. I didn't make it up. Did you use the term psychological autopsy to describe what you did or not?
Yes, but the psychological autopsy term was originally called for by the courts and therefore offered a different range of interviews.
Doctor,
so while this is based on experience I had teaching psychological autopsy, I have described the exact examinations that I did.
And you indicated that psychological autopsies have been performed in order to differentiate between suicide and homicide?
They have been.
And in order to differentiate between a suicide and a homicide, you have to realistically consider the option of homicide, do you not?
In the psychological autopsy, the psychiatrist is generally not called upon to give the state of mind leading to autopsy. That really is what the prosecution presents.
Well, didn't you describe psychological autopsies as being used to differentiate between suicides and homicides?
By the courts, by the prosecutor, by people who consult psychiatrists in order to find out whether suicide is a likely outcome.
So in this case, you didn't consider at all the possibility of a homicide?
No, that's not true.
Well, show me in your report where you discussed homicide, where you discussed any part of this being possibly a homicide. You've got your report there in front of you?
I do.
Okay. Page 1 is described psychiatric case study. Is that correct?
That's correct.
There's nothing there about this being a potential homicide, is there?
There's no psychiatric case study of the alleged murderer. It was made clear this was a case study of the person who died.
Doctor, the question.
Yeah, read the question. Thanks.
Question. There's nothing there about this being a potential homicide, is there?
And the answer to that question is no, correct?
No, that's not true.
Okay, where on page 1 do you mention that this could be a homicide?
On page 1?
On page 1.
Was the question on page 1?
Yes.
The answer to page 1 is no mention of homicide on page 1.
Okay. Let's look at page 2, the table of contents. Where is it on page 2 that there's any reference to this being a potential homicide?
Come be a part.
Nothing I can do about the commercials in this archive footage, and we got to be careful on these Disney ones. YouTube likes to whack us, so bear with me on this. We try to get through them as fast as we can. They're like 15 seconds, 20 seconds long. So once again, if you want to be part of our jury room, send an email. We're going to ask you some questions. We're going to treat it like an actual voir dire. We're going to voir dire you to see if you qualify to be on the jury. Let's make it as real as possible. It'll be fun. We're not going to ask you like personal stuff, like what's your address? Where do you live? Where do you work? We're not going to get that personal. We like to protect people's anonymities. We like that. We respect that. But we'll ask you some fun questions just to keep it interesting as if it's a real voir dire.
In the whole section on records reviewed, I review the report at length and respond to the report of the prosecution, which was a consideration of homicide and the adduction of all of the prosecution's presentation that it was a homicide without doing a suicide evaluation. And because that's referred to throughout the report, I would have to strongly disagree with your premise. In fact, the case expert that you haven't yet presented, I understand, offered a report that was about homicide, and there is a long section that involves reaction to that report.
So at the time that you were conducting this evaluation, you were looking at the potential of this being a homicide.
I was doing a psychological examination after death of a woman who, in my opinion, died of a suicide.
And let's get to that opinion then, doctor. That opinion was based to some extent on your review of the records and also your interviews in this case, correct?
That's correct.
In fact, you stressed the importance of the interviews, of a clinician doing the interviews, correct?
I think I emphasize that it's very important in cases of the differential between homicide and suicide to involve a psychiatrist who's used to working with suicides, which I had not found in the prosecution's reports.
And we're talking about your report right now. So it was important for you to conduct these interviews of all these persons, correct?
I think it was important for a psychiatrist to conduct the interviews, yes.
So the interviews were an important part of your analysis in this case, an important part of your conclusions, correct?
They were one part, yes.
And the first part, the first interview, or the first person you mentioned was Mark Jensen. You spent 14 hours interviewing Mark Jensen, correct?
That's correct.
And you testified that you were principally interested in getting names of, you just got names from Mark? That's what, but you certainly did a lot more than just get names from him in 14 hours, correct?
Yes, I did.
I object because he's mischaracterized.
Invalid question. Go ahead and restate it.
Okay. Did you testify that you just at one point, did you just testify you just got names from Mark?
Just?
Just got names from Mark.
If I use the word just in that context, I misspoke, because that's certainly not true.
So you certainly got a lot more information from Mark than just names.
Yes.
And we should refer to him as Mark Jensen. That was my mistake. But so you spent 14 hours interviewing Mark Jensen, who in this case is accused of the murder of Julie Jensen, correct?
He is the husband who was accused of the murder, yes.
And then you spent, let's see, 1.25 hours interviewing Dr. Borman.
Yes.
And you found Dr. Borman's information to be particularly useful in your case, in your opinion, correct?
Yes, I did.
And then you spent 1.5 hours interviewing Pastor Eckler.
Yes, that's correct.
And then 1.5 hours interviewing Dan and Florence Jensen.
That's correct.
The parents of the person who's accused of murder in this case.
Correct.
And then 3.25 hours interviewing Laura Koster. Correct?
Correct.
The sister of the person who's accused of murder in this case.
That's correct.
And then you spent 3/4 of an hour interviewing Dave and Judy Schmidt. Is that correct?
That's correct.
And David Schmidt has known Mark since 7th grade, correct?
That's correct.
And then you spent 3/4 of an hour interviewing Doug Brandt.
That's correct.
And Doug Brandt has been Mark Jensen's friend since long before he met Julie Jensen. Is that true?
I believe that you mischaracterized that interview. It seemed to me Doug Brandt was with his wife.
Well, Doug and Robin Brandt, correct?
That's correct.
Now, were there any other persons that you interviewed that you did not list here?
I tried to make a complete list of the interviews.
And were there any hours that you spent interviewing people that you did not list here?
You're excluding the discussions with the attorneys.
Yes, I'm talking about the 26 hours of interviews were compared to establish internal reliability.
Yes, that's correct.
And so the 26 hours of interviews is with the persons we just listed.
That's correct.
And for the period of time that you just listed in your report.
That's correct.
Now, so of this, and by the way, let's go through the math here. 14 hours with Mark Jensen and then 1 hour with David Jensen, that's 15 hours, correct? 14 plus 1 is 15 hours?
I believe so.
And then 1.25 hours with Dr. Borman, that's 16.25 hours?
I believe so.
And then with Pastor Eckler, that's 1.5 hours, that's 17.75 hours. And then with, I added up to 24 hours is what I'm trying to get at. Are you sure that it was 26 hours or could it have been 24 hours of interviews?
I would never doubt a prosecutor's edition.
Well, we'll check that out over the lunch hour then, won't we? So, because I don't have a calculator here. But so of the 24 or 26 hours of interviews, 14 plus 1.5 plus 3.25 were interviews with Mark Jensen or members of his immediate family.
That's correct.
Now, in your experience in murder cases, are the accused murderers and members of their immediate family the most reliable source of information about an alleged homicide? Or might you find in some instances they might have a motive to lie?
They might have a motive to lie, and that's why we ask for the cooperation of the prosecution. In this case, we just had the written statements the prosecution used, and as you well know, you have only summarized interview time, and for reasons that escape me right now, you've ignored all the rest of the work done in this case.
Well, Doctor, I'm asking you about the interviews right now.
Well, I understand. You are studying a part of it that favors your case, and you're ignoring the efforts that I made. Working with excellent prosecutors over the years, we often have a chance to interview rather than just depend on written statements, but I, in fact, had available, unless you were withholding things from discovery. All of the statements that were available, and I know you would not withhold things from discovery. Therefore, I had available a great deal more than you had. That is, I had your statements plus the interviews that you had not done.
Well, for example, I didn't interview Mark Jensen for 14 hours, did I?
I have no idea how long you spent with him. I know that the doctor was upset that he was not immediately interviewed in the case, because he had a great deal to add to the case. We certainly wish, in the interest of fairness, that both I had been fair, because I certainly wanted to look at all of your clients, and that you had been fair and that had looked at the doctor's testimony at the very beginning of the case.
You know, Doctor, excuse me. I ask a question, then I'm supposed to get an answer to my question. I don't need a lecture from you as to how to conduct my job as a prosecutor. Do you think that's your function in this courtroom?
Just a moment. Why don't you ask a question? And Doctor, you should confine your answer to what is asked of you.
Okay.
Dr. Borman, are you aware that Dr. Borman was contacted the Monday following Julie Jensen's death by a representative of the medical examiner's office?
I am.
Okay. So it's not as though Dr. Borman was ignored in this case, was he? And are you aware that Dr. Borman testified in this courtroom?
There was no answer.
Oh.
Well, I guess, why don't you, I guess it was more of a statement. Ask a question.
Are you aware that Dr. Borman testified in this courtroom yesterday?
Yes, I am.
And would it surprise you that perhaps there are people in this courtroom who didn't come away with the same impression of Dr. Borman's assessment or impressions of this case as you seem to reflect in your report here?
Objection to characterization by the prosecutor. I mean, there's no evidence of that.
I sustain.
Well, you know, in Dr. Borman's testimony, he spent a great deal of time talking about a woman who was apparently frantic because she was in conflict. That's not an incorrect assessment by Dr. Borman, is it?
Doesn't sound incorrect to me, no.
Dr. Borman expressed the view that this was a woman who was deeply committed to her children and loved her children very much. That you don't dispute that, do you?
I was not here, so I'm not going to characterize another witness's testimony.
Dr. Borman.
The question was not whether you agreed with the doctor. The question whether you agreed with the particular assessment.
The assessment that's what she would have said to him, I certainly can agree with, but I see a great deal going on in this case.
Well, you weren't there.
To it.
You weren't there when Dr. Borman interviewed Julie Jensen, were you?
No.
So Dr. Borman was perhaps in a better position to assess what was going on at that point than you are now, don't you think?
Objection to the vagueness of the question.
Overruled.
I think that the doctor's conclusion that this woman was depressed and needed antidepressants are a conclusion I agree with. And I think that you can cloud that with smoke.
Read the question back, please.
All right, commercials, nothing we can do. What did you guys think about that exchange between these two? He really handed it to Bobby Boy and kind of alleged, again, some controversy surrounding Bob. Bob did not do interviews and investigations. We talked about, and it's really not his job, I guess, but we talked about that with the police, about confirmation bias, not looking at all the evidence to prove or disprove different theories in the case until you have a final conclusion. Bob went around and just told everybody what the case was. Didn't let them have a chance to look at different things.
Question. So Dr. Borman was perhaps in a better position to assess what was going on at that point than you are now, don't you think?
And I was unable to agree with it. It depends on what aspect you're referring to.
No, Doctor, the question is not whether you agreed with Dr. Borman's assessment. The question is whether or not Dr. Borman would have been in a better medical position than you to form an opinion.
And my answer is still that the medical opinion depends upon 48 years of psychiatric experience as well as the information that was in the room.
Doctor.
Well, Judge, this is what my...
No, read the question back, please.
Listen to the question. And Judge, I re-object as vague, which is why I think that the answer is correct, because it doesn't say what it is.
Overruled.
Question. So Dr. Borman was perhaps in a better position to assess what was going on at that point than you are now, don't you think?
I certainly would agree with the perhaps part of the question.
So Dr. Borman, who actually had this woman in his office whom he'd known for many years, was in a position to assess whether she was depressed or whether she was responding to situational stressors or psychostressors as you've described them.
I can't answer that question as you posed it.
Well, tell me this, doctor. You understand the distinction between being depressed and being very unhappy, don't you?
Most depressed people are very unhappy, so I find it a distinction without a distinction.
But so most unhappy people are depressed?
Some unhappy people are depressed. Most depressed people are unhappy.
And I'm talking about the fact that somebody would be unhappy doesn't necessarily mean they're depressed, is it? For example, people are...
Is there a question or not?
Is there a question?
If you don't understand, could you read the question back about...
Omit the second sentence, though, just the first.
Yeah.
Question, and I'm talking about the fact somebody would be unhappy doesn't necessarily mean they are depressed, does it?
The answer to that question as it's posed is yes.
So if somebody is unhappy, in your view, they're depressed?
No, I think I said just the opposite.
Oh, okay. So if somebody's unhappy, that doesn't mean they're depressed?
It can mean they're depressed. And if you think so, you give them antidepressants.
And it could mean that life has just thrown them a couple of hard curveballs, right?
It could be hard curveballs that lead to a depression, or it could be just some hard curveballs.
A woman who loves her children and believes that her husband is leaving her might have reason to be very unhappy, correct?
Yes.
And that's not necessarily a sign of depression, is it?
It may be a sign of depression, yes.
But it's not necessarily a sign of depression, is it?
You need much more.
The fact that a woman believes that her husband is trying to poison her might cause her to be very unhappy. Isn't that true?
I would think so.
Especially if it turns out that the husband was trying, just hypothetically, especially if it turned out that in point of fact, the husband was trying to poison her.
Yes, it would.
And if the husband had never forgiven her for an affair that she'd had many, many years earlier, that would also be a stressor that could cause her to be unhappy. Isn't that true?
These are hypotheticals?
Absolutely.
Hypotheticals are a bit incomplete for a psychiatric answer.
Well, okay, I'll give you this hypothetical fact situation. Let's assume that when Julie Jensen was talking to her neighbor, Ted Voigt, she was telling the truth. Let's assume that when she was talking to Dr. Borman, she was telling him the truth. And let's assume that it was Mark Jensen who was leaving these photographs, these pornographic photos around the house in the years preceding Julie Jensen's death as a means to humiliate her and embarrass her because of this one affair, and as an indication that he'd never forgiven her. Now, assuming hypothetically all of that is true, wouldn't Julie Jensen have a very good reason to be unhappy when she saw Dr. Borman on December 2nd, December 1st, 1998?
Yes.
Now, when you interviewed Mark Jensen, did he tell you that he was having a sexual relationship with Kelly Labonte in the weeks and months preceding Julie Jensen's death?
I felt he made it pretty clear to me, yes.
Well, he told you that, or he didn't. Did he deny that? Did he tell you that he was having sexual relations with Kelly Labonte in the weeks and months preceding her death, Julie Jensen's death?
He made me aware that his relationships, he didn't use the words you're using, but he made me aware that his relationships had led to enormous unhappiness in his wife and had been subjects of argument.
You know, doctor, that really, what I'm wondering is this. As a result, what were the words that Mark Jensen used when you asked him about whether or not he was having a sexual relationship with Kelly Labonte in the weeks and months preceding Julie Jensen's death?
I don't have those words.
Do you have notes concerning this interview?
Yes, I have about a notebook full of notes that I can hardly read.
Where are they?
Right here.
I'd request they be produced.
Well,
All right, chat, let me just pause for a second. So, if you missed the direct examination, we do have that in a live stream that we did over the weekend. It is on our playlist, Mark Jensen trial. So what this doctor did, he interviewed everybody. There's been some comments in chat about, you know, he needed to interview Julie. He evaluated all of her medical records, all of the psychotic episodes that she's had, all the medications that she's been on since the early 90s. And with a lot of things that we've heard, you know, I kind of pointed out, like, guys, maybe she was schizophrenic, right? There's 5 different types of schizophrenia. But our chat said, Kev, no, she had bipolar. Now, there are 2 different types of bipolar, bipolar 1 and bipolar 2. Some of the key takeaways. Bipolar type 1 has episodes of depression, hypomania, and mania. Type 2 is depression and hypomania. So with bipolar 1, they have at least 1 manic episode in their lifetime. Bipolar 2, they never have a manic episode. You're like, Kev, what does all this mean? What is hypomanic? What is manic? Well, let's read it. During a manic episode, your symptoms can cause serious problems at home, work, or school. You may need to be hospitalized so that you can have 24-hour care. And many people with mania also experience psychosis, a break with reality. Now, a lot of the things that we're hearing in the testimony, right? And we're looking at it and we're going, Jesus, Mark is doing this. Mark is driving this lady nuts. But could Julie Jensen have had a break in reality? And she's imagining a lot of things. Now, we heard today in testimony from her brother, Paul, that there were a lot of deaths leading up to the years prior to Julie Jensen's death. I think that is critical, and it could have played a role in her psychosis, in a break in reality. It's interesting, chat. Now, with the hypomanic episode, symptoms aren't as severe. Friends and family may notice that you're acting differently than usual, but you can still keep up your daily activities. People with hypomania do not have psychosis and usually don't need to be hospitalized. So, chat has said, Kev, I don't think it's schizophrenia. She had bipolar type 1. It's an interesting theory from the chat.
That leads to some questions we should discuss.
Before I look at the notes, you want to discuss that? I don't have a problem with taking a break so we can do that. I do feel it's important for me to see the notes, Your Honor.
All right, we'll take an early lunch today, and let me ask that you return at 12:45. Thank you. Please don't talk about the case during the break.
Please all rise.
The judge, Craig.
All right, just fast forward through this commercial little part here. These this old trial footage, this archive footage, all their lunch breaks, all those things, they're all edited out. So if you guys want to watch these things on your own, check it out. But we have done so many marathon streams of the 2008 trial. It's all up on our YouTube channel. You can find the streams on the Facebook page too, because we leave those up there. But YouTube has it. I think it's a better way to watch. Let me just get past this commercial and we will get back to this testimony. These two are just nonstop yelling at each other. They're going to butt heads some more. We'd love to see Bobby Boy lose his mind. We'd like to see him yell and scream in the courtrooms.
Her conversation with Therese DeFazio and in her conversation with Ted Voigt. In both instances, Julie Jensen recounted that she had just spoken with Laura a short while earlier. This is about a week and a half before Julie's death, and that she had recounted her concerns to Laura. And according to Julie, Laura replied, "You have no idea what my brother's capable of," or something to that effect. And when I asked Ms. Koster about this at the forfeiture hearing, she denied that conversation.
Just for my information, and I beg your forgiveness if I've forgotten it, but what is the source of your knowledge of that?
The source of my knowledge about those two statements?
About this particular statement?
Therese DeFazio and Ted Voigt. They both indicate that in statements that they've provided us. And Ted Voigt, I believe, testified about it at the forfeiture hearing, and Therese DeFazio was not permitted to testify about it, even though she said that was the case.
Here's what the problem with both of the statements attributed to Ms. Koster is. They are reflective of the opinion of Ms. Koster as to what her brother might do. Now, I think that Prince Fielder might hit 70 home runs this year.
Throughout the course of this, and describe
sister
specifically instructed not to make any mention of it.
That's one issue. But he did.
Come be a part of the world's most magical.
All right, sorry, chat. Trying to find where the testimony starts again. Now, we did also in that stream, we played Mark's sister's testimony, Laura Koster, and that had a lot of good information in it too. She is on the witness list for this trial. So again, if you weren't part of that marathon stream, check it out. Sorry again about the commercials. Nothing I can do. Feel free to ask questions, get clarifications. We'll pause and answer those questions however we have to do it.
For depression, the reconstruction of delusions with no direct examination possible is not accurate enough in a case with this type data to render an opinion to a reasonable degree of medical certainty. I present the psychiatric information so that the possibility is present for the court to decide. There is a significant subset of depressed patients who develop either mood congruent or mood incongruent delusions. I would say there is a significant chance Julie suffered from this, but there is insufficient data to prove this to a reasonable degree of medical certainty. certainty. So he's laying it out there for the court, for the jury to come to that conclusion, even though he says he can't come to that conclusion to a reasonable degree of medical certainty. I believe that I should be permitted to examine that. Julie Jensen had good reason to believe that her husband was trying to poison her, partly because of the conversation she had with Laura Koster a week and a half before she died. And the reasons that I believe she had good reason to think that is, first of all, Laura Koster's response when Julie brought this to her attention. And Julie had good reason to be fearful of falling asleep. It's not a sleep disorder when she believes that her husband might be wanting to inject her with something. And Laura Koster herself testified that she saw a photograph of an item with what appeared to be a plastic syringe on top of it a week and a half before she died. And according to Julie Jensen, Laura Koster told Julie Jensen, "You have no idea what my brother is capable of." And then on top of that, the day after Julie died, somebody identifying herself as Laura Koster called the Pleasant Prairie Police Department and left a message for Detective Ratsburg saying, "I think my brother may have killed my friend Julie." And she described herself as Laura Koster. Now, I believe, and by the way, that's all information that was available to this physician at the time that he was examining this entire record. As he said, he went through everything we gave to them, he had. Now, I don't know that he had that thing about Laura Koster, but about what Laura Koster said to Julie.
Chat, I gotta pause. Those of you that were with us over the weekend, does anybody remember questions or testimony involving the sister calling the police and making any of these statements? We watched the whole testimony of Laura Koster. Does anyone remember anything about this? That would be an important thing to bring up by old Bobby boy. Bobby likes to just interject things that never happened. This guy, something's up with this guy, chat. I don't know.
Julie quoted Ted Boyd and Teresa Fazio, but he certainly had in there this information that somebody identifying themselves as Laura Koster had called the police a day or two after Julie had been.
Now that one, I'm going to tackle that one separately because for one thing, that information was not operative on Mrs. Jensen before her death. That's a statement of opinion by somebody that took place that could not have been known to Julie Jensen. So I don't see how that would factor into this at all.
Well, here's how it would factor into it from the perspective of looking at this report and the validity of the information that Laura Koster gave to Dr. Spiro. Dr. Spiro makes no mention of that, even though it's in the report. And he describes Laura Koster as being this very good historian and this reliable person and a competent observer. There's no indication that he confronted her with this statement. Well, did you call the police? Did you tell them anything about this? There's no indication in his report that he did that. Now, I haven't looked through all of his notes.
First of all we know is that someone stating that she was Laura Koster called the police. We don't know if it was in fact Laura Koster.
Here's what Detective Ratsburg wrote in his report, and this is a report that was printed March 7th, 2002. And it's near the top of page 20. Contacted Todd Koster and set up an appointment for Saturday, 12/11/99. Todd called later to cancel, stated he would call later in the week and set up another. Koster's home phone number is 694-1902, pager 312-740-8517, 9410 41st Avenue. The reason I contacted the Kosters, Mrs. Koster is Mark Jensen's sister. Shortly after Julie's death, Mrs. Koster contacted me and stated she thought her brother Mark may have killed Julie. I never heard back from the Kosters, as it appears they do not want to say anything at this time. That's the extent of what I have.
Well, a moment ago, you were saying someone identifying herself as Julie Jensen. Now you have Lieutenant Ratsburg saying not Julie Jensen, Laura Coster. Now you're telling me Laura Coster made the call?
We did not explore this at this hearing, Your Honor, because you had instructed us at a pretrial hearing that it was inadmissible. And Detective Ratsburg is here in the courtroom, and I don't want to misstate things, so I don't want to tell you exactly.
Find out what he says.
Yeah, do you want me to put him on the stand?
No, I just want you to ask him.
Okay, what happened?
Who identified?
What happened? And there's somebody called you, were called police department. Tell me what happened.
Yes, somebody called the police department, identified themselves as Lori Coster, and suspected that Mark had something to do with Julie's death.
Did they talk directly to you or talk to somebody else?
Directly to me.
Okay, so it's the person that you were talking to.
Yes.
Okay, well, tell us what that person said when they called and they spoke with you. What did they say to you?
They were crying and were sniffling, and they stated to me that
she, and that
she thought that Mark had something to do with Julie's death.
And she identified herself as who?
Lori Coster.
And so after she
was there a follow-up?
No.
A year later there was. December 11th, 1999, he called Todd Coster to set up an appointment. But at that time, and I believe this occurred within a matter of a day or two after Julie's death, and Laura Coster, or the person identified.
Did you guys catch that? Judge Schrader asks, was there a follow-up? Detective Ratsburg says no, but Bobby Boy interjects and says a year later there was. So which one was it? Was there a follow-up or was there not? Because the detective just said there wasn't. You see how Bobby Boy just interjects his own things and he's overpowering what other people say? Gee, I can't even talk today, chat. Jesus. Right? Again, another example of old Bobby Boy telling everybody what happened and not letting them tell what happened. He doesn't like people's versions of what happened because it contradicts what he thinks he knows.
Herself as Laura Coster was crying over the telephone and giving this information. Sounds like an excited utterance, actually.
It doesn't matter. You can't give some impermissible.
It's not the issue at all.
You can't give impermissible opinions, excited utterance, or any other reason. It's a Hazelton violation.
That's the problem. It's not hearsay. It's not the issue here. It's the opinion nature. And I'm thinking about, well, to what extent ought the doctor have? To what extent should the jury know as to what exploration the doctor did? And I think, when you're dealing with the opinion, I don't think that should come in. But I'm rethinking the business about the, you don't know what my brother is capable of, because to the extent that he has discussed a rather, he's got kind of an involved discussion about delusional thinking. And that would be something that, and he doesn't come to an ultimate conclusion, but he's right near there. It's kind of, he's near the point of making his conclusion to a reasonable degree of medical certitude. And he's saying about delusional thinking, one would think that on the subject of whether one is delusional or not, that a fear that is reinforced by the very sister of the accused would be less likely to be a delusion.
Judge, Dr. Spiro is not sitting here as a super juror. He's not, and his report doesn't pretend to say, well, this person says he didn't do it and I believe that person. That isn't what these reports are about as experts. What he is doing is trying to determine her state of mind. All the things that Mr. Jambois is talking about are all perfectly fit for him to make argument. He obviously has presented an entire case as to why her fears were reasonable. That's what this whole case is about. That's what all the evidence he's presented in this case is, that she had a reasonable fear and that's what actually came to pass. That's what the case is about. Laura Coster, who denies making that statement, whatever her speculation is about what her brother says, and certainly there are many possibilities about how she could have been misunderstood, misinterpreted, that Julie Jensen's secondary statement could have been misunderstood, misinterpreted.
Well, that's not the test for me in
Judge,
deciding about the admissibility of evidence.
Judge, it's one of the factors because you have to consider the probative value and the unfair prejudice. And the more layers of hearsay you have, the greater the unreliability.
There isn't a lot of hearsay involved in this, Mr. Albee. We have the non-testimonial statement of Mrs. Jensen given to Ms. DeFazio, who related it on the witness stand. Where are all these layers of hearsay that you're talking about?
Anyway, hearsay is one of the problems, and I'm trying to make an argument on, Judge. And it's because Julie Jensen's repeating what to Teresa DeFazio? Hearsay.
No. It's not being offered to prove that Mark is capable of killing her. It's being offered to prove the state of mind of Mrs. Julie Jensen.
Judge.
So that's not even definitionally hearsay at the starting point.
That's fine. It's being passed from person to person, which makes it more, Judge, if it's passed from person to person, it makes it more unreliable. If it goes through 10 more people, that's the children's game of telephone. The more people you pass it through, it becomes more unreliable. That's part of a 403 way.
Now you tell me where I'm going wrong here. You tell me, no. You tell me where I'm going wrong.
Make the argument.
I know you haven't because I'm finding fault with what you're saying, and I don't want to hear the whole argument when it's premised upon something that's not correct. Now, let's look at it. We're not talking about a statement that is offered to prove that Mark Jensen is capable of killing anybody. This statement is being examined in the light of its use as to whether or not Mrs. Jensen was delusional. The statement was made allegedly by Laura Coster, but it's not important. It doesn't have to be whether it's reliable or unreliable from Laura Coster, because its importance is only what impact it would have on Julie Jensen. So there's no hearsay or reliability assessment at all involved in it. It is to be examined in its reliability, beginning with Julie Jensen. And with Julie Jensen, it's a non-testimonial statement not being offered to prove the truth of the matter asserted. And it goes to Mrs. DeFazio, who is here on the witness stand being examined on her oath. Hearsay's got nothing to do with it. Absolutely nothing. So you can start your argument, and I'll hear you, but don't start with hearsay because that's not in the picture.
Judge, what is passed, I will move on, but when you're talking about reliability, it matters how many people in the chain, whether you want to call it hearsay or not under a hearsay definition. But when the court says that, or suggests, Mr. Jamboy says that that the issue is whether Julie Jensen's delusional. What Laura Coster thinks about her brother doesn't make anything to do with her frame of mind, whether she's delusional.
You're absolutely right.
Or more likely or not. And that's all Dr. Spiro.
You're right. What Julie Jensen thinks about, or excuse me, what Laura Coster thinks about her brother, you're right. It's got nothing to do with whether Julie Jensen's delusional. But what Julie Jensen thinks is what is relevant. And what she thinks is going to be based in part upon what Laura Coster says to her.
Judge, the issue, it isn't. That ultimately is the delusional aspect of it. I mean, there's no delusional if Mark Jensen, if the jury finds that the prosecution's allegations are accurate, then they'll be finding, I gather, that she's not delusional. But whether she has this mental condition or not, it doesn't matter what she was told by Laura Coster.
It certainly does.
In what? And I'll ask, in what sense? Why?
In the sense that if there are pieces of evidence that one can put together and make a logical conclusion about a fear, then it takes it out of the category of being delusional. It becomes a normal, psychiatrically normal fear. It's not a delusion at all. Now, whether the base information is correct or not if the president came on television and said that there are armed forces from Monaco are invading the United States right now, it would not be delusional for me to think, well, we're under attack. But if it turns out that that's not an accurate statement, that has nothing to do with whether I'm delusional in thinking that maybe the country is being attacked.
Well, Judge, I don't see anything in Dr. Spiro's.
Let me read the report again. Let me read it myself. Mr. Jambly's hand it up here.
Okay.
Belief.
So, wanted to play a little bit of that because one thing about Judge Schrader, some people hate him, some people love him, but it gives you guys a little bit of insight into why some of these things are being objected to, because we're not really hearing like a lot of argument like you heard in 2008. You're not hearing a lot of explanation by Judge Milosauskas on why he's ruling against a certain thing, where Judge Schrader just loves to explain. But it's interesting because we do get an inside look at why these things are not coming in and why they might be coming in. Schrader likes to talk, and sometimes it's boring, sometimes it's good. It gives us that little juicy inside detail that we all wanted for our own understanding. Because when these lawyers talk, we don't necessarily know what they're saying because of the lingo that they use, and Schrader kind of breaks it down for us simpletons. So we are still on break for lunch in the Jensen case. They are expected back at 1:15. I am monitoring the feed, so we're not missing anything, chat. We will join them again shortly. A few more minutes.
The woman, his wife, that one would think that would make it less likely that the thinking is delusional. And doctor has left it rather pregnant there with whether on a rather pregnant suggestion that the court should consider whether Mrs. Jensen was suffering from delusional thinking.
Well, Judge.
Yep. If you want a cautionary instruction, I will give one.
Well, there's so many problems here, Judge. The report talks about two things in particular that causes him concern about delusions. This evidence addresses neither of those. Number one, he believes somebody not suffering from delusions would have engaged in escape behaviors. That has nothing to do with what Laura Koster has to say. Second is this feces incident, and this also has nothing to do with that either. And so it doesn't address either of the concerns that he had about delusions that caused him to at least consider the possibility. Next, Dr. Spiro did not have this information available to him because it wasn't produced to the defense until nearly 9 years later at the forfeiture hearing when we first received notes that were prepared by Susan Karaskevich of a report from Therese DeFazio from 2004, I think.
Well, let me interrupt you because I don't think it makes any difference whether doctor relied on it in the past or not. The district attorney can ask him whether or not that would make a difference in his statements about delusional thinking.
And the doctor can't possibly answer that question reasonably. He should not be sandbagged by this question. He would have to, of course, what
rule is that?
He would have to talk to Laura, the rule of fairness, and he would have to talk to Laura Koster in order to find out if it would make any difference or to even see this evidence in advance to have any ability to do that. Next, there are some categories of evidence that create such a great risk of prejudice, and this is one of them. Some some statement that goes through several different hands about the defendant's sister supposedly saying, and she denies it, that I don't know what my brother is capable of. That creates an enormous inflammatory risk here that is increased by the improper statement of questions made by the prosecutor yesterday, which greatly enhances the already enormous unfair prejudice of that kind of.
You know, we've got a psychiatrist on the witness stand saying that someone who was found dead was suicidal and unlikely a homicide case, and anything that bears on that, which is not unfairly prejudicial, ought to be considered by the jury.
It is unfairly prejudicial, as it pointing out, and how that would not, I don't think, impact an opinion. Here, again, he's not acting as a super juror. What Laura Coster, he's relying on what Laura Coster described about Julie Jensen's mental state.
Laura Coster left out something of significance, like I told my sister a week and a half before, that my brother would be capable of killing her. That isn't something that Laura Coster should have included?
Because she denies saying it, so it would be difficult. It would be difficult to include that. And not only that, it was something that Therese DeFazio left out of her interview with Detective Ratsberg, left out of her written letter to Detective Ratsberg. That becomes unfair prejudice. It does say something about the probative value of that information when it doesn't come out for 5, 6, 8 years.
You have to understand something. When you say that Laura Coster denies it, the jury has to weigh that against the testimony of Mr. Voigt, if he supports it, and Ms. DeFazio, if she supports it, who are the living representation of Julie Jensen in this courtroom. That's the law.
Well, it is not necessary. No, the law, there is no law that says that it's admissible. The problem is, Judge, is that maybe the jury decides it, but it's the allegation that she said it that in itself is so prejudicial, and the difficulty in responding to that kind of allegation that is unfair prejudice. That is what offends due process, is when there's not a fair opportunity for the defense to respond to something, or whether just the insinuation of the question can create such an impact on the jury that no possible evidence to the contrary can get rid of that taint. That's unfair. And that's what 90403 is directed at, and that's what the due process clause of the state and federal constitutions is directed at.
I am well aware of the risk presented by this evidence, but as I said a moment ago, under the law of the United States, Crawford against Washington, the law of the state of Wisconsin, State versus Jensen, Ms. DeFazio, if she supports this statement, is the conduit by which the voice of Julie Jensen is heard in this courtroom.
I'm going to pause right here. They're going to be coming back here shortly, so this is a good time to kind of just break this. What's interesting to me about this statement by Judge Schrader, okay, and he just mentioned this iconic U.S. Supreme Court case, Crawford v. Washington. So for those of you wondering, oh my God, why is this letter not allowed in this trial? It's because of that case, Crawford v. Washington. That changed in 2004 to the Sixth Amendment Confrontation Clause. And that is what got Mark Jensen a retrial, that this letter from the grave, as well as 2 voicemails left for Officer Ron Kosman by Julie Jensen, were not allowed in this trial. Now, a lot of you have said, well, of course they weren't, because he unalived her, so he couldn't confront her. Well, the U.S. Supreme Court said a little bit differently. We did read that entire case and the whole breakdown and all these things in our background stream. I believe it was like the first day when they were doing voir dire. We did this whole full deep dive background on the case to give you guys all this juicy details. But what's interesting is that changed in 2004. This case gets tried in 2008, and here Schrader is, I know the law so well. Well, Judge Schrader, if you know the law so well, because he is like a law historian, why did he violate the United States Supreme Court ruling? the change in the confrontation clause under the Sixth Amendment. Schrader thinks he made the right call during this trial, even though it was, overturned by the Wisconsin Supreme Court, hence granting Mark Jensen this retrial. Schrader thinks that the U.S. Supreme Court made an error. But it is interesting that he knows this law so well, and he has to know the change of the law. He had to have read that entire case, Crawford v. Washington. So it does beg to question, why did he let these evidences in? Now, us as layperson, sometimes we don't understand these court rulings, and we're like, man, that is a critical piece of evidence. That is so damning towards the defendant. And we think as lay people that this is unfair. This should have been allowed. But we have to protect those rights. We have to protect what the Constitution says. And those are big things that we do on this platform. We expose civil rights issues. We expose corruptions within these different types of systems so that as American citizens, the government cannot overpower us and take those freedoms and rights away from us. So we deep dive into those types of things. That's why for us, chat, this case is a really good case for us to cover on this channel because it does talk about a lot of the subject matter that we discuss here. Also, I'm from Wisconsin. I'm from Kenosha, so this is a big case for us over here as well. There's a big, giant level of importance. Kenosha residents are fuming that this case is being retried. For the first time today, we have saw the state fight back. They have put on some good witnesses that I think don't look good for Mark Jensen. I think Bobby Boy realized he was losing and he needed to make a serious change in his tactics. So far today, the first half of the day, I think they're doing a killer job presenting their case in chief that Mark is guilty of first intentional homicide. And I'm not sure that the defense is coming back, crushing these witnesses like we've seen in previous days. So they are late again. I don't know why. They're usually on time, but that's all right. It gives us a little moment to chat. Be sure to hit that thumbs up on YouTube, subscribe to the channel, hit the bell for all notifications. Make sure you have your notifications turned on your phone and the back end of your YouTube. If that toggle's not switched, it doesn't matter if you hit the notifications, you won't get them. So make sure the back end is that too. And on Facebook, like and follow. If you're not on one or the other platform, go over there, do all that fun stuff. Share the stream, chat. Please, please, please share the stream. Let's, keep building this little community here. A lot of people are used to our platform with protests and all of that stuff. Protests are dead. They're no longer. Now, it's all about trials. It's all about the juicy stuff that happens in these trials that we are all just so glued to. Now, I did this morning build a second YouTube channel that I'm trying to build that it's only for trial coverage only, because again, some people don't like about talking about civil rights and corruption and all of that. And we get it, chat. We get it. It's not for everybody. They're controversial issues. It disturbs our belief systems. And we're a little adult and we use naughty words, whatever. But we built the new channel and we're trying to just make that only trial coverage. So we need 1,000 subs in order to go live on that channel. So please like and subscribe to that as well. I will post that channel up on the Facebook page, but it is coming up in the chat. So in Facebook, please, spam the chat with likes and hearts, and that helps the algorithm push our thing out. Can you guys tell I'm trying to stall? They should have been back at 1:15. It's 1:24. But ask questions, chat. What do you guys want to know? Is there anything you need clarified? You can check out the playlist on YouTube under the Mark Jensen trial playlist. That's where everything to do with Mark Jensen is under. All the marathon streams for 2008, everything about this particular trial in 2023. We clip out certain things, especially some of the funny moments, just to give you guys something to laugh about. So, Rachel says, what year did the law change? 2004. Oh, my closed captions on Facebook are saying Chad, and I'm saying chat with a D. I'm saying chat, and the autocorrect is not picking it up on Facebook. That's so funny. So 4 years before the trial. Yes, Rachel, 4 years before the trial. That's what I was saying. Judge Schrader would have known this. He had to have studied the Crawford v. Washington case and what the Supreme Court's ruling was. So it's interesting that he still allowed these confrontational evidences in. But judges do have a tendency to misinterpret these laws. And that's why we have the appellate courts and the state Supreme Courts, and then the highest court of the land, the U.S. Supreme Court. That's why you're seeing right now Derek Chauvin, who was found guilty of the murder of George Floyd. His lawyers, even though he waived his right to an appeal, his lawyers are fighting hard in the appellate court to get him a new trial. If you guys are unfamiliar with what that appeal is all about, that's also up on the YouTube channel. Another controversial subject. We don't need to be posting our comments about it right now because we're discussing Mark Jensen, but there's appeals, and that's the reason I brought it up, not to have a debate on right versus left and wrong versus right and all of these things. I don't care about any of that today, but it's up there so you can kind of see what that's about. They're appealing that conviction, and they took it to the appellate court. So that'll be an interesting case to follow as well. But that's why we have all these different types of courts, checks and balances. When we don't like decisions, we go to higher courts to see if we can have those decisions overruled. The Jensen case went back and forth between multiple judges in the Kenosha County Courthouse. And then people didn't like those decisions. They took it to the appellate courts. The appellate courts made their rulings. People didn't like those decisions. And then it was taken to the Wisconsin Supreme Court. The state didn't like that decision because Wisconsin said, nope, he gets a fair trial. Do it over again. Jamboy didn't like that answer. They brought it to the U.S. Supreme Court. The U.S. Supreme Court refused to hear the case, which then upheld the Wisconsin Supreme Court decision. If you guys are interested in reading those court documents and things like that, we did post a bunch of them on the Facebook page. I know sometimes you guys like reading those juicy criminal complaints and court docs and all that stuff. So we do our best to get those things and post them for you. Now, we do have the state's witness list as well as the defense's witness list. I don't post those things publicly just because it's got a lot of addresses and things like that. Even though under Marcy's law, the victims' addresses are redacted from those lists, but just because we don't really want people, knowing where other people live, for a moral reason, I don't post those things, that it's going to be massively shared and all of that. But if you want to read that, we do have the state's witness list up on our Patreon. We will post the defense's witness list once they start their case in chief. That's on our Patreon as well. That's another new platform that we're starting to try to build. We want to be able to put some really, really exclusive content for those that want to financially support Never Stop Media and put really exclusive things on there. Do some really fun things on our Patreon for our supporters. You can join as a member on YouTube. It starts at 99 cents, and you get tons of exclusive member-only content on YouTube. There's 3 different levels, I believe we set it up as 99 cents, $2.99, and $5.99. And each type of level, you get access to more and more things. So another great way to support the platform and all of the content that we put out. A lot of these monies go towards filing open records requests and conducting our actual investigative stories that we put out. If you guys are interested in those types of stories, you can go to our website, Never.Stop.Voices.com. Some really, really good articles up there. Again, very controversial, though. It will challenge your thinking. Some of it, you're going to drop your jaw and be like, oh, my God. Because I'm from Kenosha, we investigate Kenosha pretty hard. There is a lot of corruption in that city, unfortunately, within our law enforcement and judicial system. It's sad, it's unfortunate, but we have to expose it to keep things fair, get rid of the bad police so that our good police officers can be safe and do their jobs that they really want to do in protecting us citizens, and keep the judges on their toes and not be violating people's rights in the courts, and keep that system very, very honest. Unfortunately, chat, we know these things happen, right? We know like Serpico. We know Baltimore, where the entire like drug task force in Baltimore was, they're all in prison. So we know, unfortunately, these things happen, chat. And unfortunately, sometimes we cannot trust our news sources. So that's why you're seeing all these independents popping up and this kind of independent guerrilla style of journalism. And we're not afraid to ruffle feathers. We're not afraid to get in there. Like how you used to see with journalism, when journalism was pure and honest and there was integrity. That's what we do. Here they come, chat, finally. 131. Jeez almighty. We are coming back to it. Be sure to share the streams. Hit the thumbs, hit the likes, all of that stuff. And please comment in the chats. We like when people comment. It provides a lot of commentary and discourse and a fun community for everybody. Get to know each other. Come say hi. Thank you all for following today. We appreciate you all being here. Let's go, chat. I know you're tired of hearing from me, so let's get back to the Jensen trial.
All rise for the jury.
We're back on the record on Mark D. Jensen, 2002 CF 314. The appearances are the same. Mr. David Thompson is still on the stand. He's still under oath. We're going to start with the cross-examination. Who's going to do that for the defense? Go ahead, Mr. Perry.
Thank you, Judge. Mr. Thompson?
Yes.
When you arrived in the Kenosha County Jail, that was on September 6th, 2007, right?
Yes.
And you mentioned on direct that you were there for some bank robberies.
Mm-hmm.
Can you say yes?
Yes.
You had robbed a bank in Gurnee, Illinois in June of 2007.
Objection. This is irrelevant. It's up. The defendant was asked about his prior record. And he
I agree.
Excuse me. I mean, maybe we could be heard outside.
Yeah, I think you get a break within 30 seconds, bro. You can have a seat, Mr. Thompson. The jury's outside of the courtroom. I'm looking at 90609. Indicates the witness can be asked whether the witness has ever been convicted of a crime. Number of such convictions, if the witness's answers are consistent with the previous determination of the court, I believe it was 10 for Mr. Thompson, then no further inquiry may be made unless it is for the purpose of rehabilitation the witness's character for truthfulness.
Judge, Mr. Thompson on direct didn't just say 10. Mr. Jamboys elicited what they were for. Secondly, this goes to motive in terms of the deal that he worked out. And this was discussed at that pretrial motion regarding other defense requested impeachment, and the court said about the bank robberies, and that was impeachment that the defense had available to it. And so all of that goes toward what he was facing. It's really the same as the prior witness earlier today in terms of what he was facing and the motive for reaching out to the prosecution, and also the motive that he's explained in terms of with his lawyer of trying to work something out. So for all those reasons, including the pretrial motion hearing discussion about this very topic and the ability to go into it, is the reason I asked those questions.
Do you want to say anything, Mr. Chambers?
None of those things have anything to do with he was asking him specific questions about the specific bank robbery. All that was asked of him on direct was, you were in there as an accused bank robber, right? And then I asked him about the relative status of bank robbers to other inmates. And I did ask him a few questions about what he was expecting to get out of this. Now, if he wants to ask about his time cuts, I've got no problem with that. But asking him specific questions about what he did in each specific prior conviction, that's off the table. That was not agreed to. And he's not asking him, well, how much time are you facing because of these alleged bank robberies? And what kind of a benefit were you expecting from the state? He could ask about that, but he can't ask about specific instances about each one of these prior convictions.
I agree. You can ask the deal that he got, what he thought about it, what time he was facing. But under 90609, you can't get into the specific convictions, the actual facts of what was the conviction for under 90609. I mean, you got plenty of leeway is what I'm saying.
But
the jury knows he got charged with bank robbery.
Well, he was facing charges more than bank robbery, which is what I'm going to go into. And that's part of his motivation for saying is time to help myself in terms of all that he was facing.
So you're telling me he was facing other charges he wasn't convicted of?
At that time, yeah. And he was at that time still facing charges for bank robbery. So those weren't convictions, and I'm not asking him, and then you were convicted of it. It's in terms of what was happening at the time that he decided to help himself, that he came up with this plan, at the time that he reached out to the prosecution, and at the time that he then testified, and what it was in exchange for, and then the benefit he got for his testimony. And so because of that, that's the motive evidence. So it really falls outside of 90609, despite the fact that with that, he didn't limit himself to just the answer. He said what two of them were for, or one, he said, for bank robbery, when in fact, it was for things, bank robbery plus other things.
So you're saying other charges that he was not convicted for were dismissed?
Yes.
And that was part of the agreement that he got based on for his testimony.
He got a letter, and as a result of the letter, things got dismissed.
Your Honor, I will say this. First of all, he was facing federal bank charges. There was no state pending disposition. There was nothing that I could do directly. I did write a letter on his behalf. If he wants to ask questions about the letter that the state wrote on his behalf, go for it. But what's that got to do with the specific crime, about the specifics, the specific facts about a particular bank robbery or about any other particular crime? Now, if he wants to ask him, in addition to a bank robbery, were you facing other charges? If he was facing other charges, he can ask him about that. But he can't ask him about the facts of each one of those charges. Just, you're facing other charges. And what happened as a consequence of you assisting the state? And I wrote a letter, and that's all I could do. I didn't arrange for any charges to be dismissed. And if charges were dismissed, I guess that's news to me. I didn't know the charges were dismissed. But if they were dismissed and he knows about it, but that's got nothing to do with the individual facts of what going in and robbing a bank or whatever the other charges were that he's talking about.
If I could respond just once more to that.
Go ahead.
With the bank robberies, he's testified before, and I believe he would testify consistent with that those were acts of desperation. All that he had on the line when he committed those, and we compare that to what he had on the line when he saw Mr. Jensen and decided to help himself with this. And that goes also to, whether or not some of these details of him being able to be considered an armed career criminal, which enhanced the amount of sentence that he was facing in the federal system of, I think on one of them, 30 years to life. And so those details go to motive.
Well, but they're not details of this crime, and there's not details that the state inquired into, because I don't know anything about that stuff. I'm not a federal prosecutor. I will say this, Your Honor, his attorney reached out to me, and I wasn't interested in what he had to say because there's more, jail inmates wanting to talk about Mark Jensen. But then I heard the phone recordings. After his attorney approached me, then I heard these phone recordings that the court's going to be hearing next, not the ones that the court's already heard, where he's talking to family members about this. Then I wanted to talk with David Thompson. So the only deal that was made with David Thompson was, you come forward, you testify truthfully, the state's going to write a nice letter on your behalf. I'm not a federal prosecutor. I couldn't promise him anything with regard to the federal charges. Now, he was clearly hoping to get something out of it, but the specific facts of those particular charges have nothing to do with his testimony, nothing to do with his credibility. What does have something to do with his credibility that he can inquire into without violating section 906.09 is, okay, you were facing federal bank robbery charges, and then there was also apparently some other charges. As I'm sitting here, I don't even know what they were. And as a consequence of your participation in coming forward, you got a deal on that. And what was the deal? And he can ask what the deal is. I think we've got the letter here somewhere that we wrote on Mr. Thompson's behalf.
I'm not interested in Mr. Jamboy's motivation. I'm interested in Mr. Thompson's motivation. And that's what I want to inquire into in terms of what he knew, what he was facing at the time, and the reason for why he wrote to his kid's mom, it's time to help myself. And, in the 90609 thing, I argue it's wide open when on direct, it was elicited not just, have you ever been convicted of things, how many times? He went into specifics, and it was an incomplete specific that he went into in terms of what he was there for. And so it's what he was actually there for and the seriousness of why he was there and all that was over him, motivating him to have to help himself.
Well, I agree with both attorneys. Kind of a strange ruling, but here, 90609, it's pretty specific. It says you can't get into it once the defendant says, I have my prior convictions, and there's case law on it. I'm not going to say 90609 doesn't apply. I don't have that authority. I'm not the Supreme Court. But the defendant already said he was in for a bank robber. We know that, but he didn't get into the actual specifics of his case or the facts. And that's where I think the defense is walking on in a ground where I'm not going to let them go. You can get into this deal that you think that he got. I'm not going to stop you from doing that. But you can't just get into the charges and start going into the factual basis of the charge. And that's what the state is objecting to. You're going to go and say, well, this is what he did. This is how the armed robbery happened. And basically tell the jury what I can't let you do. Now, you have an obligation to talk about credibility in the deal that he got. I'm not going to stop you there, but I'm going to stop you if you start saying, yeah, well, this is the armed robbery, just like the question you asked before the objection came out. Well, I don't know the exact facts that you mentioned, but you started to get into specific facts of the armed robbery. And that's not where you're going to go.
I will just to complete my record on this. I I'd object to this limitation and on a couple of ways. And in that November motion hearing that we've talked about earlier in this jury trial, and the state talked about its motions in limine in particular. They said at that hearing, we don't have any problem with Judge Schrader's prior rulings except for these enumerated things, okay? And all of this that I was about to ask him, all of this came in 2008. All of these
Facts of
details.
the armed robbery?
Yes.
But Your Honor, here's the thing.
I have page citations for everything that I'm about to ask Mr. Thompson.
And was there an objection, and did the court actually have to rule on it? The fact is, in August 14th of 2017, the defense filed a motion to compel discovery of documents related to prosecution informant witnesses, and this witness is one of them. And with respect to David Thompson, their representation was, at the time of the Jensen trial, David Thompson was awaiting sentencing on 2 federal bank robbery charges following a guilty plea, which he'd entered on January 14th, 2008. At the time, he was facing 68 years to life imprisonment, and Mr. Thompson testified that he did not believe that Mr. Jamboys had jurisdiction over his federal cases, which were in Illinois, but they'd already signed his plea agreement, and they'd not been offered anything in exchange for his testimony in the Jensen case. He did not receive any concessions from the U.S. attorney as a result of his cooperation. However, during an October 10th, 2007 interview with Mr. Thompson, Mr. Jamboys told Mr. Thompson he would be happy to write a letter to the judge describing Mr. Thompson's cooperation, participation, and his agreement to testify. Mr. Thompson also told his fiancée over the phone that he expected credit for his cooperation in the Jensen case. All of those things are appropriate to talk to him about on cross-examination. So he was apparently, at the time he was incarcerated, he had already pled to 2 bank robbery charges that had occurred in the state of Illinois. There were federal bank robbery charges. And at that time that he was being interviewed, or the time he was testifying in 2008, I was a special prosecutor in the state case of State versus Mark Jensen. So I would have no direct ability to influence that beyond doing what I promised to do, which is write him a letter and write a letter on his behalf, and which I did. And he's probably got a copy of that letter. And in that letter, I indicated that Mr. Thompson testified truthfully and that his testimony was important and that it benefited the state.
Let me look at that November 21st hearing again, just for a second here.
November 21st. Okay. Can you pull it up?
See anything in that hearing where I said you can get into the actual facts of the bank robbery? I told you could get into the convictions and the consideration that he got.
Well, I'm combining that with the representation from the state that the only things that they would be objecting to from prior rulings from Judge Schrader were enumerated in their motions in limine. And I believe you said there's plenty of impeachment with these bank robberies and all that he was facing. So that's, I don't have it right in front of me.
I have it in front of me.
Okay.
I just read it.
I mean, this is motive. It's honestly with these, the details of the bank robbery, there's later where he's lying to the FBI. That's 90608 sub 2, specific acts of untruthfulness that I'm allowed to ask about. It's all the details of what he was facing when that motivated him. I'm not asking, I'm not going through, we settled on 10, right, for prior convictions. The details I want to ask about are the ones that he was facing at the time that he reached out, that he wrote this letter to his kid's mom.
And like I said, I'm not going to deny it, but I don't think you can get into the facts of the conviction under 90609. Unless you got a case that says that the judge doesn't have to abide by that statute anymore.
Well, if I could have just a couple of minutes because when the answer wasn't limited to just 10, it was a specific answer about what some of them were for. I believe that opens
He
that up.
didn't deny the 10. He didn't
No, he-
say 9 or 8 or 12.
Agreed. But then it was, what is it you were in the jail for? And he said, bank robberies, or you were in the jail for bank robberies. And that's an incomplete answer. And it's, it's the question that was asked, but it's a misleading impression when he was actually there for bank robberies, for being felon in possession of a firearm, for marijuana possession, for a theft of a firearm, for receiving stolen property, and for another theft in Wauwatosa in Milwaukee County.
Okay, Your Honor.
All of those things he was facing when he got to the Kenosha jail on September 6, 2007.
One more response, and then we're going to go. Go ahead.
So my understanding is that he was in the Kenosha County Jail as a federal inmate as part of a contract that we had with the federal government, and that on January 14th, 2008, he had pled guilty or no contest or whatever he pled to 2 bank robberies in the state of Illinois. And he was awaiting sentencing on those charges. And that's why he was in the county jail. Whatever Waukesha had nothing to do with his custodial status at the time that he was involved in his conversations with Mark Jensen. He was awaiting charges on bank robbery, and he was a federal inmate. So if there were charges in Waukesha County, that wasn't why he was in the Kenosha County Jail. He was in the Kenosha County Jail as a federal inmate, and he pled to that. He pled to 2 bank robberies on January 14th, 2008, without any agreement from the state of Wisconsin and without any agreement from the federal authorities, apparently. He just pled to those 2 bank robberies. So that's what he's being held for at the time that he was being interviewed that he was involved in this conversation with Mark Jensen. And if it's about his motive, if it's about his credibility, his motive to assist the state, what he wanted from the state was a letter to the federal authorities describing his participation. That's all he got. And so these other charges, first of all, apparently they were dismissed. He wasn't convicted of those charges. And if he was convicted of those charges, it's part of the 10 that he's already testified to. So he can't go into those things. He can go into the reasons that this witness may have wanted to assist the state.
I think that Mr. Jamboys is understating the influence a letter from a prosecutor in a homicide trial has on other cases in terms of its benefit. And that was understated, I think, this morning when Mr. Dillard was testifying, in terms of it was just a letter or whatever it's going to be right now. And I think it's understated right now because it resulted in the Washington County thing where he was facing several years being just simply dismissed.
But did Mr. Jamboys write a letter to that prosecutor?
Yes, I believe so.
Your Honor, I wrote the 2 letters that I wrote are right here. I was chief legal counsel at the Wisconsin Department of Transportation. I wrote a letter on March 11, 2008, one to Attorney Clifford Green, who was, I believe, Mr. Thompson's defense attorney. And I wrote, and I'll file these as exhibits. Dear Attorney Green, I've been informed that you are the attorney representing David Thompson. I prepared this letter and would appreciate if you would provide it to Judge Wayne Anderson prior to Mr. Thompson's sentencing. Thank you. Sincerely, Robert Jamboys. Then here's the letter that I attached. And this is a letter to the Honorable Wayne A. Anderson, Bloomberg Federal Courthouse in Chicago, Illinois. Dear Judge Anderson, it is my understanding that David Thompson will soon be standing before you to be sentenced for his role in 2 bank robberies. I don't know anything about the circumstances surrounding those 2 incidents. However, I do think you should know that David Thompson recently testified in the case of State of Wisconsin, State versus Mark Jensen, 02 CF 312 I have here, and it's actually 314. During the course of his incarceration in the Kenosha County Jail, Mr. Thompson became acquainted with Mark Jensen, who stood accused of the murder of his wife, Julie Jensen. Mr. Thompson testified in the Jensen case that Mark Jensen had solicited him to arrange to have a witness named Ed Klug, quote, sat on, unquote, or kidnapped in order to prevent Mr. Klug from testifying. The state had intercepted and recorded telephone conversations between Mark Jensen and various family members, which corroborated Mr. Thompson's testimony. I stress that Mr. Thompson never actually intended to participate in a kidnapping scheme. Rather, it was his intent to induce Mark Jensen to participate in such a scheme so that he could testify on behalf of the state in this matter. I believe that David Thompson testified truthfully in this matter. Furthermore, he was of substantial assistance to the state in the successful investigation and prosecution of this murder case. I do hope that you will consider this as a mitigating factor when deciding upon an appropriate sentence for Mr. Thompson. Now, that's what I did. And at that time, as I said, I was chief legal counsel at the Wisconsin Department of Transportation. I wasn't even a prosecutor anymore, but I had been the special prosecutor in the Mark Jensen case. As you recall, I'd left to go off to be chief counsel at the DOT. Now, in terms of, he can ask Mr. Thompson what sentence he was expecting to get when he entered the plea, and then what sentence he got, and whether or not this letter was of benefit. But it really would be purely speculative for Mr. Thompson to try to anticipate the impact that this letter had on the judge. And it would also be purely speculative for this court to try to assess what impact this letter had on the judge. But I would move the first letter to the defense attorney in as an exhibit, and the second letter to Judge Anderson as an exhibit. I don't know what the exhibit numbers are, but I'll provide them to the clerk right now, and I'll sure she can.
The attorney that represented him on the federal charges? Or?
Yes, sir.
All right.
Attorney Clifford Green. I presume that it was. I don't know, but I wrote it to him, so I imagine I was told he was a defense attorney.
So we don't have any other letters that you wrote regarding Mr. Thompson for consideration. So why are you telling me there's another letter?
Well, it was my understanding that there was another letter detailing cooperation, that Mr. Thompson is aware of that he received a benefit from it. The Washington County stuff all got dismissed.
Where's the letter?
Well, I don't have it in front of me. I don't have it. I believe that we are looking too far down the road, that the motive that makes this relevant is the information, the knowledge that Mr. Thompson had on September 6th, 2007, when he decided he would help himself by proposing this suggestion to Mark Jensen, and then by reaching out to the prosecutors. And all of that is his motive. I'm not suggesting that Mr. Jamboys contacted him in advance and said, if you come up with a plan, if you talk to Mark Jensen, this is what I'll do for you. I'm saying it's the other way around, that Mr. Thompson had storm clouds had gathered in terms of everything that he was facing, and he made a decision, and then whatever he got out of it with the state, he got out of it. But the things that he was facing at the time that he made that decision is motive evidence, and that's always relevant.
Well, I don't disagree with, he's getting a deal or whatever legal term you want to use. Like I said, I'm not going to stop you from going there, but you're talking about some letter to a Waukesha court of judge that doesn't exist. It's not in evidence. We do have the two letters that Mr. Jamboys wrote. Obviously, that's all relevant. And as indicated, the Waukesha charges were dismissed or not convictions. So everything you tell me is the opposite of 90609. If it's not a conviction, it's not coming in.
Because it's not 90609 evidence, because it's motive evidence.
I'm not stopping you as to motive that he got the consideration. So you can go there, but you're not going to get specific.
So I just want to be clear, I understand where the court's drawing the line, okay? So I can get into what he was facing, not specific factual allegations of what he was facing.
I don't want you reading the criminal complaints is what I'm getting at. And that's what you started to do.
Well, actually, I said that he had robbed a bank in Gurnee, Illinois in the date. But
that's what's in a criminal complaint.
Yeah, it usually is. It ought to be. If it was a bank robbery from June of 2007, and this is the maximum penalty we're facing.
That's fine.
All okay?
Yeah, that's fine.
The things that he didn't testify about that he was facing, maximum penalties, all fine?
If it's part of the deal, it's fine.
Wait a minute. The things that he didn't testify about, what are you talking about? I don't understand what you're saying. I mean, my understanding is this. You can ask him what his motivation. He was facing significant imprisonment on 2 bank robbery charges. At the time of his trial, at the time of the trial where he testified in this case, he'd already entered pleas. He already entered pleas to 2 bank robberies without any agreement from the state at all. It was an agreement between him and the federal authorities. And then, so he was facing sentencing at the time of this trial that he testified at in 2008. He hadn't entered the pleas at the time that he reached out to the state and was talking to us about his conversations with Mark Jensen. But he negotiated apparently some kind of an agreement with the federal authorities without utilizing anything from this office. And so at the time that he was testifying, he'd already pled to 2 bank robbery charges.
I don't care what he had pled to at the time of testifying. I care about what he was facing on September 6, 2007, when he put this plan into motion and came up with it to help himself.
We're done talking. You can get into the charges that he was facing. You can't get into the actual facts according to 90609.
Okay, so with the clarification that I asked for earlier.
I'm afraid to listen to you because we're going to continue.
It's all, okay, I don't want to, I understand the court's ruling, I think.
I mean, like I said, you can't say, well, by the way, you were in the bank robbery. You're the one that put the gun to the teller. You're the one that demanded the money.
I mean, I'll say
we're not going that way.
All of that came in 2008. The state knew this. The state didn't seek to exclude it, and they didn't seek to exclude it pre-trial.
But I still can make a ruling, can't I?
You can. But in terms of other rulings in this case, especially when the state had represented at that hearing, that all fine with rulings from Judge Schrader, the ones we're not, we've got this enumerated list of motions in limine.
So, Your Honor, I just want to say this.
Should be able to rely on that.
He's talking about these Washington County cases. The complaint in the Washington County case was filed on October 11th, 2007. So it was a month after he'd already been having these conversations with Mark Jensen. So there's no possible way that his ultimate whatever happened to him in Washington had anything to do with this. He didn't even know about the charges in Washington in September of 2007 because the charges weren't filed until October 11th, 2007.
It's news to me. Nobody told me that.
So now, well, we just started looking it up because I had not thought he was going to be asked questions about this Washington because the only charges he was facing at that time were these charges, these federal bank robbery charges. He was there because he was a federal inmate on these 2 bank robbery charges, which has nothing to do with Washington. And that's why this is so unfair. You know, we did have these rulings. We did have these arguments in advance. We're not supposed to be having this conversation now. And we're having the conversation because he ignored the court's ruling.
Well, I'm shocked to find out the complaints were filed after.
They weren't. I mean, well,
now you're telling me they weren't. It's got to be one or the other.
The filing date, the date of offense predates when he got there in terms of what he had been arrested for.
Where they filed. You guys got to have CCAP records.
The offense date was August 26,
I'm
2007.
not talking about the offense date. I'm talking about when the complaint was filed.
The complaint was filed in October of 2007. His knowledge of what he had been arrested for, what he was facing, and all predating
the complaints weren't even filed
his
yet.
Testimony.
They weren't even filed. You're acting like he's on the Supreme Court of the United States. All this legal. If they were filed afterward, we're not going to get into them.
If I could have just a minute to
We're done.
double check.
I'm going to give you a minute to get ready, and I'll bring out the jury. I let you make your record. I think I was patient enough. Okay, bring out the jury.
All rise for the jury.
All right, the jury's back in the courtroom. We're back on Mark Jensen. The appearances are the same. Thank you for your patience, ladies and gentlemen, and you can continue with your cross, Mr. Perry.
Mr. Thompson,
Yes.
you testified on direct that when you got to the Kenosha County Jail on September 6, 2007, you were there because of federal bank robberies, correct?
Yes.
Do you know what you were facing in those federal bank robberies?
Well, the maximum penalty was 20 years apiece, but I was only facing like 5 years.
You only thought you would get like 5 years.
Well, I figured it out through the sentencing guideline sheet that according to all my convictions, I was only looking at the maximum of 60 months.
Okay, you were facing 20 years for each bank robbery, correct?
Well, that's what the charge carries, yeah. But when you do your federal guidelines timesheet, it tells you exactly how much time you'll be getting for whatever charge you have.
When you were in the Kenosha jail facing years in prison on these bank robberies, you had a child at home with your fiance, correct?
Yes.
That's who Kim was, your
Yes.
fiance?
Well, no, she wasn't my fiance. She was just my girlfriend. We weren't, engaged or anything.
How long have you been in custody as of September 6, 2007?
September 6th, I had just got into custody then.
Fair to say that money was tight at home?
Yeah, somewhat. Actually, yeah, somewhat. I think more so I was just being greedy, that's all.
You were being considered an armed career criminal.
It was in consideration.
An armed career criminal would make you face 30 years to life.
In feds, yes, absolutely.
You got there on September 6th, and we heard these phone calls that were dated September 11th and September 12th, right?
Yes.
On September 8th, 3 days before that first phone call, you wrote a letter to Kim, right?
Yes.
In that letter, you said, "It's time to help myself."
Yes.
And by the time you wrote that letter, you had already put together a plan.
Somewhat of a plan, not a solid plan.
Because on the second or third day that you were in the jail, you learned that Mark Jensen was a defendant in a high-profile case.
Yes.
And you knew people had been beating up Mark Jensen.
Yes.
You knew he was getting beaten up and that people were taking his canteen money.
Yes.
And I don't know if everyone knows what canteen money is, but that's money for coffee, sandwiches, toothbrush, soap, really anything you might want to buy at the jail, right?
Yes.
And you knew that people were just kind of taking this stuff from him.
Yes.
You knew he had been beaten up for not giving people his food.
Yes.
You approached him and you wanted him to make a phone call for you.
Yes.
And he didn't, right?
Yes.
And you hit him.
No, I didn't hit him.
You said you had a little altercation with him?
Yeah, he promised me on three separate occasions that he would make this phone call to me. And I told him either you're going to do it or don't do it. Don't keep lying to me. And that's what upset me.
It's your testimony that you did not hit him.
No, I shoved him. I didn't hit him.
You wanted them to call your fiance for you.
Yes.
And by the third time after the altercation, he made the call?
Yeah, I think a couple of days later he made the phone call for me. Yeah.
You asked again, you shoved him, and then he made the call?
No, not in that fashion. No, he didn't make the call until after I apologized to him and we became somewhat closer.
You told him, don't play with me.
I told him stop lying to me.
You stole his commissary too.
No, I never stole anything from him. You didn't have to steal anything from him. He would give it away freely.
He made a phone call and you took the phone from him and talked to his parents.
No.
You didn't take the phone from him?
No, I didn't take the phone from him. He gave me the phone. I didn't take it from him.
You decided to try to suggest a plan to Mark Jensen and then report it to the prosecutor.
No.
You were going to try to convince Mark Jensen to get involved in a plot, right?
No. I was just trying to trick Mark Jensen out of some money. That was my only plan.
That was how you were going to help yourself?
No, if you let me finish it, I'll explain to you how I was going to help myself. I wanted to trick Mark out of the money. That was the initial plan. Once everything got recorded on the telephone, my lawyer told me that that they recorded all the phone calls, and he told me to come forth and be truthful before I end up getting a different charge. And that's when I came forth and told everything that happened as it did. I wasn't gaining anything from telling the truth other than preventing myself from getting another charge.
You're the one that suggested this plan about Ed Klug to him.
No. I didn't even know Ed Klug, so how could I suggest a plan to him?
After you remember testifying in this case before?
Yes.
January 14th, 2008. Counselor directing you to 107. Question. Well, you're the one who suggested that. Answer. Okay. Question. True. Answer. If that's yeah. Is that your testimony?
Could you repeat that, please?
Question. Well, you're the one who suggested that. Answer. Okay. Question. True. Answer. If that's yeah.
Well, I mean, suggested what? What are you saying I suggested?
The question on the previous page, page 106. Question, well, it was your idea from what you've testified to that you were going to talk to him about getting rid of a witness, right? Answer, I wouldn't say I really initiated that plan. I just went along with what he was talking about and fed it to him.
Absolutely, I did that.
You fed him the details.
No, I didn't feed him details. He asked me a series of questions, and I gave him the answers that I thought he would accept in order for me to get the payment.
Mark Jensen had told you that Ed Klug was lying, right?
He said he was lying, but if he was lying, why did he want to get rid of him?
You tried to get Mark to put money in your commissary.
I asked him, yes. I didn't force him. I asked him.
You tried to get Mark to give you $500.
Yeah, I tried to trick him out of $500, absolutely.
You tried to get Mark to involve himself so you could help yourself with your pending charges.
No, Mark involved himself when he mentioned to me that he needed something to happen to the guy that was testifying against him. That's when he involved himself. I didn't mention that to him.
You testified on direct about what your lawyer told you to keep doing, right?
My lawyer told me to shut up before I got myself in trouble.
Your lawyer told you just keep talking to Mark about your plan.
No, where'd you read that at? You see my lawyer with that statement?
You gave a recorded interview with the prosecutors on October 10th, 2007. Do you remember that?
Yes.
Counsel at the top.
Let me get to it here, please. Oh, here we go, page 4. I think it's right here. Starting with what?
Starting with probably the 4th sentence. So I go to court and I mentioned it to my lawyer, Mr. Green, and he said, well, just keep talking to him, and if something comes up, just let me know.
Right. There you go. That's what happened. Right. Wasn't like you just said.
And so what you did is you just kept talking to him, and finally he agreed he would pay.
Well, no, he did all that before I even talked to my lawyer. All that occurred prior to that.
Well, the sentence after what I had just read from October 10th, 2007 says, so I kept talking to him, and finally he agreed he would pay to have the dude held, or if push come to shove, completely taken out of the picture.
Yeah, those were his words. Yes.
So you just kept talking to him, and finally he agreed.
No, he agreed long before that. He brought the idea to me. He said he needed something done to his guy that was testifying against him, and I said I might be able to help you with that.
Now, your plan.
Did you see those words in there, right? Where I said I might be able to help you with that, right? You do see that in there, right?
Your plan was you were going to keep Mr. Klug in his house until any trial was over.
Absolutely.
A 6-week trial.
It was all fictitious. It never was going to happen. I just wanted the money.
Your plan was this would all happen for $1,000.
Yeah, that's what I told him.
You were gonna kill somebody for $1,000.
No, I was locked up. How was I going to do anything to anyone?
No money ever exchanged hands, did it?
Nope.
The deal was that Mr. Jamboys was going to write a letter to the federal sentencing court, right?
There was no deal.
That's not a deal?
That was not a deal. It was a deal is when you put your signature on something and the judge and you accept it. That's a deal. I didn't do any of that.
On October 10th, 2007, you met with Mr. Jamboys, right?
Yes.
And in that discussion, he said he'd be happy to write a letter to the judge describing your participation and agreement to testify, right?
No, not in agreement to testify, but in agreement for my cooperation during the process of the trial. The agreement was for me to be truthful about what happened on the telephone calls. That's what the agreement was. That's what kept me out of further trouble, is testifying to the telephone calls.
Page 72 of January 14th, 2008. Starting at the bottom line, going into the top of page 73. Question. And at that time, Mr. Jamboys told you that he had told your attorney, and he's telling you this, that he had told your attorney he'd be happy to write a letter to the judge describing your participation in the case, your cooperation with the authorities in the case, and your agreement to testify. Answer, yes. Question, right? Answer, yes, yes.
Well, as you said, he told my attorney that, not me.
And you were part of this October 10th, 2007 recorded interrogation.
With my lawyer and Mr. Jamboys? No.
That's when this
all
was,
three of us?
That's
No.
when this was said.
That probably was just me and my lawyer.
You were required to be truthful to any question posed by Mr. Jamboys, right?
To any question posed by anyone on the court.
In order to get this letter from Mr. Jamboys, you had to be truthful, correct?
Of course.
Truthful was as determined by Mr. Jamboys.
So truthful as determined by my phone calls, because if I had attested to anything other than what was on those phone calls, I would have got charged with perjury.
The federal sentencing court had the ability to sentence you up to 40 years, correct?
They had the ability, but they never do.
They were considering, at the time that you came up with this plan, considering you an armed career criminal, correct?
Yes,
Where you'd be facing 30 years to life.
absolutely.
All of this testimony and this plot was part of the plan to help yourself.
No, and I'll tell you why. I was never in possession of a firearm. I never used a firearm in the commission of my crime. The firearm was found at my house, which was later on determined to be in possession owned by Kim Nicholas, my girlfriend. It was her gun. Only thing I was charged with was having a half a pound of weed and a bank robbery.
Judge, could we have a brief sidebar?
Go take a break, folks.
Whew, chat, this is juicy. This is getting spicy, this testimony. I am trying to find the timestamp from the 2008 trial of this idiot's testimony where he says he never went in Jensen's cell, so we can compare it to what he said today that he did. It's like 5 hours of testimony that I'm trying to
courtroom. Go ahead, Mr.
find that
Perry.
spot.
I didn't ask, but we just got incomplete details about what he was facing in terms of the felon in possession of a firearm and the possession of marijuana charge that that I was not supposed to go into details on. And because he's gone into it, I believe I'm entitled to ask details about that.
State want to say anything?
Your Honor, this was in response to the question about whether he was going to be charged as an armed offender in the federal charges, in the federal case against him. And he was responding that he'd not used a gun in the federal charge against him, in the federal case against him. So there was no possibility of him being an armed offender in the federal. Now, Mr. Thompson apparently he's not aware that, the stuff in Waukesha is off limits. So he made some reference to a gun in his residence, but that's got nothing to do with the federal charges.
He's been sitting right here this entire time.
Well, he did mention the firearm. So if it's connected to the robbery charge, you can get into that.
But it's not connected to the robbery charge, Your Honor, except that it's connected to whether he'd be deemed a federal armed criminal, because if his under the federal guidelines, and I don't even know what they are because I don't do federal cases, apparently if you're an armed career criminal, then suddenly you're looking at 30 years to life imprisonment. But remember, at the time that Mr. Thompson testified in 2008, he'd already entered a plea on January 14th, 2008 to 2 charges of bank robbery without any armed criminal career offender status.
I understand where you're going, but the problem I got, the genie's out of the box now when he talked about weed and the firearm to the jury.
The weed and the firearm is from Washington County.
Yeah, that's what I'm saying.
And he hadn't even been charged yet. When he was talking with Mark Jensen and when he was on the phone about this stuff, he hadn't been charged with anything in Washington.
I understand, but he just mentioned it to the jury. So I'll give you a little bit. We're not going to get into 2 hours of questioning about.
Well, I hope not. It's part of the federal sentencing guidelines. That was all part of it. So.
Just a little bit. I'll let you go because he mentioned it. So let's bring back the jury. The jury. All right, we're back on the record. Mark D. Jensen, 2002 CF 314. The jury's back in the courtroom. You can continue, Mr. Perry.
Thank you, Your Honor. Mr. Thompson,
Yes.
right before that break, I'd asked you that you were being considered to be charged as an armed career criminal. Do you remember that?
Yes.
And if so, you would have been facing 30 years to life.
If so, yes.
And you explained that the gun wasn't yours, but the weed was.
Yes.
That's from an offense dated 9 days before you got, my math is bad, 11 days before you got to the Kenosha County Jail, isn't it?
No, actually, when I got arrested on a Friday, they went to my house that Monday and conducted a search, which is when they found the marijuana and the pistol at my home. As I said, the pistol belonged to my girlfriend at the time, and the marijuana was mine. So they charged me with the marijuana and threw out the pistol case.
You told the FBI in that case that you stole that gun from a drug dealer.
Yeah, I told the FBI quite a few things.
Those were lies?
Absolutely.
You lied to protect your family?
Yes.
And you didn't want your fiance to be charged with any of that?
Well, well, not just that, but she really had nothing to do with what happened. It was all me.
Now, that case, the disposition of it would have affected your federal sentencing guidelines, correct?
It would have, yes.
That would have drastically increased it.
Yes.
In that case alone, you were facing 14 years for the felon in possession charge of a firearm.
Yes.
7 years for the marijuana.
Yes.
Objection, Your Honor. There's no evidence that the Washington case has anything to do with this
I made
case.
my ruling, and so we're going to continue limited in this area, I said.
All of that was known to you when you wrote to your fiance, Kim, recognizing Mark Jensen in the jail, learning who he was, that it was time to help yourself. Isn't that true?
To some degree, not totally true. Some of it, because prior to I had those charges when I arrived here, and I had those charges resolved before this Mark Jensen case even took place. I had already pled to that in January.
Right. I'm talking about September 6, 2007.
Well, like I said, September is the only reason I agreed then is because of what was on the telephone. I couldn't beat that. I mean, you can't deny what's recorded. So I had to tell the truth about that. I was bound to tell the truth on that.
So you'll lie when you can, but not when you can't get away with it?
Objection, argumentative.
Sustained.
Known to you on September 8th, that's when you wrote the letter, "It's time to help myself," right?
Somewhere around there, yeah, I guess, yeah.
No further questions.
Any further redirect, Mr. Jamboy?
So, Mr. Thompson, what are you facing right now?
Oh, nothing. I've been out of jail a long time now. Had several businesses and doing quite well.
So, where were you supposed to? You're here today in this courtroom. Where were you planning to be today before you were told you got to come to court?
Oh, I had school. I'm in school for human services, and missed class today.
You're missing class to be here?
Yes.
And what are you going to school for?
Human services. I'll be a drug counselor.
And you said you've had a number of occupations. Tell us about your employment history over the last 5 years or so.
Once I got released from federal prison in 2010.
Judge, I do object to this being outside the scope.
Well, you attacked his credibility. I think the state can go back into it. So let's go.
So once you got out of federal prison in 2010.
Yeah, well, I would say 2014.
2014.
I went back for a revocation. So since 2014, I've been self-employed.
So tell us about the first way you were self-employed when you first got out of prison.
The first business I had was a cleaning service in Madison, Wisconsin. I started cleaning dormitories at UW-Madison.
And when would you do that and how much did that pay?
$40 an hour.
For cleaning dormitories?
Yeah.
And how long did you do that for?
About a year.
And then what did you do?
I had a transportation company, RCT Express, where I had a Sprinter van delivering loads cross country.
And who drove the van?
I did.
And how long did you do that for?
About 3 years.
And so that was up till about 2018 or so?
Yeah.
And then what did you do?
I had another job. I worked at I had Northwoods Property Management. I had a contract with them to clean cottages and cabins on the weekends for $50 an hour. And I worked at Merrill Iron and Steel in Warsaw, and I made $26 an hour there during the week.
And how long did you keep those two jobs?
Until I moved back here in Milwaukee in 2019.
And when you moved back to Milwaukee, what were you doing?
I worked at the Hampton Inn Hotel downtown. I was the head maintenance man down there.
And when did you leave that job? Or did you leave that job?
When I started my own cleaning company back up again. Elite Cleaning Services is what I do now and outside of school.
So you're doing two things. You're going to school and you're running Elite Cleaning Services?
Yes.
So tell us what Elite Cleaning Services does.
Power washing, clean apartments for residential move in, move outs for CEOs that come in from out of town and they rent various apartments. And once they leave, I go in and I clean them up.
Now, do you clean it up yourself or do you have people working for you to clean it up?
I do everything myself.
And how much do you get paid for doing that?
$40 an hour.
So you've got this Elite Cleaning Services that pays $40 an hour and you're going to school.
Yes.
And how many days a week do you go to school?
3 days a week, full time.
So you're going to school full time?
Yeah.
And you're working full time?
Yeah.
So today all you're getting for testifying is the inconvenience of coming here and missing work and school.
Missing my class, yeah.
Are you telling the jury the truth?
Absolutely.
Were you telling the jury the truth back in 2008?
Yes, when I testified to what was on those phone calls, absolutely.
Now, you did go to before a federal judge and you did get sentenced on those bank robbery charges, right?
Yes.
Now, you were expecting to get, before you provided any testimony in this case, you're expecting your attorney and you were expecting you're going to get about 5 years?
Yeah.
That's what you were expecting to get?
Yeah, according to the federal sentencing guidelines, I was facing 5 years, yeah.
Show this letter. I'm going to show you two letters, one marked S77 and one marked S78. And I'm going to provide them to you, and then I'm going to ask you questions about them, okay?
Okay.
Have you read them both?
Yes.
Okay. Do you remember ever seeing those letters before?
Yes, my attorney had them. I had a copy of them as well back then. I don't have it now.
Let me. Now, did your attorney show you these letters before you were sentenced by in the federal courts?
Yes.
And the federal judge was the Honorable Wayne Anderson in the
Yes.
Bloomberg Federal Courthouse?
Yes.
So this is the letter that I wrote to attorney, and who wrote the letters that you were reading? Who signed
you-
these letters?
Oh, you did.
And so the first letter is to Attorney Green. It reads, Dear Attorney Green, I've been informed that you are the attorney representing David Thompson. I prepared this letter and would appreciate it if you would provide it to the Judge Wayne Anderson prior to Mr. Thompson's sentencing. Thank you. Sincerely, Robert Jamboys. That was the letter that your attorney received?
Yes.
And then enclosed in that letter was this letter. Dear Judge Anderson, it is my understanding that David Thompson will soon be standing before you to be sentenced for his role in 2 bank robberies. I don't know anything about the circumstances surrounding those 2 incidents. However, I do think you should know that David Thompson recently testified in the case of State versus Mark Jensen. During the course of his incarceration in the Kenosha County Jail, Mr. Thompson became acquainted with Mark Jensen, who stood accused of the murder of his wife, Julie Jensen. Mr. Thompson testified in the Jensen case that Mark Jensen...
I do object to the full contents of this letter being read, aside from just this letter detailing that Mr. Jamboys found him cooperative.
Well, Your Honor, they were going into great detail on cross-examination.
I'm allowed because we've had a lot of questions about supposedly what happened with the bank robbery charges, the sentence, and the consideration he was supposed to get. It's part of the consideration. So go ahead, Mr. Jamboys.
So I'll start at the beginning of the second paragraph. During the course of his incarceration in the Kenosha County Jail, Mr. Thompson became acquainted with Mark Jensen, who stood accused of the murder of his wife, Julie Jensen. Mr. Thompson testified in the Jensen case that Mark Jensen had solicited him to arrange to have a witness named Ed Klug, quote, sat on, unquote, or kidnapped in order to prevent Mr. Klug from testifying. The state had intercepted and recorded telephone conversations between Mark Jensen and various family members, which corroborated Mr. Thompson's testimony. I stress that Mr. Thompson had never actually intended to participate in a kidnapping scheme. Rather, it was intent to induce Mark Jensen to participate in such a scheme so that he could testify on behalf of the state in this matter. I believe that David Thompson testified truthfully in this matter. Furthermore, he was of substantial assistance to the state in the successful investigation and prosecution of this murder case.
Objection, Judge, in terms of what Mr. Jamboys is currently reading. If you could explain it sidebar, I'd be happy to.
We're going to stop here, Mr. Jamboys, from you reading for.
Well, I'll just go to the final sentence. I do hope that you will consider that as a mitigating factor when deciding upon an appropriate sentence for Mr. Thompson. Now, is that the letter that I wrote on your behalf to Judge Anderson?
Yes.
And you were happy to receive that letter?
Absolutely.
And that letter is consistent with the representations I made to you, isn't it? And the October 10th, 2007 interview that occurred?
Yes.
And at that interview, do you remember who was present in the room when I interviewed you?
I think it was you, I, and Angie.
Angelina Gabrielle?
Yes.
And you remember Detective Miles being there?
Yes.
I request this be marked as, that this interview be marked as, I guess, Exhibit S79.
I object to it being received into evidence with the portions that subject to redaction.
We'll wait for that then. Just remind you, it's 79, right? Exhibit 79? All right, 79. We'll wait whether it's going to be received or not.
Would you like to know the impact that letter had on my sentencing?
You know, that's a good question. That's a good point. Yes. What sentence did you get from the federal judge?
It had no weight. Judge, and had you pulled the federal files, you would see that Judge Anderson said clearly that what happened in Wisconsin, he has no jurisdiction over.
So what sentence did you get?
They gave me 47 months.
Pretty consistent with the guidelines.
Pretty consistent with the guidelines, just a little bit under the guidelines.
Well, the guidelines would have been 60 months, right?
Right, yeah.
So maybe 13 months off. The judge didn't completely ignore me.
Yeah, I mean, I went to jail in 2000 and I was home in 2010.
Yeah.
I mean, 2008 and I was home in 2010.
Federal judges aren't the only judges that disregard me, just so you know. So, but the letter that I wrote regardless of whether the judge paid any attention to it, the letter I wrote was consistent with the promise I'd made to you.
Yes, it was a good letter. Yes. Thank you.
You're welcome. Now, Mr. Perry had asked you questions about this interview. And so in this interview, you and I did ask you questions about the conversation you had with Mark Jensen, didn't I?
Yes.
So let's be clear, because you were asked questions on cross about this. Who first raised this issue about getting rid of or sitting on Ed Klug?
Oh, he did. Mark Jensen did.
So what was the context in which you raised the issue about getting rid of Ed Klug?
Me, I just
No,
tried
listen,
to tell.
listen carefully.
Okay.
What was the context in which he raised the issue of getting rid of Ed Klug? What was the conversation? What were you talking about when he raised this issue about getting rid of Ed Klug?
He was worried that because we had been talking and I kept seeing a worried look on his face. He been like asking him what's the problem. He said, I'm worried about this guy's going to testify against me, and that's when we went into the conversation and came out with what he wanted to do.
He told you the guy is coming to court against me, but he's lying.
Yeah.
And what did you say in response to him telling you that he's coming to court, but he's lying?
I can't say exactly what I said, but it was something to the extent that I might be able to help you with that.
Well, do you recall telling him, I said, well, if he's lying, then why would you want him out of the picture? Then if he's lying, the court might see that he's lying, and that would be that. Do you recall telling him anything like that?
Yeah.
And what did you say after you'd suggested, well, if he's lying, then why you want to get him out of the picture?
He never changed his stance on it.
Who was the first person to raise the proposal or suggest getting rid of Ed Klug?
Mr. Jensen.
So you're not the one who initiated that. He is.
He is, yes.
After he was complaining about Ed Klug coming to court and lying against him.
Yes.
That was your statement then, and that's your statement now.
Absolutely.
Mark Jensen first raised this issue about getting rid of Ed Klug, was it, I'm not clear on this, was it your intention at that point to try to get $500 out of him, or was it your intention to try to get him to commit to this proposition so you could use it with your lawyer?
Well, initially I wanted to get the money out of him, but once I found out that everything we talked about had been recorded and it was going to be used against me, my attorney told me that, look, you better just go in there and tell the truth.
Defense counsel on his cross-examination had asked you about this question, and I'm directing court counsel's attention to the transcript for the trial testimony. Was it January 8th? January 14th. Question, would it be fair to say you talked to your lawyer about it, right? Answer, yes, I did. Question, and then he said, just keep talking, Mr. Jensen, to Mark Jensen, right? Answer, my lawyer said that? I can't recall he said that. Okay, question, okay, do you recall page 4, counsel? When you were being interviewed on October 10th, you said, I mentioned it to my lawyer, Mr. Green, and he said, well, just keep talking to him. If something comes up, just let me know. Okay, that could be true. So then we go to that interview. So on page 4 of that interview, directing court's counsel to page 4, and going to the top, starting midway through the first line. So I told him, I said, man, look here, maybe I can help you, So he said, what? And I was like, I got to go to court, today. I'll talk to you when I get back. So I go to court and I mentioned to my lawyer, Mr. Green. And he said, well, just keep talking to him. And if something comes up, just let me know. So I kept talking to him. And finally he agreed he would pay to have the dude held, or if push came to shove, completely take out of the picture. And so I gave him a ballpark. I said, well, $1,000. Now, you remember that portion of the interview?
Yes.
And then later on, though, I said, well, anything is possible. So at that point, I'm like, man, I need to talk to Mr. Green again. But before that happened, you guys come to see me. And I told you the story when we was meeting over there. And the next thing I know, I got a mailing from my attorney saying to stay off the phone. Everything is being recorded and whatnot. So I said, okay, I'll stay my ass off the phone then. But I don't think you kind of really believed me when I told you the story at first. Do you remember then telling the rest of that?
Yes.
When you're talking to your lawyer, he said, go ahead and keep talking. Once you'd explain to him what the theory was here, that you were going to try to that you were talking to Mark Jensen about this kidnapping plan.
Mm-hmm.
Not that you were going to actually involve yourself in the kidnapping.
No, we just were talking about it, see how far he was trying to go with it.
But previously you'd sent some sort of a brief correspondence, and Mr. Green had written you a letter saying, stay off the phone because they're recording the phone calls.
Right.
Now, you weren't present when Mark Jensen then subsequently talked to his family members about this.
Objection outside of the scope of his knowledge, just by the nature of his question.
Sustained.
Well, were you present at any time when Mark Jensen talked to any member of his family about this case?
No.
Except you were present when you talked to Kim, correct?
Yes.
And you just heard those phone conversations this morning. So Mark Jensen had gotten on the phone and talked to Kim?
Yes.
And when you were talking to Kim and you got the spelling wrong on Stifle Nicholas, Mark Jensen could be heard in the background?
Yes, he corrected the spelling for me.
And also, when you were giving this address to Kim, the address for Ed Klug, that's the address that Mark Jensen had given you.
Yes.
But you didn't hear any other subsequent phone conversations between Mark Jensen and his family members?
No.
Nothing further.
Want to recross, Mr. Perry?
A few questions.
Go ahead.
If I understand your testimony, for you, the motivation was money first?
Yeah, it was all about the money from the whole time. The whole time I was having a conversation with him.
Then after you were being confronted with phone calls, did you decide, well, I better make something of this for your case?
No, when I got confronted with the phone calls, I mean, I couldn't deny what was on what had been recorded. So I just, came forth and told the truth.
And those phone calls that we heard were September 11th and September 12th, 2007, right?
Yeah, I would assume so.
So on September 8th, just 3 days before the first of those phone calls, that's when you wrote that it was time to help yourself, isn't it?
I can't recall what day it was, but I know that I wrote that letter, yes.
And it was your testimony earlier today that it was September 8th.
Okay.
In terms of whose plan it was that you just testified to, I'm going to direct attention to page 109 of January 14th, 2008. At the bottom, question, well, your plan that you were talking about was that you were going to keep Mr. Klug in his house until the trial is over. Answer, yeah. Now I go to page 110. Question, that was the plan. Answer, yes. Question, so you were just going to have somebody wait for Mr. Klug by the garage and then take him in the house and wait for the trial to be over? Answer, that's what I told Mark, but now I wasn't going to have that done. No, I had no way of having that done. Question, and Mark Jensen, you're telling me Mark Jensen thought that was a workable plan? Answer, evidently, he went along with it. He provided me with the information I needed. Remember that testimony?
Yes.
You just explained that you pled in 2008?
To my federal charges?
Yes.
Yes.
Out in 2010?
Yes. I did 85% of my time.
And Mr. Jamboy's letter got over a year knocked off of 47 months.
No, it didn't. It didn't get anything knocked off. The judge wouldn't even take it into consideration.
He said instead of 47 months, you had 13 months off of that.
Right. And the fact that I didn't use a gun in the commission of my crimes, he gave me the lower scale of the sentencing guidelines. Because I jumped over the counter and took the money. I never threatened anyone or used a gun or anything.
And
that's why he gave me the low end of sentencing.
And the gun thing in Washington County, that went
That
away.
gun was already at home. So that was Kim's gun. So they gave that to her and they just completely disappeared. I took charge for the half a pound of marijuana because it was mine.
And you didn't get any additional time in Washington County, did you?
I wasn't facing any additional time in Washington County other than those two charges.
It was run concurrent.
Concurrent to what?
The federal sentence.
Oh yeah, it ran concurrent. Yeah, but they gave me they sentenced me. Yeah, and Washington County's one made the time run concurrent.
That's right.
Yeah.
This was pretty. When you wrote, it was time to help yourself. You did that pretty effectively, didn't you?
Well, actually, Mark did.
No further questions.
All right, you're excused. Thank you.
So now, Your Honor, the state intends to be playing some subsequent phone calls between Mark Jensen and various members of his family, and the defense has stipulated the foundation for these, so we don't need to produce Detective Zielsdorf.
All right, we're gonna need a break. I need a break, folks. Go
I
back,
guess now we're gonna
relax
take a
for a
break.
bit. Don't talk about the case.
Other
The 79, I want to deal with it while we are all fresh. Who has that exhibit?
It should be over there, Your Honor.
The attorneys have a copy of the letter. Can I see it?
I don't have a handy copy. I don't have one.
You said 79. I got 77 and 78. So
Well, the letter, if you're talking about the letter, I think that was 79 was the interview.
what exhibit did you object? Yeah, you said 79 on the record.
I just objected to the letter. I don't know.
The letter is 78.
Well, 78.
All right.
Yes, but the objection, there were a couple of objections. One was an objection to the admission of 79, which is the transcript of the interview, the recorded interview between David Thompson and myself.
I think that's the wrong exhibit.
Then I misspoke then. My objection is 78. It hasn't been admitted into evidence, so.
78 is what
fine,
you're
right?
objecting to.
Yes.
Right. So 79's coming in.
Okay.
77's coming in. We're just dealing with 78 now.
My objection on 78 and my objection to Mr. Jamboy's reading this to the jury talks about the successful prosecution of Mark Jensen,
That's all stricken.
which shouldn't have come in.
I'll tell them it's off. They're not to
Well,
consider it.
Certainly that one, Your Honor, as I was reading, I was realizing, I shouldn't have mentioned that one sentence. I should have jumped to the end.
There's two sentences that are going to be stricken.
Which two sentences are they?
I believe David Thompson testified truthfully in this matter. Furthermore, he was substantial assistance to the state in a successful investigation and prosecution of his murder case. Those two sentences are out. I'll tell the jury they're stricken or not to consider it.
I'd ask actually that instead of telling them that those two lines in particular were stricken, because that just draws more attention to it, is that it be reread with those excised and that they're to consider only that information and not any other information they may have heard about the letter.
And who is going to reread the letter?
I'd ask Mr. Jamboys to read it correctly this time.
Well, I read it correctly last time, but I'd be happy to leave out those two sentences, and I'll read it correctly this time with those two sentences excised.
All right, that's what we'll tell them, that 78 is going to come in and the letter's going to be reread to the jury. That's all. You don't want me to say which sentences are stricken, right?
Right.
Okay, I'll give you back 78
Thank
then,
you, Your
Mr. Jambois. Here's 77, it's coming in. Yeah,
I mean, with the,
work something out.
I am asking for the instruction that any other information about the letter not be considered.
What was the instruction you wanted?
That any other information they received about the contents of the letter not be considered except for what Mr. Jamboys is going to be reading. into
Any
the
other
record.
information should not be considered except for what is being read to the jury by Mr. Jambois, right?
That's right.
All right.
Show you what I'm sure these are two sentences. I know you did. I should have.
Okay, chat, they are on a break. I pulled up several timestamps from different things, but I want to play this first. But for those of you that haven't jumped in on our marathon streams and all of that stuff, so we dedicated, you guys can go back and watch this stuff. We dedicated an entire stream to the jailhouse snitches, and we didn't even get through all of them because there's so many of them. Every one of those jailhouse snitches said that none of them went in Mark Jensen's cell. None of them. Aaron Dillard stood at the doorway of Jensen's cell, never went in. And they all testified that, and this part's true, that because of jail rules, if you walk in somebody's cell, like you get in trouble. You can get put in the hole for that. Like there's all types of punishments. Okay, none of them went in the cell. Bernard Bush testified to that he also didn't see anybody go in the cell. And today we hear Dave Thompson say that he did go into Mark Jensen's cell. Okay, Dave Thompson testified in 2008 that he didn't. He also testified that about he didn't read transcripts. There's newspaper thing. That's another timestamp. I'm going to try to get in here for you guys. There's a lot of shit, but I want to play this part right here. Sneaky. And I can't even believe that defense didn't catch this. I don't, this is boggling to me.
You indicated that you did look at transcripts?
No, I said he showed me some paperwork, and then he was explaining to me what they were. I didn't see anything, just pieces of paper with writing on them.
Okay. When you say paperwork, he had what's called discovery. You know what discovery is?
I don't know what it was. It was Roy's on paper that he was explaining to me off of. I couldn't tell you exactly what it was. It could have been just regular typing paper with words on it.
He had lots of papers in his cell, right?
Yes.
I mean, stacks of papers, right?
Yes.
And that's also where you would keep his commissary, right?
That's just where you keep all your belongings in your cell.
Right. And if you go for a visit, people take your stuff, right?
No, they lock your cell though.
Oh, yeah, so
I'm sorry, they lock your cell.
They lock your cell.
So nobody's commissary would be stolen during a visit?
Not if your cell is locked.
Okay. Well, there are two people in a cell, right?
No, Mark had a single cell when I arrived there.
And was his cell always locked?
Whenever he left, whenever you leave a single cell, the cell is always locked.
But in the double cells, people can get at your transcripts, right?
Yeah, in a double cell, yes. Your own cellmate can get at your transcripts.
Right. And you were aware that Mark had been in a double cell, right?
Yes, prior to my coming there, I was aware he was in a double cell.
Right. And the scuttlebutt was that people were looking at Mark's paperwork, right?
And people were doing a number of things from what I've heard, yes.
And there was, because this was probably the most interesting case in the jail, right?
I don't know that.
Well, did you hear of a more interesting case than that one?
No, that's the only one that I've heard of. So I couldn't say that it was the most interesting case in the jail. It was the only one that I heard of.
I mean, the inmates were talking about Mark Jensen a lot, right?
I don't even know. We were only around 10 people. So I wouldn't know what the other inmates were talking about other than the ones on our pod.
And were they talking about Mark Jensen?
No.
Oh, they didn't talk about Mark Jensen?
No.
You didn't talk to Mr. Bush about Mark Jensen?
Mr. Bush talked to me about Mark Jensen.
And you were completely silent?
I mean, how could I speak of something I had no knowledge of?
And Mr. Clanton talked to you about Mr. Jensen?
Not at all, not to me.
And no other inmate ever talked to you about Mark Jensen?
They just stipulated, that, yeah, that's dude killed his wife, that's it.
And you never talked to anybody else about Mark Jensen?
I couldn't. I know nothing about Mark Jensen.
Have you not been saying that you were talking to Mark Jensen?
This was after me and Mark had our conversations, not prior to any. I knew nothing about Mark. I had never heard of the case, so I came to Kenosha.
Well, after you'd been in there for a few days, you talked to people about Mark, right?
No, I talked to Mark.
Are you telling? And as I'm saying, after that, you haven't talked to other inmates about Mark Jensen?
I've only spoken to 3 inmates on that pod. They were Mr. Bush, Mr. Clanton, and Mr. Jensen.
Well, what about when you're in K-Pod?
No, I didn't talk to anyone about Mr. Jensen and K-Pod.
So Mr. Bush and Mr. Clanton are the only inmates you have ever talked to, Mr. Thompson, about Mr. Jensen in his case?
Yes, that's what
Nobody else ever?
No.
So this is the other part too. We've only heard, and everyone heard this when we played this guy's testimony before, but they're all testifying to that they're in I and J block, right? I and J. And this guy moves over to K block at some point. And there's these notes and all this other stuff. He wasn't in one of the connecting blocks. I, J, and K do not connect like that. You cannot see through the whole goddamn jail. You can't. That's not how it works. I can't even believe they didn't pick this up.
Well, who was the person who had the newspaper that was showing it to you and talking about the case?
That was Terry Bush. When I came back from court, they had a newspaper on the unit when I got back from court. And they talked and they told me, you in the newspaper. And I'm like, let me see the paper.
Right. And then you talked about that, right?
No, what was there to talk about? Everyone had read what was in the paper. So what was there to talk about?
So there's no conversation then?
About myself, yeah. I didn't have nothing to say about Mr. Jensen.
And they weren't asking what you had to do with the Jensen
Yeah, they
case.
was asking why I was in the paper. They was more concerned about why I was in the paper than what I was in the paper for.
All right, nothing I can do about the commercials. So, oh my God, Cheryl says, I thought this was about a murder case. Yeah, it is, but the reason with all the snitches is because they all claim that Mark Jensen confessed to killing his wife. And there are so many holes in all of that. And the problem is that all of these snitches had access to this guy's transcripts. So they would have read. Here's the importance. This Ed Klug guy, okay, because they're talking about this conspiracy to kidnap Ed Klug. Ed Klug is Mark's co-worker. They're like besties. And for some reason, these two morons are when they're at work and they're going out for drinks and whatever, these two idiots keep talking about killing their wives. Ed Klug, too, he admits that he talked about killing his wife. Who knows why they did that? Whatever. So when Julie dies, Klug finally comes forward, and this is suspicious because it's many, 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 many years later that he's like, oh, by the way, law enforcement, he was joking about killing his wife, and now this chick's dead. But none of this comes out until after 2002 when Mark is arrested. And then conveniently, these people start coming forward saying, oh, Mark confessed. Oh, Mark said he was going to kill his wife. After all these details are in the newspaper. So that makes it very suspect to begin with. Okay. With the jail people, Mark got sent the Ed Klug testimony in 2007. Okay. Because they forfeited his bond. His bond was $500,000. And after some of this stuff started coming forward, Bobby Boy over here filed for the courts to forfeit Mark's bond. And they had a mini trial. It's not like a bond hearing that you see for like Brian Koberger or Richard Allen, right? It's 5 seconds and then they leave. This was a whole damn trial. Okay, so everybody is testifying, all this stuff, right? Because they got to lay out probable cause to the judge to get this guy's bond taken away. So everybody testified in 2007 before the case went to trial. Okay. That testimony from Ed Klug about, oh, he's talking about killing his wife and this and that, whatever. Mark was sent that when he went to jail, when they revoked his bond. 4 days before Aaron Dillard got to the jail. This is the guy that says Mark confessed. 4 days before that, Mark Jensen was sent the 1999 police interrogation transcript. So that video that we saw in this trial of his interrogation where he just sounds like a moron, they transcribed that. But conveniently, an hour of that video is missing. They lost it. They don't know what happened to it. They transcribed the video and sent it to Mark 4 days before Dillard got there. Now, Perry, I think it was Friday, argued extensively that there is another way that Dillard could have gotten the information other than Jensen confessing. They needed to poke holes in this. And that transcript was a way to do that. And more importantly, all of these people testified that they never read these other transcripts. They didn't read all these other documents. Nobody had access to Jensen's cell. And what I caught, and some of you did, is when Thompson is on the stand today, he says that people, and him specifically, went in Jensen's cell and read paperwork. And he talks about it a little bit here, but it's a different statement. So I'm kind of making a big deal out of this. Some of you are not. I probably sound like a crazy person. I realize this. But for those that have been with us watching and, you know, doing all this stuff, you guys know what I'm talking about. Then there was, let me pull up this other video. This is why we're doing, like, you know, especially the weekends, we play these big long marathon streams, right? And then during the breaks, we're trying to play clips for you guys of different things. So you're getting more access than the jury gets, right? Which is great for us, but maybe sucks for a defendant, or sometimes sucks for the state too, because you guys get more information than the jury is hearing. And we luck out having an entire trial that we can watch from years earlier. Let me pull up this other. I wasn't paying attention to anything in chat because I was trying to timestamp this stuff for you guys. There's a lot. There's a lot of work. I'm trying to go through 4 hours of testimony and timestamp this. The newspaper, there's so much with this guy's testimony. That's why, like, a bunch of us are in the chat on Facebook and YouTube, and some of us are freaking out because we paid attention to what was said in 2008. We showed the full testimonies of these guys, and some of the chat is, you know, taking notes, and people are calling BS on some of these testimonies. And it has nothing to do with the length of time of the case. It's nothing to do with that. It's that what's questionable about the whole thing is that a lot of these people never came forward. And even like Julie's friends or Mark's friends, nobody comes forward until after the 2002 when he's arrested and details get put out in the news. And then more in 2007 when even more details get put out. Then all of a sudden, people are, you know, saying all types of stuff. And we've shown, like, that there's a lot of stuff that's really, really messed up. Sorry, I'm just trying to pull this up. I'm trying to do this as fast as I can before this break ends.
3 weeks, yeah, roughly about 3 weeks. Yeah.
And then you moved to K? Is that what you said?
Yes. I didn't say that, but that's where I moved to, K Block, yes.
Okay. And how long were you in K?
I was in K Block up until about maybe a month and a half ago.
So this is the inconsistency as well. They're talking about how they're in I and J. And this guy's talking about how he's moved to K, but this is where, you know, they're passing notes back and forth and all these things. That these 3 blocks do not connect in the Kenosha County Detention Center. They don't. That's not how this works. It's 2 blocks that connect, and then it'll be 2 more blocks that connect, so on and such forth. Then there's this statement, and I know I'm just like, you guys can object and argue completeness with me. I'm just fast trying to play some of these clips. We have the full testimony on the YouTube channel. If you guys want to go and watch it, go back and watch this whole line of crap compared to what his testimony was today.
Well, you had decided that you wanted to help yourself, right?
Yes.
And what could help yourself more than a confession?
Well, I wasn't basically trying to even speak upon the confession. My sole purpose of calling them was to talk about the phone call.
You didn't tell them about a confession, right?
Excuse me?
You did not tell them about a confession at that time.
Not at that first meeting, no.
Right. That's because none had happened, right?
If you say so.
And then after you had met with them you met with them again on October 10th, right?
Yes.
And between the time that you met with them in September and the time you met with them in October, the trial had been adjourned, right?
I don't know.
The trial had been postponed, Mr. Jensen's trial?
From October 8th?
Yes.
Yes.
And along with the news that the trial was postponed were newspaper articles, right?
Shit. All right, hang on, chat. We gotta go back. They're coming back into court. Oh, it was just getting juicy. Here we go. But this is why we do these big giant streams on the weekends, so you guys can see the 2008, and then you can compare it when these guys
Okay,
come
we're
back
back
on the
on
stand to
record,
testify.
Mark D. Jensen, 2002 CF 314. The appearances are the same. The jury's back in the courtroom. We just have to tie up something from the testimony that we finished before the break. It's the letter Mr. Jambois wrote to the authorities in Illinois. I will tell you any information, you should not consider any information except for what's in the letter now that Mr. Jambois is going to read back to you. Okay, go ahead, Mr. Jambois.
Thank you, Your Honor. The letter is dated March 11, 2008. The Honorable Wayne Anderson, Bloomberg Federal Courthouse. Ray David Thompson. Dear Judge Anderson, it is my understanding that David Thompson will soon be standing before you to be sentenced for his role in 2 bank robberies. I don't know anything about the circumstances surrounding these 2 incidents. However, I do think you should know that David Thompson recently testified in the case of State versus Mark Jensen. During the course of his incarceration in the Kenosha County Jail, Mr. Thompson became acquainted with Mark Jensen, who stood accused of the murder of his wife, Julie Jensen. Mr. Thompson testified in the Jensen case that Mark Jensen had solicited him to arrange to have a witness named Ed Klug, quote, sat on, unquote, or kidnapped in order to prevent Mr. Klug from testifying. The state had intercepted and recorded telephone conversations between Mark Jensen and various family members, which corroborated Mr. Thompson's testimony. I stress that Mr. Thompson had never actually intended to participate in a kidnapping scheme. Rather, it was his intent to induce Mark Jensen to participate in such a scheme so that he could testify on behalf of the state in this matter. I do hope that you will consider that as a mitigating factor when deciding upon an appropriate sentence for Mr. Thompson, and then assigned sincerely, Robert Jambois.
All right, Exhibit then 78 will be received. All right, what do we do next now for the state?
So, Judge, this is Exhibit 75, and we are going to be playing excerpts from jail phone calls. This initial one is from July 31st of 2007 between Mark Jensen and his parents, and it begins at 04:35.
All right, play the phone call.
But anyhow, we're going full speed ahead, but I would be somewhat shocked as how this thing is developing here, because it's different from what we were talking. We got this witness here who says you did it.
Right. Let's talk about it. Yeah. But, again, where does the seat come up,
Well, that's a pretty strong reaction, though, I would think, on the part of anybody who listens to it. I think that you did do it.
Right.
We're going to have to do something about that guy.
I didn't say that to him.
Huh?
I didn't say that to him. There were 3 people there.
What's his motive for saying it you did?
Talk to Mom about it.
Okay.
Calls are monitored, Dan. Calls are monitored?
Yeah, I know.
Okay.
Now stopping that at 05:29. And now we'll be moving to a call from 9/11/07 at 15:40. And this will commence at the time of 11 minutes and 15 seconds.
Well, I got an offer of help today in a different way, which was interesting. What? I got an offer of help today in a different way, which was interesting.
Yeah, how's that?
Well, tell you guys about that later.
Okay.
And, let's see. Other than that, talked to Kel last night after, probably.
All right, and stopping that at 11:36. Now I call 9/11/07 at 20:40 between Mark Jensen and Kelly. And this call will commence at 8 minutes and 25 seconds into the call.
Oh. Well, the guy today was offering to go grab somebody and sit on him.
Okay.
Oh. Just the way the kids used to be able to do it,
Yeah.
Like they would go find Doug, grab him, pick him up, carry him somewhere, sit on him.
Yep.
So. Oh, God. But that would be we got time to figure it out and have some fun with it.
Mm-hmm.
That's the big question is
Yep.
where do we want to go and where do we want it to be? Where to from here? Draw a line, put all this behind us, and move on. But I want our life back,
Yep.
all of it, every part of it,
So stopping that part at 9 minutes and 13 seconds and then moving to, in the same call, so this is starting up again at 11 minutes and 50 seconds into the call.
Let's see, money-wise, how is everything?
Fine, I guess. I just have to remember to pay the bills.
Bills?
Oh, shit. Forgot to pay one of my credit cards.
Oh, really?
Got stocked with the late fee and the interest charge. I was like, son of a bitch.
Okay.
Because it just happened, just at the right time where it was just the last thing on my mind. And I don't get paper statements anymore from anything.
Gotcha.
So I have to remember to go out there. And I went out there the day the next statement was cutting off.
Right.
Made the payment. Well, that didn't cut it.
Gotcha.
But, it's taken care of. But, no,
Okay.
other than that, we're fine.
Sounds
That's why I have so many things set up on auto pay. Because I just don't need the hassle.
Okay. Oh, let's see. There was something. Okay. Well, that's good. There was something I think I want to have my folks take care of.
Mm-hmm.
And might have you give them some money, just a little bit. And I'll explain that to you.
Okay.
Okay? Not right now.
Okay.
Okay? We'll see if I'll figure it out. Okay. Other than that, I don't know anything more about that at this point, so.
Have to do with something in there?
What's that?
Does it have to do with something in there?
Oh, no. No. Yeah, no.
Okay.
Yeah, no.
All right.
Okay. And that's all.
How much?
It'd be like 500,
Okay.
maybe twice, and that would be it. And I'm not sure if I want to do that or not, but, you know,
Okay.
and I know I'm not giving you any answer at all.
No, well, but I understand. You know.
Okay. I'm just, yeah, it'd probably be better to have that part of the conversation now and the other part of it later or something like that.
Okay.
We'll figure it out. But
All right.
definitely want to, I don't know. We'll see.
You have 1 minute left.
You're going to get cut off again.
All right.
Okay, well, don't worry about that. It's just the, just I want to give you a heads up or something like that with that. Okay. Love you. Everything else good?
Uh-huh.
Good. Everything's fine. Let's see, what else is going on here?
All right, stopping that at 15:42, or sorry, 14:57. That was the time on that. And so now moving to a recording from 9/11/07 at 21:05. Once again, this is Mark Jensen, call to Kelly. And this will start at 37 seconds in.
Hey,
Hey there.
it's almost 9. What are you doing?
Oh, I know. I just want to get back to you on that. I got $20 left. So, I spent a lot on pads and pens and stuff like that last week.
Okay.
Okay. And I got a bunch of stuff ripped off.
I can't afford $100 a week, pal. So you need to budget a little better.
I understand.
Okay.
Okay. I'm working on it.
All right.
It's just, to get a bar of soap and a couple soap, shampoo, stuff like that. Generally, usually it's about $50. I spent more than that, though, this last time. It was like 80 of that 100. And then I grabbed some stuff for that medical stuff, too. So.
Mm-hmm.
Okay. So.
All right.
Sorry. I understand. But, yeah, stuff's not real cheap.
No, it's fine. It's just, was put, what?
I know. I realize that. It gets over the...
$800 in phone calls.
Right. The cost of being here is amazing, and it sucks.
It's $100 every 2 weeks, and now we're going to $100 every week.
Right.
Yeah.
Right. No, I understand.
And now you want another $1,000 for something I don't know anything about, but your parents do, and we're all talking on the same phone, so I'm not really sure about that one, but
Right.
okay.
Right.
And they're certainly never going to tell me the truth, so.
Right. Well, I don't even know about that one, sweetie. I just don't want you to, just don't want to get you.
Okay, that's fine.
Okay.
That's fine.
That's okay. I'm not even sure that, want to do that or anything, or I'm going to do it or something like that. Yeah.
All right.
I just,
You're just trying to keep people in line, or what?
What's that?
You're just trying to keep people in line?
Here?
Yeah?
No.
Okay.
No, not for that. So, okay.
Okay.
That's not it. So, yeah, other than that.
You're trying to keep your girlfriend happy?
Yeah. No. No.
I'll give her a truck.
Yeah, thanks. No, nothing like that.
It's almost 30 grand. I was wrong about it being as upside down as I thought it was.
Really?
Yeah, because I put on there that it was a Hemi and not a diesel. And a Hemi's only worth 19. The diesel, we're within a couple grand of what it's worth.
Okay.
But,
Yeah,
we're still losing money on it, so.
Diesel's worth a lot more.
Yeah, it is.
Yeah.
So I meant to tell you that a long time ago, but obviously your truck is not at the top of my priority list.
Right. Gotcha.
Yeah.
Okay. Well, no, I hate having you, telling you to do something like that, or, no explanation. I just, not sure to do it without talking about it. That's all.
I know.
So,
But if your parents know about it, you talked about it to somebody.
no, I haven't. So.
Okay.
Not yet.
All right.
Not yet.
Okay.
So, okay.
Yep.
Okay.
Bye.
Love you. And, ultimately, I'm probably not going to, so.
All right.
I just wanted to check with you to see if, that's it. If I will never talk to you about it again, and if I wanted to do something, I'll just have them ask you for it,
All right.
Okay. Love you.
All right, so stopping that at 3 minutes and 57 seconds. And the next recording is 9/12/07 at 18:01. Call with Mark Jensen and his parents. So this starts at 2 minutes and 9 seconds into the call.
Okay. Hey, question for you. Do you still have Kim's number?
Kim.
Yeah, remember that Dave who you helped that night? His wife's name was Kim? You talked to her on the phone?
Say that again? Who, Kim?
Kim, yeah. Oh, you got me back on the speakerphone?
Yeah, you're back on the speaker.
Who's Kim?
You there?
Yeah.
I'm sorry, I'm not connecting. What? Who did we talk to?
I hardly hear.
Okay. You there?
Oh.
So that section ended at 2 minutes and 53 seconds, and the next part will commence at 4 minutes and 43 seconds.
Hey, you do me a favor, sir. You have the phone with the mom.
Okay.
Okay.
Hey there. Yeah, let me give you this phone number here.
Oh, okay, let me get a pen.
Okay. Just hang on to it.
Got more stuff around and no pen.
Gotcha.
Okay.
262?
Okay.
247? 2437.
2437.
Yeah.
262-247-2437.
Right.
Okay, what is that number?
That was you, the lady you talked to the other night.
Oh, okay.
Okay. You get a chance, just give her a call and touch bases.
Okay.
And she'll, that's all.
All right.
What's it like out there?
So stopping that section at 5 minutes and 42 seconds, and then resuming in the same call at 11 minutes and 31 seconds in.
Sounds good.
And I'm willing to do anything at all.
Okay.
Period.
Sounds
okay?
Good. Sounds good. Well, Kim, let's see. Dave offered to help. You got Kim's number. Give her a shot when you get a chance. Touch bases with her. Maybe she can explain to you. And if you got any questions, I'll give you a call back later. And
okay.
If you got any questions on it, okay?
Okay.
And other than that, it's supposed to get hot again tomorrow. It's supposed to get hot and then cold again.
Yeah, exactly.
Well, it'd be nice to have some fresh air. And then you get any fresh air. It's like 80 degrees in here all day long. Everyone's just sweating.
Oh, I know. I can imagine. That's awful.
They do everything they can to make you And yeah, hook up with Phil on the tax file tomorrow. That'll help. And that's all I can think of right now.
Okay, I'll take care of everything as I'm supposed to.
Okay.
And
All right, and stopping that at 12 minutes and 23 seconds. And the next call is September 12th, 2007 at 18:53. Also Mark Jensen to his parents. And this commences at 45 seconds into the call.
Yeah. Oh, good God. The blood's coming down. Oh.
well, I called Kim.
Okay.
She said she was going to call her, talk to her husband tonight.
Okay. Sounds good. And, was she able to explain any of that to you?
Nope, she didn't say a word.
Okay. Sounds good. And, well, that's probably the best bet is talk to, I don't know. Otherwise I can, well, that's fine. Yeah, have her talk to Dave. That works.
Okay,
Okay, as long as you guys are in touch. And,
I'll keep her number.
that sounds good. And, yeah, let's go. So, that works just fine.
Okay, other than that, I don't know a thing except from the last time we talked, except that I do want you to know that I will do whatever research, whatever I need to do.
Okay.
Period.
Sounds good. Yeah, I don't know if they're
So stopping that at 1:52, and then in the same call, we'll be resuming again at 6 minutes and 18 seconds.
Doesn't matter, right?
Yeah, even books of your own. Hell, you guys might get $1 million book deal out of this thing. You know.
Yeah, probably could.
Exactly. So, I mean, talking about being.
Yeah, I'll go for it. I will go for it.
That's what I mean. We got to do whatever we possibly can to make sure we're on the winning side of this whole thing, and probably knows it them. So, that's it.
Mm-hmm.
Now, like Kim, she's just, sweetheart. So, yeah, she'll talk to Dave and figure it out. But, go from there. But talk to her. Other than that, I can talk to you guys Sunday when I see you about that.
Okay.
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 And what's the day? I'll talk to you beforehand. If you got any questions, just, I got to remember to be quite careful on the phone about what gets said.
Okay.
That's all.
I try to be, but sometimes I just want to be.
I know.
I say what I want to say.
Yeah, I try to pass it on. So, I think, at some point you just got to hook up with Kim.
Yeah.
And that'll be fine. And,
Okay.
Other than that.
She will call tonight.
Oh, she's going to call tonight?
Yeah, after she talks to her husband.
Okay. I'm not even sure if he's, okay, no, that's fine. Never talk to him and we'll see.
Okay.
It's just a question of, getting everyone on the same page and explanations and, I'm not sure,
Okay.
Need to be probably the best way is, when I see you guys or something.
Okay.
Okay.
All right.
Well, there's time to figure that one out. But, yeah, just wanted you guys to be able to talk, that's all.
Okay.
Okay.
I did.
Sounds good, and, yeah, we'll go from there, so.
All right.
We'll talk to you tomorrow, but that, that could be fun.
Yeah.
Fun and interesting. This is something that Baca would like.
Oh, okay.
Okay.
Then he will talk to her.
Oh, it doesn't have to. I mean, it could be, you guys talk and,
This
everything's
is
fine. So.
a Baco kind of thought process?
No, it could be. Yeah. Could be kind of fun, so I don't know. what you gonna do? Sometimes it's like, two little kids when they're, well, it's like David used to do it, Doug. You know, when Doug was misbehaving, David would just go grab him, pick him up, and go sit on him for a bit.
That didn't sit well with Doug.
What's that?
Doug, that did not sit well with Doug.
No.
Doug does what Doug wants to do.
Yeah, he doesn't like getting fed.
Doug knows what he needs to do, and he is going there, and he is not going to be deterred.
Right. Exactly.
He's just the coolest boy.
Yeah. Well, he's a good little guy. So, but yeah, just Baco, with the thought processes and everything. So.
Oh, well,
Yep. What you gonna do?
Deal with it, because sometimes that thought process is really cool.
Right, exactly. Yep. Sometimes, you gotta get, yeah. Sometimes a 12-year-old has the best answers. Yeah. What you gonna do? Yeah, Doug, and he's riding his bike all over the place. Church, you name it, everywhere. Newfound freedom until the clock starts changing time. So, okay. Yeah, I'm not sure, what Kim.
In the oven?
As long as you guys are talking, that's cool. I'm not sure what she'll be able to explain to you or something like that. But, if not, I can fill in those blanks for you. Later.
All right.
See you. Okay.
All right.
Okay.
Waiting to get the disc.
All right, so pausing that at 10:09. Then this next call will be September 13th, 2007 at 10:21. Another call with Mark Jensen and his parents. So this starts at 11 minutes and 42 seconds.
Here, talk to your mother. Okay.
What do you mean talk to your mother? I mean, you asked me to call Kim last night, which I did.
Okay.
And she didn't call back.
Okay.
But there was somebody else named Wayne Palmer?
Oh, no, Kel talked to Wayne Palmer.
Okay.
Which is for the month. He's got like 30 apartment buildings in town.
Okay.
He owns outright. And he's had for a long time and whatnot. So he's with Schaefer Electric. In the construction business. So he called to find out how I was doing weeks ago, and Kel talked to him, and we were, he said he wanted to come and see me, or, but he's a big supporter. And so Kel called him and said, hey, what can we do? Could you help? And he said, well, sure, I'll do everything I can to help, just let me talk to Mark. And so I'm going to call him tonight.
Okay.
So, like getting things going with the bond thing, so.
Right.
Okay. Okay, no, if you haven't gotten the call back on Kim, that's fine. And other than that, well, that'll be fine. Yeah, just hang on to her number.
What?
Just hang on to that number.
Okay. I'll do that.
Okay.
I'll put it over by here by the,
Okay.
or this phone, so I've got it.
Sounds good. I just have to have you hook up with Kel on before, this is the Port Washington projects and stuff like that.
Uh-huh.
Part of that. So, some point just got to have you hook up with her and take care of that headache for me. So.
Okay. All right.
And other than that, that's all I know with that one.
Yeah. Okay.
All right, so pausing that at 13:28, and now moving on to the last call. This is from 9/14/07 at 18:24, a call between Mark Jensen and his parents. Okay, this begins at 14 minutes and 21 seconds.
Oh, Mom, can you still got that Kim's number?
Yeah.
Okay, give her a call and have her put money on the phone.
Give her a call and have you, and
Put money on the phone.
you have 1 minute left.
She'll know.
Yeah, give me the instruction again.
Just give her a call and say I have her put money on the phone.
Oh, have her put money on the phone.
Right.
Okay,
Yeah, she'll know what that is.
okay.
And other than that, yeah, I don't know. You know, talk to Kel. She's got that stuff for you. I'll talk to her, but you know, we gotta see if we can get this part done. Okay.
Okay.
And I'll talk to you guys tomorrow.
Okay. All right.
Okay, love you.
See you on Sunday.
Okay, that's right. Yep, see you Sunday.
Yep.
Okay.
Okay.
Bye-bye. Bye-bye.
All right, stopping that at 15:12. And so that's it for this exhibit, which is State's Exhibit 75, and the state will move that into evidence.
75 is received.
Judge, I'm going to be now entering Exhibit 72 and playing 2 calls from it. The same. First one is dated September 8th, 11:56 in the morning, and it's between Mark Jensen and his dad.
2007?
September 8th, 2007. Could you turn my computer on? Thank you. And this is starting at, I think I already said 11:56.
Yeah, I mean, you know, that's not gonna, you know, whatever individual realtors have going on, you know, that, you know, for RE/MAX, 75% more.
Well, the actual sales are off maybe 20%.
Okay.
But I think you had a lot of people who wanted to close prior to school starting, and they.
Yeah, that could be. That's true. That's
and
true.
so the week of when school started, there was a slowdown in closing.
Yeah.
But it should be the next week in the paper will be better, I would think.
Okay. Hey, question here. Let me give you a phone number.
Okay.
247?
Yeah.
2437.
They want to buy a lot?
No, this guy, you can just make a phone call when you get a chance. It's a local. But there's a guy in here who got picked up back on the 23rd when he was on vacation about a month ago. And he just got back to the jail here but can't even get a hold of his family. But apparently, you know, his family has never had a chance to talk to him in weeks. So.
Why not?
They will want to make a phone call. He's a Fed guy for some reason. But yeah, he's stuck in here. And he got a hold of his sister a week ago, I guess. But, you know, if you get a chance.
Well, what am I supposed to do with his number?
Oh, just nothing actually. Okay.
I'm supposed to call it?
Yeah. No, you don't need to. I just wanted to get rid of that headache.
247-2437?
Yeah. Yeah. Now, if you want to do somebody you know, a good turn, I guess just give them a call and say put some money on the phone so that you can actually call. So.
Put some money on the phone.
Yeah. I guess you have to have money on his phone so that he can call and get a hold of his wife and kids. They're on vacation. They were literally, you know, they use this place to bounce Fed guys through, federal prisoners.
Yeah.
So they grabbed this guy on vacation.
Yeah.
He's coming out of a casino up by, I guess by Watersmead, up there. They were up there on vacation, but you know, same neck of the woods as Lorian Todburn. But yeah, they grabbed him and he's been bouncing in every county jail all the way down to the lakeshore.
How come?
I guess he's heading towards Chicago. So, but this is
why they got a casino there too?
No, this is the game the Feds play. You know, you got state prisoners, and then
how much trouble am I going to get in by calling this number?
None. Actually, I probably wouldn't even bother, really. Because if he sees me on the phone, say he has me a number and says,
Hey, if his family knows where he is, they're gonna know from calling the police department what to do.
right, exactly.
I don't see me getting involved in this thing and doing anything that they can't do for themselves.
You're right. You're right. No, see, but what happens is you get hit up here all the time.
Oh, I'll bet.
Yeah, so that's all. I'll just
Say you passed it on, but don't say who to whom.
That's exactly what I did.
Okay.
So, okay. Oh, no, man.
I mean, you don't know what bad asses you're running into in there.
Oh, no kidding. And then you don't want to, you're not showing up.
Yeah, you think you're doing something right, and the next thing is you're accomplice to the son of a bitch.
Yeah, exactly. And your number shows up in a caller ID and everything else.
Yeah, now you got a lot of explaining to do.
Right. Oh, no shit.
No, I think you got enough trouble without looking for more.
Right. Well, that's all I'm trying to do is not buy it, so. You know where I'm coming from.
His wife wants to call him. She knows where he is.
Right. Exactly. Oh, it was Kel. One of the guys in here saw me dialing the whole number and started calling her.
Why?
She was getting phone calls and stuff from the jail.
Why?
Beats me. Because people will they don't have anybody to call. There's a lot of people just roll through here. So they call her and ask her to do something or some bullshit. She was actually getting mail from these guys. It's like, so you learn real quickly. You got to hide your phone numbers and your addresses and stuff like that. People
isn't that something?
take advantage of it. Yeah, it's bizarre. So, you live and learn, right? So it's fine. You know what else? Don't know nothing else. Next Friday is a hearing date.
Next Friday?
Yeah. Oh.
That stopped at 12:27. This next call is same day, September 8th, 2007, at 2:03 p.m., Mark Jensen to his parents.
Hello, this is a collect call from an inmate from the Kenosha County pretrial facility. To accept charges, press 0. To obtain customer service information, this call is subject to monitoring and recording. Thank you for using Global Tel Link.
Hey.
Hey there.
What's up?
Oh, I got myself a headache here.
How come?
Oh, just that call.
What?
That phone call?
What phone call?
That number I gave you before?
Yeah?
He wants to do a three-way. So I'm going to have a fight in my hands here, or we let this guy make a three-way phone call.
How do you do that?
I think you put that flash button.
The flash
Hit
button?
flash, then you should have an area code, or you should hear a dial tone. And then let me give you the number again.
Okay, hold on.
This is BS, but
I haven't done a three-way call.
yeah. You hit flash, and then you should get a dial tone, and then you dial this other number, then you hit flash again, and it should connect the two.
Okay, 1 second.
Okay.
What? I don't see a flash button.
Oh, you know the same one you'd hit to probably answer. Is there an asterisk on it?
You know how to do a three-way call? You mean the talk button?
Yeah, I think it's a talk button, or there should say one. Well, it should be one on there that says flash or try.
Yeah, you talk to your mother.
Okay.
Hello?
Hey there.
Hey.
Hey, do you have like a? Hang on 1 second here.
Okay.
Okay. Talk. Gonna try to make a three-way call. Try hit talk.
Okay.
Let me write down this number. I gave it to Baco earlier.
Okay.
But 262.
Okay. 262.
247.
247.
2437.
2437.
Yep.
Okay.
So hit flash. Dial. You'll get a dial tone.
Uh-huh.
Then dial that number.
Okay.
And then hit talk again.
Okay.
And it should connect it to.
All right.
Okay.
All right. Hang on.
And after you do that, then I'll talk to you guys. I'll
Okay.
get you on the phone. See if
Okay.
it works.
Okay. Flash.
Okay, still got me.
Nothing.
Still got me.
Yeah, okay. I just couldn't get the other one.
Okay. Huh, it's not. Did you get a dial tone when you hit flash?
No. Let me try it one more time.
Okay.
Okay. Let's try this one more time. Hang on.
Okay.
You there?
Yeah.
Okay. No, it won't work.
Did I? Okay. So that's when you hit the talk button, right?
Right.
Is there another flash button on there or something that says flash somewhere in that cordless?
It says flash, but I hit flash and I don't get a dial tone.
Okay, when you hit flash, you don't get a dial tone.
Right.
Okay. Is there a talk button on there? Does it say talk?
Yeah, I've got a talk button.
Okay, try the talk button.
Okay. No. I hit talk and I don't get a dial tone either.
Okay, you just don't get any kind of a dial tone.
Right.
Okay. Yeah, you got a cell phone?
Yeah.
Okay. Try dialing that number on the other cell phone. Is that the cordless phone you're using? Yeah.
Yeah. I can try it on my cell phone. What am I trying to get?
Oh, just call this. There's a guy here's trying to get a hold of his wife. And so just trying to.
Oh, okay. Is it a local number?
Okay. What's that?
Is it a local number?
Yeah.
Okay.
Yeah. Yeah, it's 262.
Do I have to do a dial 262?
Yeah, 262. 247-2437. And then put like the cell phone on speaker and just flip them around.
Put what?
Take the two phones and flip them around so the headset's by the voice piece.
Okay.
I guess.
Mm-hmm.
Okay. See if you can get him on the phone. This is unbelievable.
Mm-hmm. What am I supposed to do if she answers?
Just know her Dave wants to talk to her.
Okay.
I don't know. Yeah, just hold the phones together and I'll put him on.
Okay.
Okay.
Mm-hmm. Hello? Just 1 minute, please. Dave wants to talk with you. Okay. Okay, I'm putting her on.
All right. Hello? Hello? Did you flip the phones around? Hello? 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 Oh, yeah, it's my mom. Oh, well, yeah. She's having a hard time here. Because, yeah, she does. Hello? 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 Hello?
Yeah, are you there?
Yeah, I'm here.
Okay.
Do you have her on the other phone?
Hello? Hello? Okay. Just 1 minute. Just 1 minute. She's there, but he is not.
Okay. No, he's here.
Okay.
He's here. He wants to talk to her.
Can't he call her?
She's got to put money on the phone so he can.
Okay. 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 I'm sorry. I'm
Yeah, tell you what,
just
Mom.
a mother of someone who called from there. He wants to talk with you, but you evidently have to put money in for him to talk to you. Okay, sir. Bye-bye. Okay.
Okay. What's that?
Okay.
She's got
So
that.
then you know you need to put the money in, correct?
Hey, Mom?
Okay.
Hey, Mom?
Sure. Bye-bye.
Mom, hang on. Don't
Okay, she's going to put the money in.
Okay, she's still there?
No.
Okay.
I think she wasn't quite sure that what she had to do, or maybe she just had run out and didn't know that.
Okay. Oh, she ran out and then...
That's what it sounds like. But she said she was going to put the money in, so. That's all I can do. Right?
Yeah. Call her back real quick. He wants to ask her one question real quick. And I'm just going to let you relay it, okay?
Okay.
So try that one more time. We'll be done with this.
Okay. One second.
Okay.
Two six two 247 2437.
Okay. There you go. Tell you what, I'm just going to hand the phone over to this guy. His name is Dave.
Okay.
You got his wife on the phone, so.
Okay. It's dialing right now.
Okay. But then you can just relay. If you can't get the phones working right, just, if you got a quick question, you can try it that way. Okay?
Okay.
Okay. There you go.
Okay.
Hello?
Hello, Dave?
Hey, how you doing, Ms. Jensen? Sorry.
I'm doing that just fine.
Like this. I'm just trying to get a little bit of information on my wife here. That's all. That's all.
Okay. No, I talked with her. She might be on the phone trying to put more money in.
Is she on the line now?
Okay. I got voicemail on it right now. They might be on the phone or something.
Could you try her cell phone for me, please?
Pardon?
Could you dial her cell phone for me, please?
I sure can. Hang on 1 second. Okay.
It's 414.
Okay.
531 5048.
5048. 48.
Yes.
Okay. Do you want me to just relay the question to her?
Yes, ma'am.
Okay.
Is she on there?
No, she's not. It's dialing.
Okay.
Do you want to? Okay. No, I got voicemail on her cell phone.
On the cell phone?
Do you want me to relay a message to her?
Yeah. Just ask her, did she take care of what she was supposed to do this week? And
Okay, let me write that down. I mean, I had talked with her and told her to put money in the account, so, okay, did she do what she was supposed to do this week?
did she go to the police station, do what she was supposed to do this week?
I'm sorry, did she do what?
She was supposed to do at the police station this week.
Okay,
And how long will it be before the phone is right? That's question number 2. And see if you can find out what time our court date is set for Monday. And I really would appreciate it. I truly thank you.
okay,
Mark will get back with you later for the answers from me.
okay,
Okay, thank you. I appreciate it. Thanks a lot, Ms. Jensen.
okay,
Here's Mark.
all right, bye-bye.
What number were you gonna move in now?
That was, again, track 3 from 203 ending at minute mark 12:49. That was the entire phone call. This, Judge, is Exhibit 72.
All right, it is received.
I will have to, and I can do this tomorrow, submit a paper transcript of that I'll be moving in as well.
All right. Okay, are we back then to the state's witness?
Yes, we are.
All right, who are you going to call?
The state is calling David Ellis, number 16.
All right, chat. Facebook stream is going to end in 10 minutes. There's nothing I can do about that. They only allow us to stream for 8 hours. Oh, look who just walked into the courthouse, fist pumping the goddamn enemy. Look at that, hanging out with Kevin Mathewson, Nathan DeBrune. Look who's there, chat. Isn't that convenient? This guy cannot stay out of my city. Unreal. Anyway, we are still live on YouTube. The Facebook
Right, if you
chat
could
does
remain
end. There's
standing,
nothing I
raise
can
your right
do.
hand. You solemnly
Switch
swear the
over to
testimony
YouTube
in
now,
this matter
chat.
be the truth, whole truth, nothing but the truth shall be God. Thank you. Get as close as you can to the microphone. Spell your first and last name for the reporter.
It's David, David, Ellis, Ellis.
Thank you. Go ahead, Ms. McNeil.
Mr. Ellis, in about April of 1996, did you have contact with Mark Jensen and Julie Jensen?
Yes.
And why did you meet with Mark Jensen and Julie Jensen at that time?
I was contacted by, I believe, Mrs. Jensen in reference to a situation where, excuse me, there was an issue where someone had been placing pornographic photos around their home, around their neighborhood, and on Mr. Jensen's car at work. And we had a discussion about setting up a surveillance to try to determine who was doing so.
So what was your employment?
At that time, I owned a private investigative agency.
And before opening or before you worked full-time with that private investigation agency, did you work as a police officer?
Yes.
And where did you work?
I started in 1977 in Silver Lake, Wisconsin. In 1978, I went to Kenosha City Police Department, and I left there in 1986.
And then when you left, did you pursue this private investigation business?
Yes, I actually started it in 1984. In 1986, I decided to leave the police department and run the agency full time.
And so did you have some contacts with officers who work for the Pleasant Prairie Police Department?
Yes.
And would those officers sometimes refer people to you?
Yes.
In what context would they refer people to you?
Occasionally, they'd have a case where they felt that
it was better suited to have a private investigator work it rather than the police department. Maybe it wasn't a criminal matter. It could have been a civil issue. But that happened a couple of times over the years.
And so that's how in April of 1996, you came in contact with the Jensens?
Yes, I believe that the police department may have referred them to me. I had a close relationship with Paul Ratsberg, Mark Hunter, and Ron Cosman, all of the Pleasant Prairie Police Department.
And so when you met with the Jensens, where did this meeting happen?
At the Jensen home.
And during this meeting, did they inform you of the problem that they wanted you to investigate?
Yes.
Okay, so can you just give us a summary of that?
There was, again, as I mentioned, someone was placing these pornographic pictures around the home and around Mr. Jensen's vehicle. And we had a discussion at their home as to what was happening, when it was occurring. We talked about potentially who might have been doing it. And a result of that discussion, we decided to set up a surveillance on a Friday afternoon.
Now, did they tell you that they believed that this was arising out of an affair that Julie Jensen had had?
Yes.
And so what did you suggest or what did you decide to do to further investigate this?
I conducted a surveillance on a Friday afternoon of Mr. Jensen's vehicle. Nothing occurred during that time. I believe it was roughly from 1 in the afternoon till maybe 4 or 5 in the afternoon. Monday, I contacted the Pleasant Prairie Police Department. I had been given information that they had some photographs in evidence, and I had met with them and requested to look at the photographs to see what the nature of them was, so I knew more so what I was dealing with.
And so did you actually go to the Pleasant Prairie Police Department?
Yes.
And did you view some of the photos from this complaint by the Jensens that was in evidence there?
Yes.
Can you describe for us what those photos from the Pleasant Prairie evidence look like?
There were about a dozen or so, excuse me, photographs, or they weren't actually photographs on photo paper. They appeared to be Xerox copies, either copies of photographs or something that was, my initial thought was that they were printed off the internet and onto photo paper and then possibly second generation copies. They were just photocopies. They were black and white. They were what I would consider kind of poor quality photos. They were, I don't know if I mentioned, they were all pornographic in nature. I can only specifically remember 2 of them. The others, they were pornographic, but I don't remember the exact content.
So what kind of paper were they on?
Copy paper.
So just normal printer
Normal
paper?
copy paper, yeah.
And you said they were all pornographic, but there was 2 that you recall what the subject matter was. Can you tell us what that was?
Yes, there was 2 photos of a woman performing oral sex on a man. One was a view from the top, as though there may have been, like it was taken from the ceiling down, and the other one was from the side. It would have been the side view of a couple on a bed.
And now you have described to us that there was one Friday afternoon that you did sort of a stakeout of Mr. Jensen's car. Is that correct?
Yes.
And where was his car parked when you were watching it?
It was at an office building on Highway 31. I don't know the address. It was 5600 block of Green Bay Road. And I positioned myself in a little bit to the south, and on the west side of the street, there's a trucking company. And I positioned my vehicle in that parking lot so that I could observe Mr. Jensen's vehicle.
And was this because he had complaints about these images being left on his vehicle at his workplace?
Yes.
And then obviously in the time you were watching, nothing happened?
Nothing, no.
And Mark Jensen was aware that you were surveilling his vehicle at that time, correct?
Yes.
And Julie Jensen was also aware?
Yes.
So then when you actually went to the Pleasant Prairie Police Department and you looked at these photos, what did you decide to do next?
I called Julie Jensen and spoke to her. After I viewed the pictures, I was convinced, or I felt that the photos were not of Julie. So I wanted to discuss that with her, as well as the findings from the surveillance, which was negative.
Now, had Julie Jensen expressed concern or fear that some of these photos were of her?
Yes.
And so you were going to tell her in this call that you saw them and you believe they were not her?
Correct.
And did you have that discussion with her in this call?
Yes.
And what was her response during that discussion?
She thought that the pictures could be her and was kind of leaning towards the fact that they were of her.
Now, in these two discussions that you had with Julie Jensen, how would you describe her in terms of her demeanor or how she presented herself?
She was very nice. She was kind of meek, and my reaction, or one of my thoughts, was that when we had the discussion about the photographs and whether it was her or not, and I don't mean this in a negative way, but she seemed a little naive in the sense that I don't know, it's hard to describe. She just, as many points that I pointed out to her that it was my belief that it was not her in the pictures, she wasn't really open to hearing that. It was, she sort of had the idea that it was her, and what I had to say about it really had no bearing on what she thought.
Now, was it your intention to continue this investigation?
Yes.
And so what happened, though, during your phone conversation that you've described?
Julie told me that they wanted to cancel the surveillance.
And so it was just one time and then it was canceled?
Yes.
And did she say to you at all why it was being canceled?
No, she didn't tell me why. She just said that they, I believe she said they had decided to stop the surveillance.
Now, did you discuss with her any ideas about you continuing the surveillance?
Yes.
And what did you discuss with her?
Well, I had a suspicion that the person that was behind this was Mr. Jensen. And I suggested to her that we tell Mark that we were canceling the surveillance, but we would continue the surveillance, because I thought if it was in fact happening, that there was a good possibility that I would determine that it was her husband that was behind it.
And were you open with Mrs. Jensen about your reasoning here?
Yes.
And so how did she respond to that?
She was a little kind of wishy-washy about it. She said, well, you know, because I had specifically asked her if she entertained the thought that her husband was behind it. And she reluctantly said, well, yes, I've thought that, but I really don't want to go down that road and think that he would do that.
So you made that offer, but she declined it.
Yes.
I've shown you what's been marked as State's Exhibit 76. Do you recognize what that is?
Yes.
What is it?
It's my invoice to the Jensens for the 6 hours of work that I performed for them.
And when did you generate this invoice?
That's dated May 1st, 1996.
And was this bill paid by the Jensens?
Yes.
And was that the end of your interaction with them about this issue?
Yes.
Now, at some point after December of 1998, were you contacted by Detective Sergeant Ratsberg of the Pleasant Prairie Police Department?
Yes.
And is that when you learned of Julie Jensen's death?
Yes.
And did he ask you for what you had in terms of your file for when you did this investigation?
Yes.
And really all you had was the invoice?
Yes, I really had nothing other than the initial information that I had written down when I met with the Jensens and a copy of my invoice.
I have no further questions.
Who's
Thank you.
doing the cross?
Attorney Krause.
Go ahead.
Mr. Ellis, you met with the Jensens in their home,
Yes.
and they had asked you to conduct some surveillance at Mr. Jensen's work,
Yes.
because that's where Mr. Jensen had found photos on his vehicle.
That's what I was told. Yes.
And you explained to them there was no guarantee that you would catch the person who was leaving the photos.
I don't recall telling him there was no guarantee. I mean,
The person would have had to leave the photos while you were watching.
yes,
And if you weren't there watching, then you wouldn't have been able to see it.
correct.
And you were the one conducting the surveillance.
Yes.
You didn't have anyone with you.
No.
You were alone.
Yes.
So if you had gone away from the parking lot for whatever reason and somebody had left something, you wouldn't have been able to see it
That didn't occur.
because you conducted surveillance for 4 hours.
Right. The entire time. I never left once I got there until 5 o'clock, I believe, when we had predetermined that we would stop.
And I understand that. If you had conducted further surveillance, you would have had to have been there at the time someone left the photos in order to catch them.
Yes,
If you weren't there, you wouldn't have seen it.
of course.
You also spent some time reviewing the photos at the Pleasant Prairie Police Department.
Yes.
And you said there were about a dozen photos,
Yes,
and you remember 2 photos.
correct.
And it's based upon your memory of those 2 photos that you had told Miss Jensen that you didn't believe it was her.
Correct.
And I think what you said is that she believed it was her, and there was nothing you could say that would convince her otherwise.
Yes,
What you said had no bearing on what she thought.
correct.
And it was after that conversation with her that you were told that they had decided to cancel the additional surveillance.
Correct.
The time that you spent total in this case was, I think, 6 hours.
Yes,
And that was 2 hours reviewing the photos and meeting with the Jensens,
correct.
and 4 hours with surveillance on the vehicle that Friday afternoon.
Yes,
And the total bill was $1,200.
no, the bill was $180.
I'm sorry, that's correct. Your total, it was, thank you. 4 hours of surveillance was $120, and then 2 additional hours was, the total was $180.
Right, I billed at a rate of $30 an hour.
Thank you. So if they had asked you to conduct surveillance for 1 week, 8 hours a day, it would have been $1,200.
I'll take your word for it.
I used a calculator, so I think that's right. And that was in 1996.
Yes,
And the Jensens understood how much it was going to cost for you to do this surveillance work.
I would assume.
They knew your hourly rate.
Yes,
And they were fine with that when they brought you on to do this work.
yes.
And after that afternoon and phone call with Julie, they decided not to go any further.
Correct.
I want to talk a little bit about the photos that you reviewed at the Pleasant Prairie Police Department. Was there an officer or a detective with you when you looked at the photos?
There were 2 officers. I don't remember who they were.
And did you talk to them about whether they had gotten any prints from the photographs?
No,
Did you ask them if they attempted to get any prints from the photographs?
no.
Is that something that law enforcement will do if they recover evidence and they think they can get prints?
Possibly.
You also talked to Julie Jensen about why law enforcement wasn't looking into the phone calls.
I don't recall that.
Do you remember talking to her about getting the phone company's cooperation to get phone records from Perry Tarica?
I don't recall having any discussion about phone calls.
Did you talk to Julie Jensen about whether the police had taken fingerprints or whether they should have?
No,
You said that what you did talk to her about, though, was that she suspected the photos were of her,
yes.
and she had looked at the photos.
I would assume she had seen them.
And you disagreed with her, and you told her that when you talked to her on the phone.
Yes,
She told you that she believed it was her based upon the subject matter in the photos.
she believed that the female in the photo could have been her.
You asked her in general if it could be her based on the subject matter in the photos, and she told you yes.
Correct.
And she told you she hadn't taken photos like that with her husband.
I don't recall that.
Now, the Jensens retained you together when you came to their home.
Yes,
And Mr. Jensen and Miss Jensen agreed to pay your fee.
yes,
And when you submitted the bill, they did pay your fee.
yes,
It was only after the conversation that you had with Miss Jensen and not Mr. Jensen that she canceled the surveillance.
yes.
You didn't talk to Mr. Jensen after that.
No,
Nothing further. Thank you, sir.
Any redirect?
So just to clarify, you said that you assumed that Julie Jensen had seen the photos,
yes.
but you don't know that for sure.
No, I don't.
And you don't know if she's the person who actually recovered the photos or if Mark Jensen recovered them.
No, I have no idea. I just became aware that some of the photos were in the hands of the Pleasant Prairie Police Department. How they got there, who found them, I have no idea.
And so what you do know is that she was afraid she was in the photos.
Excuse me?
She was afraid that she was in the photos.
She was very concerned, yes.
I have no further questions.
Any cross on those questions?
Briefly, when you met with them about the photos, where they were recovered and who they were recovered by, you understood that it was kind of sporadic. They weren't all left at the same place at the same time.
No, I had no idea when they were left. I didn't know if it happened once, 100 times. I don't know. I have no idea.
You didn't get that information from them.
No, I didn't.
And when you talked to Miss Jensen about who was in the photos, you asked her if it could be her based on the photos and the subject matter, and she told you it could be.
Yes.
Nothing further. Thank you,
All
sir.
right, you're excused. Thank you.
States Exhibit 76. And then, Judge, we have one more, we think, quick witness.
One more quick witness, 76 is received.
Gretchen Rosenke, and I think on your list she's number 63, Your Honor.
Thank you.
All right, this is going to be the last witness of the day, chat. So stay tuned. Right after the trial day, we do a breakdown of what happened, point out some juicy
Standing, raise your right
details.
hand, I'll swear you in. You solemnly swear the testimony is meant to be the truth, whole truth, nothing but the truth, so help you God?
I do.
Thank you. Get as close as you can to the microphone. Spell your first and last name.
My name is Gretchen Rosenke. Gretchen is Gretchen. Rosenke is Rosenke.
Go ahead, Mr. Jamboys.
Good afternoon, Ms. Rosenke. In 2007 and 2008, by whom were you employed?
The public defender's office
And in what capacity?
as an assistant attorney,
You were an attorney or an assistant state public defender?
an assistant state public defender, yes.
So you weren't an assistant to an attorney, you were an attorney.
Right, correct. As an attorney, yes.
And as of 2007 and 2008, how long had you been with the public defender's office?
I want to say about a year and a half or maybe 2 years at most.
Now, during that course of time, did you come to represent a person named Aaron Dillard?
I did.
And do you recall receiving a letter from Aaron Dillard at some point?
Yes, I do.
And what did he ask you to do in that letter?
Well, a couple of things. He wanted me to come and talk to him because he had gotten some information regarding the Mark Jensen case, but he also had wanted me to reach out to the assistant district attorney that I was working with to let them know that he might have some information.
And did you end up reaching out to the state in this matter?
I did.
You remember who you talked to?
Unfortunately, I don't know.
Do you recall talking to me at some point?
Yes, that I do.
Okay, so you talked to another assistant DA first, and then you end up talking to me?
Yes, it might have been at the time Attorney Gabrielle.
And when you called to talk to me, what did you tell me?
I believe I told you something to the effect that my client had indicated that he had had conversations with Mark Jensen, and based on those, he had some information regarding Jensen's case.
And what was your impression of my reaction to the fact that Mr. Dillard had wanted to talk to me?
As I recall, you were a little bit skeptical about that.
What happened next?
I mean, I'm not entirely sure. It's been a while, but I'm sure I met with Aaron just to get a very clear understanding of what it is, what kind of information it was that he had.
Do you recall me asking you for an example of what Aaron Dillard had said to you?
Yes,
And did you read a portion of the letter he had sent to you?
I did.
And what was my response immediately after hearing that portion of the letter?
I believe you wanted to set up an interview with Mr. Dillard.
At some point thereafter, did we have an interview?
We did.
And who was present for the interview, if you can recall?
Okay, well, it would have been you, of course, me, Mr. Dillard, and I believe one other assistant DA from Kenosha County. I'm not sure who.
So was there one interview or more than one interview?
There were 2 interviews, I believe.
Okay, where did the first interview take place?
I think it took place at the Kenosha County Jail, but, out of the main population, like in a separate room.
And where did the second interview take place?
I don't remember.
Now, you were present for both of these interviews.
Yes, I was.
And what was the purpose of these interviews?
Well, Aaron had received some information because he had been talking to Mark Jensen. They had kind of struck up, we'll say, a relationship of sorts in the jail. They were just, hanging out. And according to Aaron, Mark had
Objection, hearsay.
Sustained.
For the truth of the matter asserted, Your Honor, I'm asking about the circumstances surrounding this interview.
Well, then ask that question.
So, well, tell me this. Did either Ms. Gabrielle or myself ever supply any information to Aaron Dillard?
No.
We were asking Aaron Dillard what happened.
Correct. Yes.
Now, before these interviews occurred, did you talk to Aaron Dillard about this?
Yes, I did.
And did you give him any advice as to what he should say or do?
Not to what he should, just in terms, just be truthful. I mean, whatever information, it should be truthful, but otherwise, no.
I'll show you this document that's been marked as State's Exhibit S69.
Okay.
And ask you to take a look at that. I'll ask you questions about it in a moment.
Right.
Have you read through the letter, ma'am?
Got a little bit more to go. It's kind of a long one.
You don't need to read the whole letter. What I want you to know is, from what you've seen of the letter, can you identify that letter?
Yes, I can.
What is that?
That is a letter that Aaron Dillard sent to me.
And when Aaron Dillard sent you that letter, where was he located?
I believe he was in custody.
And when you got that letter, what did you do with it when you first received the letter?
I don't exactly remember. I mean, I read it, obviously, and then I believe I reached out to an assistant DA in Kenosha County.
And then you ultimately ended up speaking with me.
Yes.
Did you get consent from Mr. Dillard to provide me a copy of that letter?
I did.
And you provided me a copy of the letter.
I did.
Now, during either one of these interviews, did either Assistant District Attorney Angelina Gabrielle or myself, did either one of us ever provide any information to Aaron Dillard?
Objection, asked and answered.
Go ahead and answer it one more time.
No, you did not.
And who was providing the factual information during the course of this interview?
It was Mr. Dillard.
Did anybody else provide any factual information to Mr. Dillard during the course of this interview?
No.
No further questions of
Who's
this
doing
witness.
across? Go ahead, Mr. Perry.
Mr. Rosenke, what information did you review in advance of your testimony today?
I did review a copy of the transcript from the last hearing of just my testimony, nothing else.
Now, the letter that's in front of you, it's still in front of you, right?
Correct, yes.
That's State's Exhibit 69. That wasn't sent directly to you, was it, from Mr. Dillard?
I'm not sure. I was his attorney, so I'm thinking he did send it to me.
It was faxed from his wife to you, correct?
Oh, okay. I think so, yes.
Mr. Dillard was in prison at the time, correct?
Yes.
Do you remember what prison?
No, I don't.
And it's your understanding that this letter was mailed to his wife, correct?
Yes.
And then from his wife, it was faxed to you.
Yes.
Did you say that you, after receiving this letter, went and met and discussed this with Mr. Dillard?
I think I would have at some point.
Did you travel to whatever prison he was in to meet with him?
I honestly don't remember.
You represented Mr. Dillard at that time on the pending reconfinement matter.
Yes.
On that case, he was facing 4 years, 6 months.
Yes.
That was the recommendation from the agent, correct?
I believe the agent was recommending the max on all of the cases that he was revoked on.
Did you represent him on the theft by contractor and home improvement fraud case?
Yes.
And did you also represent him on his pending obstructing charge?
Yes.
No further questions.
Can you redirect?
No, Your Honor.
All right, you're excused. Thank you.
Next witness, Your Honor, was the Kenosha County Medical Examiner in 2005 to 2008, and her testimony is expected to take a lot longer than 15 minutes.
I think it's a good time to go home, folks. Remember, don't talk about the case. See you tomorrow. Have a good evening.
All right, that is going to be it for the day. Stay tuned. As soon as they walk out of the courtroom, we will do a quick breakdown. Good time to ask your questions, get some clarifications. I got a bunch of stuff I got to say today. Holy God, chat. What a day in court. So we'll see if they say anything else. If not, as soon as Jensen leaves, then...
Into the courtroom. Then I take it, Mr. Jamboys, that's going to be Mary Mayland, correct?
Yes, Your Honor.
Okay. Okay, we're holding the jury. The defendant can go back.
Just a quick question. We had all of our witnesses prepared for Wednesday after changing everything. I don't think I'll be able to get anyone, depending on what happens with Mary Mainland, if this is like halfway through the afternoon. I mean, I guess I could play a video, but
We're going to do something. We're not just going to sit here. You told me a few days ago, we got to get this case done.
and I agree, but we didn't, but they gave us a list of 130 people, and we've actually had people change their plane tickets.
We're going to
now.
do something.
That's fine. I'm just letting the court know that it might be a video in the afternoon because we might not have a witness.
We can break the Judge Milosauskas rule.
Okay. I just wanted the court to know.
All right, thank you.
Woof. All right, so Dr. Mary Mainland, she's going to be coming up. So, chat, remember the original person who did the autopsy was Dr. Maureen Lavin. Lavin mysteriously gets fired. And more importantly than that, her autopsy report goes missing. And they've never found it. Then we have Dr. Chambliss come in. Dr. Chambliss, he agrees with everything that Bob Jamboy tells him he needs to agree with. Chambliss was a key witness in 2008, and then we find out that Chambliss lied in 2008. He doesn't know anything about antifreeze. Dr. Mainland is the person kind of above, not kind of, she is above Maureen Lavin and Dr. Chambliss. That's their boss, the head medical examiner. And Maureen and Dr. Mainland is the one who testifies, and she's extremely damning. And then there's more craziness when Dr. Long comes on, because Dr. Long initiated his report based off Maureen Lavin's report, And now there's all this discrepancy on how much antifreeze was actually in Julie Jensen's system. Because everybody's report that says a tiny amount, everybody's fired, reports are missing, it's crazy. And now there's like liters of antifreeze. So stay tuned for that. That's going to be a pretty interesting testimony. We've not played any of Mary Mainland's testimony from 2008 just because a lot of these doctor testimonies are really, really boring. They're long. It's a lot to get through. So we'll be hearing what she has to say for the first time. I've not watched too much of her stuff. I watched some of it because of the whole pathology report that gets lost. It is interesting. It's good, but I didn't want to bore you with 2 sets of testimonies from her or Dr. Long. So we're going to hear it for the first time. You guys won't have anything to compare it to. Do your own research on the 2008 testimony with Mary Mainland. So that is that. Now, there's a lot going on over here today. Phone is blowing up. Bad news, good news, all types of things. Okay. Today, I think, was the first time that the state finally presented a case. I think today the state of Wisconsin just kicked ass. They dominated that courtroom today. And I don't think Jensen's attorneys fought hard enough like we've seen them do in the past. That begs to question, are they getting tired? Are they running out of steam? Do they not have anything else to present to damage the credibility of these witnesses? Are they running out of the juice? What do you guys think? We saw in 2008, there was a point that Craig Albee is just tired, defeated. He needs it to be over. He's still fighting. He's throwing those lazy punches. He's getting in there. He's still fighting. He's still arguing. But he is exhausted. Have we reached that point with Jensen's defense yet? Now, we pointed out some things when it came to Dave Thompson that was pretty questionable. You know, these jailhouse witnesses, it's hard with them because you kind of want to take out their past history and not hold that against them because maybe something they heard today or saw today, right? It shouldn't affect their credibility when they're testifying of what they saw or heard. However, sometimes their past history does affect what they say. So Dave Thompson, I think, sounded to me not credible, especially with us watching all of his testimony before. There were a lot of things that I caught on to, right? It's also weird that out of every witness, because we've all seen every witness is forgetting stuff. They don't remember. It's been so long. I can't recall. I don't know what I said, right? And that's everyone's big argument is, oh, it's so long and nobody remembers. But the jailhouse snitches, every one of them remembers word for word, and they're reciting more details. So that's interesting and convenient that they know everything. Front and back, sideways and center, they've got it all memorized. They know. I don't know if any of you all have picked that up, but that is an interesting thing to me. But Thompson and Jensen are supposedly conspiring to kidnap Ed Klug, Mark Jensen's best friend at work. And I think a lot of us didn't believe it. And then we hear the recorded jail calls. Chat, holy God. And I'm sitting here and I'm like, man, and I'm trying to really listen, because we think, you know, Julie kind of staged a lot of things. There's a lot of stuff. We think these jailhouse snitches saw his paperwork, and I'm trying to listen to this, and I go, oh my God. Oh my God. After listening to all of that, this is my thought. You guys let me know where you're at. Put it in the chat. I am interested. I want to know where your guys' brains were. What were you thinking when you were hearing the jail calls? Because this was crucial for the state, right? Mark Jensen is only charged with first-degree intentional homicide, and it's the only charge he had back then too. They never charged him with conspiracy to kidnap a witness or, you know, whatever those charges are called. They never charge him with that. They don't charge the parents. They don't charge Dave Thompson. Nobody's charged with anything kidnapping. And we see Bobby Boy is going for the jugular. He wants Mark Jensen in prison forever. Why would he not have charged him? If he was so sure and they had this damning evidence, why is there no charge? So here's what I think. I still believe in our theory, okay, that Mark may not have had anything to do with Julie's death. He didn't kill her. He didn't kill her. Okay? Now, for those of you that are new and you're like, Jesus Christ, what did I just hear from this streamer over here? All right. Let me just explain real quick. Don't hate me, real quick. Because we investigate corruption on this channel, I've kind of taken the role as the defense team. So I'll be the bad guy and you guys be whatever side you want to be. We have some that are defense. We have some that are the state. And I'm just pointing out the corruption and the stuff that doesn't make sense. That's what I'm doing. We don't like Mark. We definitely don't like him. He's not a good guy in any way. But we're not sure he's guilty of intentional homicide. So to clear that up. So don't hate me. Okay. So if we go with this Gone Girl theory, and Julie staged all these things, she's on the internet searching, she's all this, right? And we've laid all this out before in great detail, so I don't want to go through it again. Is it possible that Mark is so panicked? Because in 2008, court is not going good. It's not. Every day is not going good for this guy. Because Bobby Boy is just hammering it home. He's hitting home runs every time he gets up to the plate. Every time he's winning arguments, he's just dominating with witnesses. It's not like we're seeing in today's trial. So is it possible that even though Mark may have been innocent of the death of Julie, that he is so scared now that he's willing to do anything at this point to go home? And he actually conspired with Dave Thompson to kidnap Ed Klug. For me, listening to those phone calls, if I was a juror, 100% Mark Jensen is guilty of whatever the charge is, conspiracy to kidnap a witness, to dissuade a testimony, or whatever the charge is. 100%, I think he's guilty. And I think mom and dad are co-defendants. They're accomplices to this, co-conspirators, especially mom. Dad almost seemed like he really didn't know what was going on. He's a little more confused about the situation. But I would have to think that mom and dad are talking once they get off the phone. Mark obviously has no idea how to talk in code on a recorded line. This guy talks too damn much. But I think he's guilty of a conspiracy charge. So that leaves me to question, why would Bobby Boy not charge him with that? He's got him smoked right there. And Kenosha will thump you over the head on that charge, 100%. They don't like you intimidating witnesses. They'll smoke him for that. Why would they not have charged him? That doesn't make sense to me. But if they did, if that charge existed, I'm sorry, I'm convicting him on that, 100%. Max him out. Go to prison, whatever the max is. Because that's big. That's like mafia shit, right? Chat, what do you guys think? Put it in the chat. That was so damaging. Now, it has nothing to do with the intentional homicide charge that he has, but the state is playing it because they have to make this guy look bad. They have to show that this guy is willing to do everything and anything. He's already murdered his wife, right? He's trying to cover things up. And now he's in jail. He's confessed. And now he's got to, go and kidnap people. So they're going to throw everything out there that makes Mark Jensen look bad. Make him look guilty. Now, we've been smart over here and we have been ripping apart Bobby Boy's evidence, and we are pointing out all of the flaws, discrepancies, everything. And we've backed it up ourselves with our own little proofs. We've backed it up. And then we have some theories, some speculations, right? We obviously get to hear a little bit more because we're playing all this background stuff. So we're kind of cheating a little bit, right? Our visit calls recorded. Yes, they are. Yes, they are. Don't talk on a goddamn phone in jail. And honestly, don't even talk. I told you guys before, just sit on your bunk. Sit on your bunk and read a book. Don't even go in the day room and play spades. Don't play no dominoes. Don't play no checkers, no chess, nothing. Don't do it. Sit on your bunk and shut your mouth. Because the phones are recorded, okay? The visit areas, you have to be on a phone. That's recorded as well. And how they're describing the blocks and the guard booth that's in there. Okay? There's an intercom system. And the guards like to be sneaky, and the inmates know when they turn it on, right? The guards like to be sneaky, though, and they turn the intercom on, and they listen to what the inmates are saying. It's a good way to eavesdrop and make sure that, nobody's fighting and about to start a fight. There's no threats, so they do listen to that stuff. But these sons of bitches also record that, whatever's going on. Everything is recorded. So, yeah, don't talk. Mark, talks too much. Talks too much. But, I still believe that Dave Thompson, because he admitted today that he did go in Jensen's cell. He looked at paperwork. Just that testimony alone, that statement, it knocks every other jail's snitch. Their testimony is done. And we haven't even seen all of them. There's so many of them in 2008. But they all said that nobody went in this guy's cell. Nobody read his paperwork like that. And we found out today that they did. I think that was a truthful statement by him. I think he forgot what he said in 2008. I think he fucked that up. And it was irritating to watch that Perry, none of them caught that, apparently, because they didn't question it. Or maybe they did catch it and there's a reason they didn't bring it up. I don't know. Maybe they got something up their sleeve that we don't know about, right? And maybe we may find that out. But if they didn't catch that, that's problematic because they could have discredited Aaron Dillard. They could have discredited David Thompson and then any other snitch that comes on the stand. And the minute they're all like, we didn't go in there. Well, Thompson said you did. And, whatever. And then if they change their testimony today and say, well, yeah, some of us did go in there, whatever. They didn't say that back then. They were directly asked all these things, right? So it's, it's crazy. But chat, I'm telling you, I think he panicked. 100% sure, whether he was guilty of Julie's death or not, he 100% panicked in jail. And I think he's guilty of the conspiracy to kidnap. I think he is. 100% facts on that. 100% facts on that. Aaron Dillard. I don't believe anything Aaron Dillard says. Now, an important piece to Aaron Dillard is that we know for a fact, Aaron Dillard read the Ed Klug testimony from the 2007 bond forfeiture hearing. The question begs, did Aaron Dillard read the 1999 police interrogation transcript? And it's plausible that he may have. They're reading all kinds of stuff inside of this jail. And we find out, too, that Mark is in a double cell. So if you're in a single cell, they lock it anytime you're out. But if you're in a double cell, those cells are not always locked, okay? Because your cellie needs to go in there. Now, There are some guards that understand that each prisoner has their little right to privacy. So if one of the cellies is not there, they will lock the door. And if the other cellie needs to get in, he's got to ask the guard permission. And it's kind of an in and out thing. There's no like sitting in there type stuff. So let's say that even happened. Okay. And every jail's different. Every guard is different. Every block is different. Everything's different, right? Even though there's protocols and shit that's not always followed. So let's just say that even happened in a 2-man cell, because we know that Jensen was at one point was in a 2-man cell. So people have access to all of his stuff. So let's say Jensen is out at court. Celly needs to go in there, nabs one of his papers. Everyone's reading it. And then they're able to put it back before Jensen comes in. This is the doubt that I'm putting in the jury's mind if I'm the defense. These are the questions I'm asking if I'm the defense. I need to put that doubt. I don't think the defense for Jensen ripped Aaron Dillard apart. I really don't. I think they did an okay job. They got some points in, they got some blows, but it needed to be the knockout punch. Aaron Dillard is one of the biggest witnesses, and I don't think they knocked him out. I don't think they did. So, that was absolutely crazy. Phone calls, problematic. Then we have Bobby Boy sneak in more barred evidence. This is not the first time he's done it. He cannot talk about Mark being convicted, the key word, convicted. He can't talk about that. Everyone knows there was a trial. They're allowed to know that. They cannot know the exact verbiage that Jamboy said when he was reading that letter for the consideration of Thompson. And he said the conviction in the previous trial, and what he knows he's not supposed to say that. That's why there was the argument. Now we have a special jury instruction. It's FUBAR at this point. The jury has already been aware. They're paying attention to it. And like Perry's concern was, pretty much no matter what is said at this point now, what corrections are made, this is in the jury's mind. And anything we do at this point, it's just going to make it stick out even more. And Bobby Boy knows that. So you have these unethical things that Bobby Boy is doing. Now, I think at that point in 2008, because we know from the footage we've all watched together, that Craig Albee asked for a mistrial 3 different times because of the shit that Bob was doing. So here we have another big problem. Defense doesn't ask for a mistrial. Now, maybe there's a reason for that. Maybe they, got their knockout punch coming. Maybe they don't want to have the argument about a mistrial. There was another thing that Bobby Boy got in an actual document. And that was at the end of one of the days last week. I don't remember if it was Thursday or Friday. It was the last thing they did with the last witness. And it was a barred piece of evidence. So Bob is scared. You can tell when Bob is scared because he starts doing very questionable, unethical things. And I think this becomes very problematic. Did any of his bunkies testify? I don't know because we didn't watch all of the jailhouse snitches. I didn't watch every single one of them. We just showed you guys the main ones. So I'm not 100% sure. I have time to watch 1,500 hours of video. The guards now have to use their own phones as cameras in their vests. Not the Kenosha County sheriffs. They're not using their phones. They have body cams. Even if they come back with conspiracy to commit kidnapping and negligent homicide, he walks with time served. I think so too. The chances of him re-offending are low. He isn't a threat to the community. Maybe. I don't know. I just, it's weird that they did not charge him with the kidnapping conspiracy back then. I just think that was too, yes, Darlene, the jail guards do. The sheriff's department got body cams before KPD did. That's how it is in a lot of these towns. The jails and yeah. So yeah, I don't know. I think it was weird that they did not charge him. I thought that was very, very damning evidence, guys. And 70%, we did a poll. This is what's cool and fun about the YouTube chat. We did a poll. Is Mark guilty of conspiracy to kidnapping? 69% of you said yes, 25 said undecided, and only 5 said no. You ever find out anything about the juror list stuff? What is that? What is the juror list stuff? Oh, on whether or not it's public? No. Darlene, did you ever go? I mean, it's the weekend. The courts aren't open. I didn't call this morning because I'm dealing with the stream. I didn't hear anything from my corporate reporter buddy. Today definitely went in the state's favor. Definitely went in the state's favor. It did not look good for Jensen. But however, all of the stuff that they showed today and proved today and all this stuff, right? And especially the kidnapping thing, it doesn't prove first-degree intentional homicide. Now, unless you believe the jailhouse snitches, right? Dylan's testimony, Thompson's testimony, if you believe what they're saying and you found them to be very credible, then, it proved it for you that he confessed to them and all of that. I don't think so. Several of the chat doesn't think so. I don't know, but what do you guys think? Because a lot of us that are here, and there's still some new people, so please feel free to chime in. There's several of us that are here that were really kind of going with the theory that he gone girled this, or Julie gone girled this, and staged this whole thing, and the plan got sideways, and she accidentally unalived herself, and Mark really wasn't guilty. So let's say that's actually true, but he did get scared and planned to kidnap this dude. That doesn't make him guilty of first-degree intentional homicide. But I don't know. What do you guys think? Put it in the chat. And all you newbies that are in here, welcome, welcome. Come chime in, chat away, meet some people. Everyone's cool and fun and friendly. But remember, all for the newbies too, I don't think there's anybody that even is talking in chat right now. Nobody likes Mark Jensen. They all want to punch him in the eyeball. Even if he's innocent, they still want to punch him in the eyeball. That's their thing. They don't like him. They don't like his shifty eyes. They don't like his shit-eating smile. They don't like his jaw. They don't like the sound of his voice. They don't like any of it. None of it. Andre, if you were Mark and the DA offered you everything else but murder and you'll get time served, would you take it? See, it's hard, bro. You can't ask me that because, it's kind of why I got a bunch of shit on my background that there's some stuff I've never even done. There's a lot of shit on my background I've never even done. I'm kind of a scared little bitch, bro. I go to jail and they say, hey, this, and you go home. Okay, let's do it. I just want to go. I can't do that. I can't. No, I can't do jail. I'm a scary little guy. So I would, if I got to go home, I'd just be like, I don't even care, dude. Nope. I'm going. But I don't know. I mean, probably I would. I'd just be like, fine, I don't care. I get to go home today. because he's facing life in prison again. He's like forever. Bro. He's never coming out. Never. Was pushing this agenda about kidnapping, and Mark went with it. Yeah, I believe that too. I think Dave Thompson came up with the idea. I think he pressured Mark into it. He was pushing that narrative on him, that whole agenda, and I think it got in Mark's head, and Mark saw a way out. But either way, it doesn't matter who thought of the plan first. Mark went with it. I think Mark should have been charged. I think Dave Thompson should have been charged. I think both of Mark's parents should have been charged. And I think Kim should have been charged. And I think they drill Kelly. And they stick her in the hot box for a little while, interrogating her ass. Because she may have spilled the beans. And maybe she gets charged. Then you offer Thompson a deal to testify against the conspiracy thing. The girlfriend Kim is going to get the same deal because they're going to turn, cooperating witnesses against everybody. And then Mark, Kelly, and his parents all go down. And now the parents are sitting in the clink with them. The jailhouse snitch stuff did not go very well today. They did not crush Aaron Dillard. That was messed up. The jail phone calls about the kidnapping shit did not go good. That was all very damaging. Very damaging. It was not good. Not good. I thought the defense was lazy today, and that was not the day to be lazy. They needed to still be fighting. Maybe they got a little lazy because they thought they were winning. I mean, we've seen they've looked pretty confident. But even today, Mark was smiling like he was so confident. He was real cocky. I was typing in the chat a few times, like, I don't know why this dude's smiling right now. They would have had to have some toilet paper on the table for me. Oh. Do you think the Sons will testify on Mark's behalf? I don't know. No idea. The one is on the witness list. He's on both of them. So I am, listen, as much as we kind of really poke out and I clip a lot of the like when the defense is crushing, the state. I'm gonna be honest today, chat. I'm gonna be honest. I'm clipping out all the jail phone calls about the kidnapping shit. I'm gonna clip that out and I'm gonna post it up. I'm gonna post that one up. That's gonna throw everybody for a loop on the internet. That was very damning evidence right there. But I don't know why they didn't charge him. That doesn't make sense to me. It doesn't make sense to me, chat. Said he didn't give Kelly information. No, but Kelly talked to the mom. So Kelly may have known. That's why I'm saying they needed to bring Kelly's ass in, and they needed to put her in a fucking heater box. Because Kelly talked to the mom. They had to all coordinate this. And Dummy is over here talking on the phone with the jail code that he learned that he didn't really learn very well. So, and then you got mom talking in code. Here's white mommy talking in goddamn code, and mom knows even less than Mark does. She's trying to pick up what he's putting down, right? Mom's trying to speak in code, and she's like, I'll do everything I need to do for you. I'll research it all. I'll do everything for you. Right? I'll research it all. Mom's trying to speak in code. Get the fuck out of here, mom. Get the fuck out of here. Dude, my mom is not even answering the phone when I call. And if she did, if I suggested some shit like that, Guess who's calling the fucking police? My mom. This lady's over here going, oh, I'll do whatever I gotta do. Hold up. The last two phone calls that the defense put on when they were crossing Thompson did poke a little doubt. I don't think it did. I don't think it did. And the problem is a lot of you were not paying attention, and a lot of you were in and out, and a lot of you missed a lot of shit. I don't think those two phone calls did. All those two phone calls did was prove that the fight between Thompson and Mark did happen. We have the testimony. We already know because Thompson said it happened too. There's just discrepancy whether he was pushed or slapped. But there was a fight about Mark not making a phone call for him. And then after he gets his ass whooped, Mark makes the phone call. That's what those two phone calls showed. That's it. That now he's making the phone call. So they're trying to show that Mark was getting punked and bullied, and they're stealing his commissary and all type of shit, right? That's all those two phone calls showed, is that the fight happened and he had to make the phone call. I don't think it refuted the whole because that was all the before type shit. So that's why, like, you guys got to pay attention to dates and times and shit too. Get your little papers out and your pens and all that. You got to write the dates and times down, because that was before. And then the conspiracy kidnapping stuff starts coming on. And then all those phone calls that we heard, that's a whole separate incident. Andre says white suburban people don't do jail code well. No, they don't, dude. They're so stupid. They're so dumb. Dude, Boss and I, Andre, Boss and I, we laugh our asses off when these jail people come up, bro. We laugh so hard. We know, bro. We know. And we just die laughing. Even when, like, Thompson in the 2008 trial, Thompson's testifying that he's talking through the radiator, right? And that does happen. You can do that. That's a factual thing. But if you picture a tiny little block, bro, there's 6 cells. They're small, bro. It's the size of my fucking house, right? That day room is small as shit. That TV is loud. The sound is distorted, right? It's so loud, it's distorted. Everyone's talking loud as shit. And then you got guys that are playing spades. You got guys playing dominoes. So they're slapping the tables, right? You got people rapping and shit off in the fucking corner. You're trying to be on the phone. You got one hand on your ear talking on the phone. And these guys are whispering through a fucking radiator. Nah, bro. It's not happening like that. They ain't whispering. You're yelling. You're yelling through the radiator. Even when you got to talk through the vent in the ductwork vent up in the fucking wall, bro, that you put the toilet paper on. Bro, you're still yelling through that bitch too. There ain't no whispering. There's no paper cup with the string coming out of it. That don't happen. That doesn't happen, dude. So that's why, like, dude, we're in here going, come on, man. You know, come on. Morons. But scared little white boys, they don't know shit, and they'll get punked real easy, guys. They'll get punked real easy, and if you show that fear and that you're scared, they're taking your commissary. And then when one person does it, and you got another one, and another one, now you're getting punked by everybody in that. And that's when you got to let a guard know you're going to PC. That's it, and then you're stuck there. So what else, guys? That's what I picked up. What did I miss? I was in the middle of doing some stuff today, so now I got to go investigate another one of my videos. But yeah, So I know I did miss some things. What did I miss? What did you guys catch that I missed? What parts of anything, did you put more in Mark's column? Did you put more in Julie's column? What did you hear today that you're like, man, I don't know. I don't know. Now, remember, when the state rests, I'm going to see if we can bring 11 people in, and I'm going to be the 12th person. I'm going to be the jury foreman. And we're going to call it the jury room. I don't know if I can bring all 12 people on or not. It might be 6. I got to see how many people I can invite to the stream. But however many it is, if we can do 6 or 8, that'd be good. Let's pretend it's only 3 though, or 4. Then we might do 30 minutes for the 4, and then bring on another 4 for 30 minutes, something like that. We'll set up some parameters so we can kind of get like a good amount of people in the discussion. But if we can get at least 6 in one chat, right? I'll be the jury foreman, and we're going to deliberate. We'll set up rules so everything is polite and respectful, and nobody's talking over each other and arguing and cussing at each other, right? Because it's supposed to be fun. We're all a little community, and I want to be able to do this on all of the trials that we start covering. I don't want people fucking it up. People start violating the rules, then they're getting the boot, and that's that. And then maybe we'll have a backup juror. But I want to do that when the state rests their case with all the evidence that we've heard and break it down. And if we had to make a decision right then and there, we're breaking it down, and what would we think? And then when the defense rests their case, okay, and the jury actually goes into deliberation, we're going to do a jury room again. Now we've really heard everything, and we're going to bring those jurors back, and we're going to deliberate. Now, I think it was 32 hours in the 2008 trial. 32 hours for jury deliberation. The state put on their case for 5 weeks. The defense put on their case for 5 days. This case was expected to go 5 weeks this time. And we're talking about we're a day or 2 away from the state resting and defense opening their case in chief. So this is super quick. So I think we're going to be at least 2 weeks short of what they thought it would be, which is great, because then poor little Kevin can go back to work. Speaking of which, chat, if you like what we do here, hit the pinned comments. There are some donations if you want to help financially. A lot of that stuff goes towards open records requests and time involved for all the video edits and all the stuff that we're doing. So that's a great way to help. Join as members for monthly subscription things. That's another great way to support the platform, all of those things. When this trial is done, I'm going to take a little break, and we're going back to work. Let me know, too, in the chat of, certain trials that you guys are interested in. I'll start taking a look, and we'll figure out which one we're going to do, because we can only do one at a time, and we'll see trial we can do next. But what did you guys find out today? What piqued your ears? What did you guys pick up on that I haven't covered already? April says, have Nightbot be the rep. Yeah, our Nightbot got a massive attitude. A massive attitude. So if you're new and you're lurking in the background and you've been too scared to chat right now, so I'm sure there's a few of you out there. So we have our moderators in the chat that kind of control any nonsense that happens. But then I have an AI moderator, and it posts our links for us and different things, parameters that are set up, and I've disabled a few things because the chat likes to put their little emojis. Some of them like to talk in caps, which they've kind of chilled out on, so that I can type in caps so people like pay attention to what I'm trying to say, especially when the trial's going and they're asking questions, so I'm not constantly talking over the testimony. So I type in caps. But I disabled it in case somebody else, just generally writes in caps. I do anyway, but for some reason my Nightbot is still like muting people and timing them out and giving them little punishments. But the Nightbot puts like little sarcastic comments, and I'm like, this is funny. But we had some naughty.com type stuff coming in, and the Nightbot wasn't having that. Some find you a girlfriend.com type things, and Nightbot's like, yeah, I got a girlfriend for you. It's so funny, dude. It's so funny. You think you're slick with those emojis. It's some stupid AI moderator. Like, it's so dumb, but it's like, it's the funniest thing. I laugh hysterically because Nightbot be getting on everybody. He don't care. People will be sending me messages and stuff like, hey, why did you mute me? Why did you tie me up? But I didn't. Quit yelling at me. I let my moderator deal with the chat when it comes to everybody else, and I deal with the like highbrow, high level stuff, the trolls, the nonsense, the box. I deal with the high level stuff. Mods deal with everything else. So look, if you get timed out and it was for something petty, it was either the Nightbot or it was one of my mods. If you're on some crazy stuff, it was from me. So it is. But my mods deal with less nonsense than I do. I'll troll the trolls. My mods are like, no, Kev, shut up. We ain't dealing with it. They just start banning people. They don't care. They're like, no, move along. Go to another channel. Sometimes I like to have fun. They don't let me. So even I get grounded. And I own the damn company. So but anyway, you rocking makes the mic go in and out. Stop rocking, granddad. You know what? Listen. Hang on. Let me. Sometimes on the 9-hour streams, it doesn't like the microphone. And I'm using the mic on the camera. So if you want to donate so I can buy this $157 microphone I want, then ching, ching, ching. And then we probably won't have that issue. Day Drinker, my mod, says my patience for trolls is all used up at work. So funny, dude. So funny. The rocking put me to sleep the first night. That's probably why I get so tired in here. I don't have a computer chair, which I'd rather have. So I use my great grandma's chair. I like it. It's comfy. Sometimes I wear my I wear my cardigan. Makes me look like an old man. Deep thoughts. Deep thoughts and trial breakdowns with Never Stop Media. I'm gonna put my old grandpa hat on. Maybe I'll do that tomorrow morning. All right. Anyway, anybody have anything else to say about the Jensen case? I don't want to turn this into we're gonna all hang out. I got stuff to do. I got video to edit. I got to go look at one of my old protest videos for something. And yeah, we got today's videos to edit. We still have some other testimonies from a couple other days that we got to get up there. So we have an entire playlist, Mark Jensen trial playlist. You guys can go back and watch things, the individual testimonies, because you know it's super easy. Everything that's it's for members, but it's set up under the 99-cent membership. So super easy to access, and it only costs you $1. April says I should totally do that tomorrow. All right, I'll be the old grandpa tomorrow. We'll do that. I'm gonna wear my little pajama bottoms and my t-shirt, cardigan, my little grandpa hat. That's what we're gonna do tomorrow. So, all right, well, I'm gonna get going and start getting some video. Make sure you guys subscribe to the new channel because we're just doing trials over there. No controversial shit on that channel. It's just court trials. So make sure you guys subscribe over there. There's links all over the place. We need 1,000 subs over there to go live. Hopefully we can get there before this trial ends so we can start streaming over there too. 8:30, plan on 8:30 tomorrow. Court start date, time, all that. I'll go live a little bit early like usual. I will see you guys tomorrow.